Matter admission malad.
Hmm.
But fresh matter malad. No application. Fresh matter malad.
Kodi.
Tomorrow malad.
Being mistake ಮಾಡಿ ನಾನು ಕಮರ್ಷಿಯಲ್ ಕೋರ್ಟ್ ಅಂತ ವಿಡ್ರಾ ಮಾಡ್ಕೊಂಡಿದ್ದೆ ಅಪ್ರೋಪ್ರಿಯೇಟ್ ಕೋರ್ಟ್ ಅಂತ
Commercial court.
ಕಮರ್ಷಿಯಲ್ ಒಂದು ಮ್ಯಾಟರ್ came up for maintainability. I withdrew the appeal stating that I would approach the commercial court. It's not commercial.
Commercial appropriate court.
Appropriate.
Commercial court ಅಂತ ಆಗಿದೆಯಾ?
ಹೌದು
ಕೊಡಿ ಚೇಂಬರ್ ಕರೆಕ್ಷನ್ ಮಾಡ್ತೀವಿ. ಅದೇನ್ ತಗೊಂಡ್ ಹಾಕ್ಸಿ. ಅದಕ್ಕೆ ಸೀನಿಯರ್ ಕೌನ್ಸಿಲ್ ಎಂಗೇಜ್ ಮಾಡಿದ್ರೆ ನಾಳೆ ತಗೋಬೇಕಾ? ಏನ್ ಅರ್ಜೆನ್ಸಿ ಏನ್ ಹೇಳಿ ಅದನ್ನ ಹೇಳಿ. ಕನ್ಸ್ಟ್ರಕ್ಷನ್ ಸ್ಟಾಪ್ ಆಗಿದೆ, ಏನಾಗಲ್ಲ, ಒಂದು 4 ದಿವಸದಲ್ಲಿ ಏನ್ ಜೀವ ಹೋಗಲ್ಲ, ಬರ್ಲಿ. ಯೂಶುವಲ್
an IPR matter,
ಕೊಡಿ ಮೆಮೊ ಕೊಡಿ, ಪೋಸ್ಟ್ ಮಾಡ್ಸ್ ಯೂಶುವಲ್ ಕೋರ್ಸ್. 2:30 no business in this court at 2:30.
Day by day changing in nature.
ಅರ್ಜೆನ್ಸಿ ಏನ್ರಿ?
Day by day they changing in nature. Within a span of 5 days, my lord. Agriculture land ಅಲ್ಲಿ ಈ ತರ ಮಾಡಿದ್ದಾರೆ.
ಆಯ್ತು ಕೊಡಿ, ನಾಳೆ ಕೊಡಿ. ನಾಳೆಗೆ ಹಾಕ್ಸಿ ಮೇಡಮ್ ಅದು.
My lords, kindly. Serial number 15, my lord, I represent.
ಲೈವ್ ಸ್ಟ್ರೀಮಿಂಗ್.
My lord, serial number 15. I appear for the respondent.
15.
Yes.
ಹೇಳಿ ಏನು?
15 ಅಲ್ಲಿ last time, my lord, when the matter was listed, the appellant had suggested if in case of any settlement, my lord, we are in fact exploring.
ನೀವು ರೆಸ್ಪಾಂಡೆಂಟ್ ಈಗ?
I appear for the
ಈಗ
respondent.
ಅಪಲೆಂಟ್ ಹೇಳಿದೀರಾ?
Appellant inform ಮಾಡಿದೆ.
ಆಯ್ತು, ಬೋತ್ ಕೌನ್ಸಿಲ್ ಸಬ್ಮಿಟ್ ದಟ್ there is an element of settlement.
Possibility, my lord.
Element of settlement.
Please, grateful.
Hence list this matter immediately after winter vacation.
Please.
15. Next. 17. 17 and 18. 19 to 26.
27, my lord.
ಹೇಳಿ.
Inform that.
ಲಾಸ್ಟ್ ಟೈಮ್ ಟೈಮ್ ತಗೊಂಡಿದ್ರಿ.
ಅವ್ರ ಮನೆಯಲ್ಲಿ ಸೆರೆಮನಿ ಅವ್ರ ಮನೆಯಲ್ಲಿ ಸೆರೆಮನಿ ಇದೆ ಸ್ವಾಮಿ.
ಯಾರ ಮನೆಯಲ್ಲಿ?
ಅಪಲೆಂಟ್ ಕೌನ್ಸಿಲ್ ಮನೆ.
ಲಾಸ್ಟ್ ಟೈಮ್ ಏನಾಯ್ತು?
ವೀಕಲ್
ಪ್ರತಿ ಸಾರಿ ಡೇಟ್ ಕೇಳ್ತಿರಲ್ಲ. ಅಪಲೆಂಟ್ ಕೌನ್ಸಿಲ್ 6 time.
I am for respondent. ಕೊಡ್ಬೋದು.
And for the counsel for the respondent.
Inform ಮಾಡಿದ್ರು.
Present.
Serial
This matter after winter vacation.
Serial number 2021 ಗೆ another 2 matters ಇದೆ.
ಯಾವ್ದು ಇದ್ರ ಜೊತೆ ಅಲ್ಲ?
ಜೊತೆನಲ್ಲಿ 41, 47, 23, 42, 020.
ಅಲ್ಲ ರೀ, 27 ಕನೆಕ್ಟೆಡ್
ಅಲ್ಲ 27 ಅಲ್ಲ 2021 ಗೆ
20, 21. ಏನ್ ಹೇಳಿ? 20, 21.
another connected matter is there.
ಆಯ್ತು, ಒಟ್ಟಿಗೆ ತಗೊಳ್ಳೋಣ ಮೂರುನು.
ಅಲ್ಲ ಅದು ಪೋಸ್ಟ್ ಆಗಿಲ್ಲ, ಅದಕ್ಕೋಸ್ಕರ ಪೋಸ್ಟ್ ಆಗಿಲ್ಲ, ಅದು ಕನೆಕ್ಟ್ ಮಾಡ್ಬೇಕಾದ್ರೆ.
ಸೀರಿಯಲ್ ನಂಬರ್ 40 ಅಂತೀರಿ ಮತ್ತೆ?
ಅಲ್ಲ 2021 ಗೆ
ಇನ್ನೊಂದು ಇದೆಯಾ?
ಇನ್ನು 2 ಮ್ಯಾಟರ್ಸ್ ಇದೆ.
ಇನ್ನೊಂದು ಯಾವ್ದು ಹೇಳಿ?
ಈ 41, 47/23,
41,
47/23, ಆಮೇಲೆ 42/02/23,
42/02/23
ಅರೈಸಿಂಗ್ ಸೇಮ್ ಅವಾರ್ಡ್.
ಸೇಮ್ ಅವಾರ್ಡ್ LIC
ತಗೊಳ್ಳಿ.
ಸೀರಿಯಲ್ ನಂಬರ್ 2021 ಅಲ್ಲಿ ಮೇಡಮ್, ಅಪ್ಲೈಂಟ್ ಕೌನ್ಸಿಲ್ ಸಬ್ಮಿಟ್ ದಟ್ ಅದರ್ ಕನೆಕ್ಟೆಡ್ MFA 4147 of 23, 4202 of 23 are arising out of the same notification.
ಹೌದು,
same notification, and hence registry is directed to post those matters also along with these matters after winter vacation.
31.
ಸೀರಿಯಲ್ ನಂಬರ್ ಯಾವುದು?
31.
ಹೇಳಿ, ಏನಾಗ್ಬೇಕು?
ನೆಕ್ಸ್ಟ್ ವೀಕ್ ನೋಡ.
ಅದರ್ ಸೈಡ್ ಇದಾರಾ?
ಹೇಳಿದೀನಿ ಬಸವರಾಜ್.
ಹೇಳಿದೀರಾ? ಲಾಸ್ಟ್ ಟೈಮ್ ನೀವು ಟೈಮ್ ಕೇಳಿದಿರಿ.
ತಗೊಂಡಿದ್ವಿ. ಡಾಕ್ಯುಮೆಂಟ್ಸ್ ಎಲ್ಲ
Appellant counsel 6 time and also counsel submits that already intimated counsel Sri S. Kalyan Basuraju, and hence list this matter after winter vacation.
Serial number 7.
Serial number
7.
7.
Yes. 36.
Your Lordship, I appear for appellant in this matter.
36.
There is urgency, my lord.
ನೀವ್ ಯಾರಿಗೆ?
ನಾನು
ರೆಸ್ಪಾಂಡೆಂಟ್ ಗೆ. ಅವ್ರಿಗೆ
I appear for appellant, my lord.
ಇಂಟಿಮೇಷನ್ ಮಾಡಿದ್ರು.
ಇಂಟಿಮೇಷನ್ ಅವರೇ ವಾಪಸ್ ಮಾಡ್ತಾ ಇದಾರಲ್ಲ.
ಇಲ್ಲ, ನಾನು
ಸೀನಿಯರ್ ಕೌನ್ಸಿಲ್ ಗೆ ಇಂಟಿಮೇಷನ್ ಮಾಡಿ.
it be taken up on Monday, my lord. Let it be taken up on Monday.
ಮಂಡೆಗೆಲ್ಲ ಡೇಟ್ಸ್ ಇಲ್ಲ. ಮಂಡೆಗೆ ತುಂಬಾ ಪೋಸ್ಟಿಂಗ್ ಮಾಡ್ಬಿಟ್ಟಿದ್ರಿ. ಇವತ್ತಿದ್ರೆ ನಾನು ಓದ್ಕೊ ಬಂದಿದ್ದೀನಿ, ಅಸಿಸ್ಟ್ ಮಾಡಿ ಅಷ್ಟೇ. ಒನ್ ಅಲೌಡ್ ಕನ್ಸ್ಟ್ರಕ್ಷನ್ ಸ್ಟಾಪ್ ಅಂತ.
ಟ್ಯೂಸ್ಡೇ ಆದ್ರೂ ಹಾಕೋ.
ನೋಟ್ ಇಟ್. ಏನ್ ರೀಸನ್ ಏನ್ ಹೇಳ್ರಿ?
ನಮ್ಮ ಸೀನಿಯರ್ ಹುಷಾರಿಲ್ಲ ಸ್ವಾಮಿ,
ನಿಮ್ senior ಯಾರು?
ಟೈಫಾಯ್ಡ್ ಆಗಿದೆ.
ನಿಮ್ ಸೀನಿಯರ್ ಯಾರ್ರಿ?
ಅವ್ರ ಕೊಲಿಗೂ ನಮ್ ಕೊಲಿಗ್
ಆ?
ಪೂನಮ್ ಅಂತ.
ಆ?
ಪೂನಮ್ ಅಂತ.
ಪೂನಂ ಯಾರು ಇಲ್ಲ ಇಲ್ಲಿ.
Last occasion also they have made same submission, your lordship.
TN ಗಾಯತ್ರಿ ಅಂತಿದೆ. ಹಾ, ಯಾರು ಪೂನಂ ಯಾರು ಇಲ್ಲ.
ವಕಾಲತ್ತಲ್ಲಿ ಇದಾರೆ.
ನೋ ನೋ ಮೇಡಮ್. ನೆಕ್ಸ್ಟ್ ವಕಾಲತ್ತಲ್ಲಿ ಇದ್ರೆ ಬೇರೆ ಅಡ್ವೊಕೇಟ್ಸ್ ಇದಾರೆ. ಅವ್ರಿಗೆ ಜ್ವರ ಬಂದ್ರೆ ಬೇರೆಯವ್ರಿಗೆ ಏನ್ ಜ್ವರ ಬಂದಿಲ್ಲ. ಒಂದು ಆರ್ಗ್ಯುಮೆಂಟ್ ಮಾಡಕ್ ಹೇಳಿ. ಹಾ,
ನೆಕ್ಸ್ಟ್
38 ಏನಾಗ್ಬೇಕು ಕೇಳಿ.
ಸೈನ್ ಮಾಡ್ಬೇಕು ಕಾಂಪ್ರಮೈಸ್
ಹಾ? ರಿಪೋರ್ಟಿಂಗ್ ಸೆಟ್ಲ್ಮೆಂಟ್ ಎಷ್ಟು ದಿವಸ ಆಯ್ತು ಇದು? ಇಬ್ರು ಇದೀರಾ?
We are objecting.
ಅಬ್ಜೆಕ್ಟಿಂಗ್. ಹಾ, ಮತ್ತೆ
Matter may be raised.
ಹಾ?
Instruction ಇಲ್ಲ, proper instruction
ಹಾ.
ಇಲ್ಲ.
ಆಯ್ತು, ನೋಡಿ ಇಟ್.
Your lordship, so serial number 52, your lordship.
52. Yes, madam.
Appearing for the appellant, your lordship.
ಹಾ,
Your lordship, we have engaged senior counsel Aruna Sham, our Dharwad ಇದ್ದಾರೆ, your lordship. I see two.
ಈಗೇನ್ ಅದರ್ ಸೈಡ್ ಇಂಟಿಮೇಟ್ ಮಾಡಿದೀರಾ? ಮಾಡಿದಿರಿ. ಅಪನೆಂಟ್ ಕೌನ್ಸಿಲ್ 6 time and also submit that already intimated. ಯಾರಿಗೆ ಇಂಟಿಮೇಟ್ ಮಾಡಿದ್ರಿ ಹೇಳಿ?
Srinivas.
ಇನ್ನೊಬ್ರು ಇದಾರೆ ನೋಡಿ, ಮುರುಗೇಶ್ ಚರಾಟಿ ಫಾರ್ BDA.
Charity was only called in for producing certain documents, your lordship.
ಆಯ್ತು, and also submit that already informed counsel B Srinivas. And hence list this matter after winter vacation.
Grateful.
Serial number 60, my lords.
ಹಾ, ಹೇಳಿ.
For respondents, my lords.
ಹಾ, ಹೇಳಿ.
I pray for adjournment. my lords.
ಅಪನೆಂಟ್ ಕೌನ್ಸಿಲ್ ಹೇಳಿದಿರಾ?
ಹೇಳಿದ್ದೀವಿ, my lords.
ನೀವ್ಯಾರು?
R5, my lords.
R5 ಕೌನ್ಸಿಲ್ 6 time. ಬೇರೆಯವರೆಲ್ಲ ಅಡ್ವೊಕೇಟ್ಸ್ ಇದಾರಲ್ರಿ? ಸರುಡ್. ಆಯ್ತು, ಲೋಕನಾಥ್ ಅವ್ರಿಗೆ ಹೇಳಿದಿರಾ?
Yes, my lords.
Submit that already intimated appellant counsel and hence this matter after winter vacation.
53 my lord.
63.
53 53.
53 ಆಗೋಯ್ತು. ಹೇಳಿ ಏನ್?
ಒಂದು 1 week time
ಅದರ್ ಸೈಡ್ ಇಂಟಿಮೇಟ್ ಮಾಡಿದಿರಾ?
ಮಾಡ್ತೀನಿ ಸ್ವಾಮಿ, ಈಗಲೇ ಫೋನ್ ಅಲ್ಲಿ ಹೇಳ್ತೀನಿ.
ಮಾಡ್ತೀವಿ ಬೇಡ, ಮಾಡಿದ್ರೆ ಮಾತ್ರ ಕೊಡ್ತೀನಿ. ಮಾಡಿದ್ಮೇಲೆ ಹೇಳಿ.
ಆಯ್ತು, ಮಾಡ್ತೀನಿ, ಈಗಲೇ ಫೋನ್ ಮಾಡಿ ಹೇಳ್ತೀನಿ ಸ್ವಾಮಿ. 1 week
ಫೋನ್
ಅಂತ
ಮಾಡಿ ಹೇಳಿದ್ಮೇಲೆ ಸಬ್ಮಿಷನ್ ಮಾಡಿ.
ಆಯ್ತು.
1:30 ಮಾಡಿ ಹೇಳಿ.
ಓಕೆ.
ರಿಮೈನಿಂಗ್ at 2:30. ಹಾ, ಸಂಜಯ್ PK.
appear per appellant in this case.
ಹೇಳಿ ಏನ್?
ಸ್ವಾಮಿ 2:30 ಹಾಕೊಳ್ಳಿ ಮೇಡಮ್. ಅಬ್ಜೆಕ್ಷನ್ ಇದೆ, ಆಫೀಸ್ ಅಬ್ಜೆಕ್ಷನ್.
2:30
ಡ್ಯೂರಿಂಗ್ ಕೋರ್ಸ್ ಆಫ್ ದಿ ಡೇ ನಾನು ಅಬ್ಜೆಕ್ಷನ್ ಕಂಪ್ಲೈ ಮಾಡ್ತೀನಿ.
ಯಾಕೆ ಕಂಪ್ಲೈ ಮಾಡಿಲ್ಲ? ನೀವು ಫೈಲ್ ಮಾಡಿದ್ ಯಾವಾಗ?
ಸ್ವಾಮಿ ನಿನ್ನೆನೆ ಫೈಲ್ ಆಗಿದ್ದು, ಮೊನ್ನೆ
ಫೈಲ್ ಆಗಿರೋದೇ ನೆನ್ನ.
ಸ್ವಾಮಿ ಎಕ್ಸ್ಟ್ರೀಮ್ ಎಮರ್ಜೆನ್ಸಿ ಇದೆ ಮೈ
ಪಾಸ್ ಓವರ್.
2:30
ಆಫೀಸ್ ಅಬ್ಜೆಕ್ಷನ್ಸ್ ಇದೆ. ಪಾಸ್ ಓವರ್
ಸ್ಮಾಲ್ ಅಬ್ಜೆಕ್ಷನ್ಸ್ ಇದೆ ಮೈ ಲಾರ್ಡ್.
ಸ್ಮಾಲ್ ನೆನ್ನೆ ಹೋಗಿ ಅರ್ಜೆನ್ಸಿ ಇದ್ದಾಗ ಮಾಡ್ಬೇಕಲ್ವಾ ಹೋಗಿ ಆಫೀಸ್ ಅಲ್ಲಿ?
2:30 ಒಳಗಡೆ ಮಾಡ್ಕೊಡ್ತೀನಿ.
ಆಯ್ತು. ನೆಕ್ಸ್ಟ್
Blood seal number
ನಾನ್
2.
ಫೈಲಿಂಗ್ ಆಫ್ ಶೇರಿಂಗ್ ಅಗ್ರಿಮೆಂಟ್.
Yes. Actually, release date is executed in 2003, my lord. The court
2003 ಅಲ್ಲಿ
3 ನಲ್ಲಿ.
ಹಾ,
They have filed a suit in 2019. Court grant.
ಇಲ್ಲೇನ ನಾನ್ ಫೈಲಿಂಗ್ ಆಫ್ ಶೇರಿಂಗ್ ಅಗ್ರಿಮೆಂಟ್
ಏನ್
ಅಂತ
ಬೇಕಾಗಲ್ಲ. Actually, it may not be essential because court has rejected the IA for restraining alienation. Apartments are fully constructed, my lord. ಈ stage
ಆರ್ಡರ್ ಆಗಿದೆ ಮೇಡಮ್ ಅದ್ರಲ್ಲಿ ಏನಂತ?
ಇಲ್ಲಿ ಏನು ಎಂಟ್ರಿ ಮಾಡಿಲ್ಲ, ಬಟ್ ಹೇಳಿದ್ದಾರೆ ಜಾಯಿಂಟ್ ಡೆವಲಪ್ಮೆಂಟ್ ಪ್ರೊಡ್ಯೂಸ್ ಮಾಡಿ ಅಂತ ಹೇಳಿದ್ದಾರೆ.
ಲೀಗಲ್ ರೆಪ್ರೆಸೆಂಟೇಟಿವ್
We can produce that copy.
ಪ್ರೆಸೆಂಟೆಡ್.
Interim order.
Owner's share is to be solved.
Learned counsel for respond 1 to 3 again seeks time to file sharing agreement ಅಂತ ನೀವೇ ಟೈಮ್ ತಗೊಂಡಿದ್ರಲ್ಲ?
Last time ಅವರು.
Hence finally 1 week time is granted ಅಂತಿದೆ.
ಹೌದು.
ಲಾಸ್ಟ್ ಟೈಮ್ ನೀವೇ ಟೈಮ್
ಆಯ್ತು,
ತಗೊಂಡ್ರಲ್ಲ?
ತಗೋಲ್ಲ.
You only took time.
ಡೆವಲಪರ್ ಇಸ್ ದೇರ್. ಆಯ್ತು, ಕೊಡೋಣ.
ನೀವೇ ತಗೊಂಡ್ರದು.
ಆಯ್ತು,
ಆಯ್ತು, ಪ್ರೊಡ್ಯೂಸ್ ಮಾಡಿ. ಕೊಡ್ತೀರಾ ಈಗ? ಏನು
ಇವಾಗಿಲ್ಲ,
ನಮ್ಮ ಹತ್ರ ಇಲ್ಲ, ಇವ್ರ ಹತ್ರನೇ ಇದೆ.
ನಮ್ಮ
ಹತ್ರ ಇದೆ.
ನಮ್ಮ ಹತ್ರ.
ಓನರ್ ಶೇರ್.
ಲಾಸ್ಟ್ ಟೈಮ್ ಟೈಮ್ ತಗೊಂಡವ್ರು ಯಾರು?
ಆಯ್ತು, ನಾವೇ ಕೊಡ್ತೀವಿ, ಅದು ಕೊಡ್ತೀವಿ. ನೆಕ್ಸ್ಟ್ ವೀಕ್ ಹಾಕ್ಬಿಟ್ಟು
2 3 again seeks time to file sharing agreement ಅಂತಿದೆ.
ಎಸ್.
ಏನ್ ಆರ್ಗ್ಯುಮೆಂಟ್ ಆಗಿತ್ತಾ ಇದ್ರಲ್ಲಿ?
ಅಂದ್ರೆ ಸ್ವಲ್ಪ ಆಗಿತ್ತಂತೆ, ಅಷ್ಟೊತ್ತಿಗೆ ಪ್ರೊಡ್ಯೂಸ್ ಮಾಡಿ ಅಂತ ಹೇಳಿದ್ದಾರೆ.
ತಗೊಳ್ಳಿ. ಕೌನ್ಸಿಲ್ for R 1 to 3 again seeks time. Finally 1 week time granted to file the sharing agreement and hence this matter.
ನೆಕ್ಸ್ಟ್ ವೆಡ್ನೆಸ್ಡೇ
next Wednesday.
ಪ್ಲೀಸ್.
Order may kindly extend.
Entry order ಇದೆಯಾ?
Yes, my lord.
Entry order granted earlier is extended till next date of hearing. ಆಯ್ತು, after winter vacation ಹಾಕೊಳ್ಳಿ ನಿಧಾನ.
ಸ್ವಲ್ಪ ಅರ್ಜೆನ್ಸಿ ಇದೆ. ಅಪಾರ್ಟ್ಮೆಂಟ್ಸ್ ಎಲ್ಲ ಕಟ್ಬಿಟ್ಟಿದೀವಿ.
ನೆಕ್ಸ್ಟ್ ವೀಕ್ ಕೊಡ್ರಿ.
ನನ್ನ ಶೇರ್ನ
11 12.
ಪ್ಲೀಸ್.
ಯಾವ್ದು ರಿಪ್ಲೈನಾ? ಹೇಳಿ. 2 ನಿಮಿಷ ಹೇಳಿ.
My lord, submission to the honorable court is this. Even if the impugned order, which is in appeal before the honorable court, is sustained, the fact that third-party rights have been created, to that extent I need protection, will be the last word I would submit to the honorable court. Because otherwise, my suit is rendered infructuous. I might succeed in the suit. And if he's allowed to create third-party rights, then I'm left nowhere. And my lord will see that there's an interim order, an undertaking of this court, undertaking given by the respondent to this court, which has been violated with impunity. Now, in that respect, I'd like to rely upon a judgment of the Supreme Court. Because that violation was not addressed. And my lord had to remind the respondent to tender an explanation as to the violation of the undertaking. I believe the respondent struggled.
Earlier also you have given citations, sir. Earlier ಕೊಟ್ಟಿಲ್ವಾ?
Yes, yes.
Argument ಮಾಡುವಾಗ.
Yes, because
ಈಗೇನ್ ರಿಪ್ಲೈ ಮತ್ತೆ ಒಂದು
the
25 ತಂದಿದ್ದೀರಿ?
respondent went beyond the scope of the impugned order in producing some new material. My lord is aware of. I'll point out, I have to reply pointing out to those citations. And my submission to the court would be, even by those citations, I'm entitled to a minimal order of ensuring that no third-party rights are created. Now kindly see, the first judgment which I rely upon is at page number.
Paragraph ಹೇಳ್ಬಿಡಿ.
I'll tell you
Paragraph.
I'll submit the, yes. Kindly come to page 69.
Copies.
Page 69.
Yes. This is a case of Delhi Development Authority versus Skipper Construction Company. The relevant paragraph is at paragraph 17. Here, the principle that a contemner ought not to be permitted to enjoy and or keep fruits of his contempt is well settled. In Mohammed Idris versus Rustam,
I will go through the paragraph number 17 then. What is the sum and substance of the
the sum and
paragraph number
substance of the
17?
proposition of law highlighted by the Honorable Supreme Court is this. That if there is an order of the court or an undertaking given to the court which is violated, it is the duty of the court. I mean, let me, with due respect, submit, my lord. Law says that is the duty of the court to set right that violation.
Yes.
Now,
Next.
now the interim application we have filed, my lord, is in respect of the violation of the undertaking given by the respondent, that he will not create third-party rights. My lord will see, the request to the court was a very reasonable request. We came to court for an injunction against changing the nature of the property, even before anything was done to the property. And as the interim applications were being argued in the trial court and before this court, the respondent had, with no concern, pending proceedings before the court, proceeded to put up a construction which obviously had to be at his own risk. And therefore, my lord, when we made a reasonable request to the court, that at least let no third-party rights be created, a prompt undertaking was given by the other side to avoid an interim order of this court that they will not create third-party rights. Now, my lord has noticed the date of that undertaking. And then, my lord, we've submitted sale deeds executed in violation of that undertaking. A very weak response after my lords had requested the other side to address in his reply to my arguments the allegation of violation. A very weak submission was made that they had not sold the property and somebody else had sold the property. Lord will see that the sale deeds have been produced along with the application, and the sale deeds would disclose that the sale is by the respondent acting through his power of attorney. Now, my lord, you give an undertaking to the court.
Yes.
It's your duty to ensure that the undertaking is followed to its word. And the explanation hardly justifies the act of contempt committed by the respondent.
Yes.
And therefore, my lord,
Is the suit filed?
my request to the honorable court would be to set aside those sale deeds and to restore the status quo ante. Even if the issue of possession is to be decided against me by upholding the impugned order. Lord will see that the impugned order was passed on the basis that even if the construction is proceeded with, no equity will be claimed by the other side. So my lord will see that the undertaking not to create third-party rights has to be read in the context of that undertaking to the court that no equity will be created. Now, if third-party rights are created in the same breath of an argument requesting the court to permit construction to proceed and to say that we will not claim any equity, then my lord, transfer of the rights over the property goes against that very conditional submission made by the other side to undertake construction on the basis that no equity would be claimed. Therefore, my lord will see at the time of institution of the suit, the construction was not commenced. It happened during the pendency of the suit. Now, this is quite a runaway by the respondent, and it appears that there is absolutely no protection afforded to the appellant.
Yes.
Now, my lord will see there were two judgments cited by the other side. A recent judgment of the Supreme Court arising from an order passed by this honorable court in certain MFAs. The order passed by this honorable court in those MFAs were also produced by my learned friend.
Already those documents are referred counsel. Any reply?
I'm
Other
replying to,
reply?
I'm exactly referring to, my lord, may I understand lawyers are waiting. Can I do it later? pass forward?
Already given sufficient time. Third, heard the reply arguments of appellant counsel and also counsel produced list of document posted for orders, reserved for orders.
That's only on that undertaking, my lords.
ಏನ್ undertaking?
On the undertaking. so-
Undertaking ನಾನೇ ಕೇಳಿದೀನಿ, ನೀವು ಆನ್ಸರ್ ಮಾಡಿದಿರಿ, that's all.
Please.
No reply to reply.
ಅಲ್ಲ, ಅದ್ರಲ್ಲಿ ನಮ್ಮ ಸಿಗ್ನೇಚರ್ಸ್ ಇಲ್ಲ ಅಂತ.
ಹಾ?
ಅದ್ರಲ್ಲಿ ನಮ್ಮ ಸಿಗ್ನೇಚರ್ಸ್ ಇಲ್ಲ, ನಮ್ಮ GPA ಹೋಲ್ಡರ್.
ಪವರ್ ಆಫ್ ಅಟಾರ್ನಿ ಹೋಲ್ಡರ್ ಯಾರೋ ಮಾಡಿದ್ದಾರೆ ಅಂತ.
ಹೌದು. ಆ ಪವರ್ ಆಫ್ ಅಟಾರ್ನಿ 18/4/2022 ಎಕ್ಸಿಕ್ಯೂಟ್ ಆಗಿದೆ. ಅದು ನಾವು ರಿಟರ್ನ್ ಸ್ಟೇಟ್ಮೆಂಟ್ ಅಲ್ಲಿ ಹೇಳಿದೀವಿ, ಅವ್ರನ್ನ ಪಾರ್ಟಿ ಮಾಡಿಲ್ಲ.
Next, serial number 4.
Okay, for the appellant, my lord. Lord, there is a delay of 124 days in preferring 124 delays, my lord, days delay in preferring this.
Non-filing of objections to a 1 of 24.
Last time
Otherwise-
it's not
Because may
filed.
prefer Monday, my lord. May prefer Monday, my lord. I'll file my wakalat and also my lord.
Objections ಹಾಕಿದಿರಾ ಇಲ್ಲ ಅಷ್ಟೇ ಹೇಳಿ.
ಇಲ್ಲ ಹಾಕ್ಲ Saturday, my lord. Monday, my lord. Monday I prefer, my lord.
Lord, 120.
Entry ಮಾಡ್ರಿ ಏನಾರು ಇದೆಯಾ?
ಇಲ್ಲ, madam.
ಇಲ್ಲ, ತಗೊಳ್ಳಿ. Respondent counsel again seeks time to file objections and hence 1 week time granted, list this matter on. ಯಾವ್ದಾರ ಒಂದು ಡೇಟ್ ಕೊಡ್ರಿ, 11/12.
Lord,
Obliged.
12th, my lord.
12th?
12th.
12. Again seeks time, finally 1 week time granted, list this matter on 12/2.
Lord,
Karthik, yes.
indeed, my
Mayur.
on the last date, my lordship had directed me to consider to read Justice Lordship Nagmohan Das judgment regarding maintainability. It is submitted that judgment was on a writ petition, and the holding was that the writ petition was not maintainable. It had to be a first appeal by
It is
way of
applicable to even for
section-
the MFA also.
90. My lord, my submission is that whether it is a MFA or is a RFA is controlled by the High Court of Karnataka.
Whether the order passed in the writ petition or in any other matter, but court comes to a conclusion that RFA is maintainable, not the any other proceedings. That's what the order passed by this court, and also matter has been disposed of in division bench also in RFA.
My lord, I'm filing a memo
Yen.
seeking prayer for conversion
Conversion,
into RFA, my lord.
RFA, third. Counsel for the appellant files memo seeking permission of this court to convert the same as RFA. And hence permitted to convert the same as RFA. And for the statistical purpose, MFA is disposed of.
Obliged.
Rakesh Kini.
Similar matter.
Similar,
I may also be permitted to convert to. I may also be.
RFA ಆಗ್ಬೇಕಾ?
RFA.
ತಗೊಳ್ಳಿ. Memo ಕೊಡ್ತೀರಾ?
ಕೊಡ್ತೀನಿ, ಬರ್ದು.
Counsel for the appellant files memo seeking permission of this court to treat the convert the same as RFA. And hence permitted to convert the same as RFA And for the statistical purpose, MFA is disposed of.
Let's appear for the appellant's
Council submission with regard to office objection.
138, my lords, is a sketch. Page 138.
My lord, appear for respondent, my lord. Yesterday only I received copy.
Day before we have sent a
ಅದರಲ್ಲಿ
email.
CID ಇನ್ವೆಸ್ಟಿಗೇಷನ್ ಇದೆ, ಲೋಕಾಯುಕ್ತ ಕೇಸ್ಗಳಿದೆ, ಡೀಟೇಲ್ ಅಬ್ಜೆಕ್ಷನ್ ಇಸ್ ರಿಕ್ವೈರ್ಡ್.
Office objection ಏನ್ ನೋಡೋಣ.
My lords, that manuscript in 138 sketch ಇದೆ. It may not be necessary for the present, that other manuscript
138.
138 annexure G1 ಅಂತ ಮಾರ್ಕ್ ಆಗಿದೆ. ಕೆಚ್ಚಲ್ ಕೆಳಗಡೆ
Sketch.
ಅದು ಟೈಪ್ ಕಾಪಿ ಅಂತಾರೆ ಆಸ್ ಆಫ್ ನೌ.
ಆಯ್ತು. Office objection regarding annexure G1 is overruled. Next ಏನಾಗಬೇಕು?
ಇಲ್ಲ ಅಷ್ಟೇ ಅದೊಂದೇ.
ಯಾರು ವಕಾಲತ್ ಹಾಕಿರೋದು ಯಾರು ಇದ್ರಲ್ಲಿ?
My lords, they are on KVI.
ಹಾ.
Now, my lords, an
ನೀವು
injunction.
ಕಾಪಿ ಯಾವಾಗ ಶುರು ಮಾಡಿದೀರಾ?
My lords, email
ನಿನ್ನೆ ಮಧ್ಯಾಹ್ನ ಸರ್
email ಅಲ್ಲಿ ಮೊನ್ನೆ ಕಳಿಸಿದೀವಿ. ಹಾರ್ಡ್ ಕಾಪಿ ನಿನ್ನೆ ಕೊಟ್ಟಿದೀವಿ. ಇಮೇಲ್ ಅಲ್ಲಿ ಮೊನ್ನೆನೆ ಕೊಟ್ಟಿದೀವಿ.
ಆಯ್ತು.
My lords, the injunction.
ಅಬ್ಜೆಕ್ಷನ್ ಡೀಟೇಲ್ ಅಬ್ಜೆಕ್ಷನ್ ಇಸ್
Detail objection.
CID ಇನ್ವೆಸ್ಟಿಗೇಷನ್ ಹೋಗ್ತಾ ಇದೆ ಸ್ವಾಮಿ.
ನೀವು ಕೇವೇಟ್ ಹಾಕಿದ್ಮೇಲೆ ರೆಡಿ ಇರಬೇಕು. ಹೌದಲ್ಲ?
ನಿನ್ನೆ ಮಧ್ಯಾಹ್ನ ಕೊಟ್ರೆ ನಾವು
ನಾಡಿದ್ದು ಹಾಕ್ತೀನಿ, ಹಾಕ್ಬೋದಾ?
ಮಂಡೇ ಸ್ವಾಮಿ ಪ್ಲೀಸ್.
ಮಂಡೆಗೆಲ್ಲ ಯಾಕೆ?
ಪ್ಲೀಸ್.
My problem is.
ಇಂಟ್ರೀಮ್ ರಿಲೀಫ್ ಕೇಳಿರೋದೇನು?
Lords, injunction which was operating from 2016. IA is heard in 2024 and it is rejected. Two compromise where they concede title.
You have enjoyed the interim relief
From 2016.
16 to
2024 now.
ಇಲ್ಲ ಸರ್, ಮಚ್ ಪ್ರಿಯರ್ ಟು ದಟ್ ಸ್ವಾಮಿ. ನಾವು 79 ಇಂದ ಪೊಸಿಷನ್ ದಲ್ಲಿ ಇದ್ದೇವೆ.
Order sheet.
How they have acquired the position? ಎಲ್ಲ bogus concocted said it.
ಏನಾರಾಗ್ಲಿ, when they have enjoyed the relief of temporary injunction before the trial court from 2016 to 24.
No, only one submission, Swami. The present appellant is a respondent number 10 in RFA.
RFA.
Another RFA pending.
ಆಯ್ತು.
ಇನ್ನೊಂದು ವಯಸ್ಸಿನಲ್ಲಿ ಡಿಫೆಂಡೆಂಟ್ ನಂಬರ್ 10 ಸ್ವಾಮಿ. ಅದ್ ಕನ್ಸೀಲ್ ಮಾಡಿ ಹೋಗಿ ಎಕ್ಸ್ ಪಾರ್ಟಿ TI ತಗೊಂಡಿದ್ದು ಸ್ವಾಮಿ. ಐ ಅಪಿಯರ್ಡ್ ಬಿಫೋರ್ ದಿ ಕೋರ್ಟ್.
ಎಕ್ಸ್ ಪಾರ್ಟಿ TI ಆಗಿದ್ದು 2016ರಲ್ಲಿ, ಹೌದಲ್ವಾ? That was vacated in 2024. ಈಗೇನು ಅಷ್ಟೊಂದು ಅರ್ಜೆನ್ಸಿ? ಯಾವಾಗ ಹಾಕ್ತೀರಿ ಸ್ಟೇಟ್ಮೆಂಟ್ ಆಫ್ ಅಬ್ಜೆಕ್ಷನ್ಸ್? ಹಾಕಿ. ಇನ್ ದ ಮೀನ್ ವೈಲ್ ಇಂಟ್ರಿ ಆರ್ಡರ್ ವಾಟ್ ದೇ ಹ್ಯಾವ್ ಎಂಜಾಯ್ಡ್ ಬಿಫೋರ್ ದಿ ಟ್ರಯಲ್ ಕೋರ್ಟ್ ವಿ ಕ್ಯಾನ್ ಪಾಸ್ ಆರ್ಡರ್ ಅಷ್ಟೇ.
ಮಚ್ ಪ್ರಿಯರ್ ಟು ದಟ್ ವಿ ಆರ್ ಇನ್ ಪೊಸಿಷನ್ ಸ್ವಾಮಿ. ನಾವು ಎಂಜಾಯ್ ಮಾಡ್ತಾ ಇದ್ದೇವೆ.
ಆಯ್ತ್ರಿ, ನಿಮ್ಮ ರಿಲೀಫ್ ಆಗಿರೋದು ಈಗ ವೆಕೇಟ್ ಆಗಿರೋದು ಇವಾಗಲ್ವಾ?
ನಮ್ಮ ಅಬ್ಜೆಕ್ಷನ್ ತಗೊಂಡು ತಾವು ದಯವಿಟ್ಟು ಇದು ಮಾಡ್ಬೋದು. ನೆಕ್ಸ್ಟ್ ವೀಕ್ ಎನಿ ಡೇಟ್ ಸ್ವಾಮಿ.
ಈ ವಾರನೇ ಫ್ರೈಡೇಗ್ ಆದ್ರೆ ನಾನು ಏನು ಆರ್ಡರ್ ಪಾಸ್ ಮಾಡಲ್ಲ. ಈ ಫ್ರೈಡೇಗ್ ನೀವು ರೆಡಿ ಅಂದ್ರೆ ನಾನು ವಿಲಿಯರ್ ಅಂಡ್ ಡಿಸ್ಪೋಸ್ ಆಫ್ ದಿ ಮೇನ್
ಸರ್ಟಿಫೈಡ್ ಕಾಪೀಸ್ ಎಲ್ಲ ತಗೊಳ್ಬೇಕು.
ತೊಗೊಳ್ಳಿ. Appellant counsel submits that he has enjoyed the interim relief from 2016 till vacating the interim order before the trial court. And in view of this submission that he had enjoyed the interim relief before the trial court from 2016 to 24 till vacating the order, it is appropriate to.
Much prior to that we are in possession.
Temporary injunction, he shall not interfere with our.
Not to interfere with, and hence respondent is directed not to interfere with the possession of the appellant till the next date of hearing. Counsel for the respondent also seeks time to file objections to IAS and hence list this matter. ಯಾವಾಗ ಬೇಕು ಹೇಳಿ, ನಿಮ್ ಡೇಟೇ ಕೊಡ್ತೀನಿ.
ನೆಕ್ಸ್ಟ್ ವೀಕ್ ಏನೇ ಡೇಟ್?
ಯಾವತ್ತು ಬೇಕು ಹೇಳಿ, ಕೊಡ್ತೀನಿ ನಿಮ್ ಡೇಟ್. 11/12, 13/12, 13/12.
ಆಗ್ಲಿ.
13/12 ಆಯ್ತು.
Please.
Advocate for the appellant in this case, my lord. Matter might be
For the
posted
respondent.
for final.
Non-filing of objections to commissioner report.
We have no
Advocate for
objections.
appellant.
Your
We have no
No
objections.
objections.
No objections.
ಇಬ್ರು ಇಲ್ವಾ?
ಇಲ್ಲ sir.
ತೊಗೊಳ್ಳಿ. Both counsel submit that no objections to the commissioner report. ಏನಾಗ್ಬೇಕು ಈಗ ಮ್ಯಾಟ್ರ್? ಮತ್ತೆ ಹಿಯರ್ ಆಗ್ಬೇಕಾ?
Matter may be posted for final hearing.
ಆಯ್ತು. ಫೈನಲ್ ಹಿಯರಿಂಗ್ RFA.
RFA sir.
ಆಯ್ತು. ಪೋಸ್ಟ್ ದಿ ಮ್ಯಾಟರ್ ಫಾರ್ ಫೈನಲ್ ಹಿಯರಿಂಗ್ ಯಾವಾಗ? ಕಮಿಷನರ್ ರಿಪೋರ್ಟ್ ಯಾವಾಗ? ನಾವು ನಮ್ ಕೋರ್ಟ್ ಡೈರೆಕ್ಟ್ ಮಾಡಿದ್ಮೇಲೆ ಮಾಡಿದ್ದ ಏನು?
ಅದೇ ಲಾಸ್ಟ್ ಡೇಟ್ ಅಲ್ಲಿ ಕಂಪೈಲ್ ಮಾಡೋದು.
ಆಯ್ತು. ಹಾಗಾದ್ರೆ ಬಿಫೋರ್ ವೆಕೇಶನ್ ಕೊಡಿ, ನಾವೇ ಹಿಯರ್ ಮಾಡೋಣ, ಡಿಸ್ಪೋಸ್ ಮಾಡೋಣ. 16/12 ಅವತ್ತು ಇಬ್ರು ರೆಡಿ ಆಗಿ ಬನ್ನಿ. ಮತ್ತೆ ಟೈಮ್ ಕೊಡಲ್ಲ. 16/12 ಆಚೆಗೆ 4 days ಇರುತ್ತೆ ವೆಕೇಶನ್. Awaiting service of notice to propose R2A and B. 27/11 ಅಲ್ಲಿ ಹೋಗಿದ್ಯಾ? ಆಯ್ತು. await notice and list this matter after immediately after winter vacation.
Much.
ಏನಾಗ್ಬೇಕು ಅದ್ರಲ್ಲಿ? 3B4 ಸತ್ತೋಗಿದ್ದಾರೆ. ಇದ್ರಲ್ಲಿ ಯಾರು? ಈರಪ್ಪ ರೆಡ್ಡಿ ಕೌನ್ಸಿಲ್ ಯಾರು?
I filed applications, my lord. Yesterday I filed application.
ಹಾಕಿದೀರಾ? ಯಾವಾಗ ಹಾಕಿದಿರಿ?
ನಿನ್ನೆ ಹಾಕಿದ್ರಿ ಮೂರ್ ಅಪ್ಲಿಕೇಶನ್.
ನೋಟಿಸ್ ಆಗ್ಬೇಕಾ?
ಹೌದು, ನೋಟಿಸ್ ಆಗ್ಬೇಕು.
Issue notice against the R3B and 4. R3B LRs, madam. R3B
ಹೌದು, ಹೌದು.
LRs and R4 LRs. And A number.
ಎಲ್ಲಾರ ಕಂಡೋನೇಷನ್ ಡಿಲೇ ಅಬ್ಜೆಕ್ಟ್ ಸೆಟ್ಟಿಂಗ್ ಅಸೈಡ್ ಮೂರ್ ಹಾಕಿದ್ವಿ.
I 1 to 6 again 1 to 6 against the respective LRs. List this matter immediately after winter vacation. ಅದು in RFA connected ಅಲ್ಲಿ RFA connect 1904 of 2013 ಅಲ್ಲಿ.
For complaint, my lord, the vide has issued the information, my lord, for issuing the award and the plan and the notification, my lord. This is the 19/11/24 issued the information. Some time for issuing.
Delay objections ಇದೆಯಾ ಏನು?
Delay file objections file ಮಾಡಿದ್ದಾರೆ.
Objections file ಮಾಡಿದ್ರು.
File ಮಾಡಿದ್ದಾರೆ.
What is your objection?
The BDA issued the information, my lord. We have to produce the whether the survey the site is comes under the survey number 12/1 of Saraki village or not. This honorable court issued the direction 22/4/24. The appellant has to produce the notification, plan and award. My property, my lord, my father property was acquired 1967. 1 acre 16 guntas. Out of that, my lord, the 9 guntas was given up for it was a developed land. And in the award, my lord, the amount was deducted. From the 1999, it was a partition between my father and myself.
In respect of 9 guntas.
9 guntas is concerned. From the
ಅಲ್ಲ ನಾವೀಗ ಮೆರಿಟ್ಸ್ ಮೇಲೆ ಕೇಳ್ತಿಲ್ರಿ, IML ಡಿಲೇ ಕೇಳ್ತಾ ಇದೀನಿ. 331 days ಗೆ ಏನ್ ಕೊಟ್ಟಿದ್ದಾರೆ?
They have filed the objections, my lord.
ಅವ್ರ objections ಹಾಕ್ಲಿ, ನೀವು reasons ಏನ್ ಕೊಟ್ಟಿದ್ದೀರಿ ಹೇಳ್ರಿ.
Reason is COVID-19, my lord.
COVID-19 MFA 2023 ಇದು. ಈಗೇನ್ COVID-19 ಬರ್ತದೆ?
Applications
in the A1 of 23 ಏನ್ reasons?
Reasons, my lord, the page number 209.
ಓದ್ಕೊಂಡು ಆರ್ಡರ್ ಪಾಸ್ ಮಾಡಿ ಅಂತಾನ ಏನು?
209 ಅಲ್ಲಿ it was affidavit we have filed. Earlier, my lord, the trial court directed to file the written statement. The affidavit number 3, IA number 1, and before 2/1/2021. I have filed the written arguments in the office and IA number 1 due to notice to the plaintiff, even though I have filed the written argument. Para number 6, I submit that my advocate has not communicated the impugned order passed against me. He was not contested. He was not
interested to contest the matter. When the matter was posted for arguments on main. Then only I came to know that my advocate has not cross-examined PW1 and not led any evidence. Immediately I have taken the file on no NOC, so impugned order. The limitation is exempted in COVID-19 1/3/22 from date extended by the Supreme Court. There is 331 days in filing appeal. ಏನಿದು ಏನು ಆರ್ಡರ್ ಏನಿದು impugned order?
Order is not to interfere in the suit property filed by the plaintiff suit, my lord. The plaintiff is suit for declaration permanent injunction. Based on that, the property was.
What is your objections, madam?
Your Honor, they have already violated the interim order granted by the trial court. Your
Interim order ಆಯ್ತು, delay ಹೇಳಿ.
Delay, your lordship may see, they have filed the present petition only in 2023, my lordship. The Supreme Court had given the exemption till 28 February 2022, my lordship. So the delay cannot be condoned and there is no reason state.
After condoning and after the said period, the delay of 331 days. This impugned order was passed on what date?
2021, my lordship.
Particular date, madam.
2/1/21.
6/1/2021.
6/1/21.
6/1/2021. Appeal is filed in 23. The reason is advocate has not communicated the order.
Communicated and he was not contested till the matter was posted for the arguments.
Where is your objection statement, madam?
10/4/2024, my lordship.
Objection to the ಎಲ್ಲಿದ್ದಾರೆ objections, madam? Court officer ಅಲ್ಲೇನಾರು ಇದೆಯಾ ನೋಡಿ separate ಆಗಿ. ಯಾವಾಗ ಹಾಕಿದಿರಿ madam objections?
10th of April 2024.
10th of April.
Yes, my lordship.
8/8/24. Commissioner report. 10th April, statement of objections. Statement of objections to the main appeal or IA?
For only the delay,
Delay. You accept filing return statement, you have not done anything before the trial court when the matter was posted for judgment. You comes up with an application.
Lordship, one more submission, it is
recalling.
already,
Return statement filed, madam.
Only a return statement, ಆಮೇಲೆ ಏನು ಮಾಡಲ್ವಲ್ಲ ನೀವು?
Thereafter, the objections and
one more submission, your lordship.
In the
The
appropriate
matter is
plan-
now posted for cross-examination of PW1. They've already partly cross-examined the PW1.
now, my lord, entire cross-examination was completed. Now the matter is posted for defendant evidence.
Defendant
They have already asked for recalling the
The
stage
cross-examination-
and
During the cross-examination, my lord, he admitted the property comes under 12/1.
ಅದೆಲ್ಲ
and
ಮೆರಿಟ್ಸ್ ಮೇಲೆ ನೋಡೋಣ.
He is in possession of the property.
ಡಿಲೇಗೆ ಹೇಳಿ ಅಷ್ಟೇನೆ. Third,
your lordship.
heard the appellant counsel and also the counsel for respondent on IA number 1 of 23.
Lordship, it may be taken up on some other day to hear on the delay application. Senior will be present.
And there is a delay of 331 days excluding the COVID period. And reason assigned in the application that the advocate who is on record did not communicate the order passed by the trial court in passing the impugned order. And on the other hand, filed the statement of objections contending that after filing the written statement, even not appeared before the trial court. And also extracted the order sheet that no representation from D1 throughout in the proceedings, and when the case was set on for judgment permitting to file the written arguments. At that juncture, an application is filed under order 18 rule 17 for recalling. And also counsel submits that already witness is also recalled and cross-examined the witness, and counsel for the appellant also submits that matter is set on for defendant evidence. And on perusal of the impugned order is passed on
6/1/2020.
6th of January 2021. Allowing the IA, restraining the appellant, interfering, obstructing and disturbing the peaceful possession and enjoyment of the social property. And order was in force from 21 till filing of appeal. And when the case is already set down for defendant evidence, and the reason given in the condonation application is also that advocate on record, he did not communicate the same, and hence he had taken NOC. And when the interim order is in force from 21, and when the case is set down for defendant's evidence, and also taking into note of detailed objection statement, appellant has not made out any ground to condone the delay of 331 days, excluding the benefit of COVID period, and no proper explanation is given, and hence I do not find any ground to condone the delay. And hence IA is rejected, and consequently MFA is dismissed.
My lord, in this, the pendency of this appeal, my lord,
ಏನಾಗಲ್ಲ,
the commissioner,
21ರಿಂದ ಎಂಟ್ರಿ ಮಾಡ್ರಿದೆ, ಈಗ ಡಿಫೆಂಡೆಂಟ್ ಎವಿಡೆನ್ಸ್ ಇದೆ, go
Right.
and take the
this honorable
orders
court,
on merits,
my lord,
that's
this
all.
honorable court has appointed the court commissioner, my lord, on 22/4/24, my lord.
ಅದನ್ನೇ ತಗೊಂಡೋಗಲ್ಲ ರಿಲೀವ್ ಮಾಡಿ.
My lord, in this, the report of the commissioner, my lord, as indicates that the dependent number 1 is in possession of the property.
Make use of the same before the trial court, that's all.
And even the cross-examination, he admits that the.
You get an order on merits, that's all. When the case is set on for defendant evidence and the interim order is there from 2021.
Yes.
You are not.
They have violated and
pursue the
miscellaneous has been
matter.
contempt
Anyhow,
has also
when the
been
case was set on for
initiated.
judgment, you filed an application for recalling and the same is also allowed and witness is recalled and cross-examined. Case is set on for defendant's evidence, you take the order on merits, that's all. Recall the order dated 28/24.
I appear for appellant, my lord.
Hmm?
I appear for appellant.
PF ಕೊಟ್ಟಿಲ್ವಾ? The week's time is granted for taking steps. By that time, if the steps are not taken, the appeal shall stand dismissed without further reference to the court. You can recall the order dated 28, ಹೇಳಿ, counsel ಹೇಳಿ ಏನು?
I filed the recalling application, my lord, before your lordship. Interesting thing, your lordship may be pleased to see. All the other respondents are served. They are before the court, but court has dismissed the whole appeal. Even not against the one respect. For him also, I filed the process memo. It is available in the court itself. But earlier address it was not served. Office did not send it.
But it says that the copy is served to me through email. But no email is. But I have checked, my lord.
Through email, you are not received.
No, my lord. If recall.
Thirdly, counsel for the respondent would submit that he has not received the copy of IA for recalling through email. And counsel for the appellant relies upon the same is served through email. And hence counsel for the appellant is directed to serve the copy of IA 3 of 24 in person. And list this matter on 16/12. 16/12.
My lord, I appear for respondent 13 in this matter. They say they have filed an IA 4 for additional documents. Last time they took time for that, but they have not served me the copy of the IA. They have not served
Sarvana.
They have not served it, and in any case, my submission
Additional
is-
documents ಏನ್ ಹಾಕಿದಿರಿ? ಕೊಡ್ರಿ ಅವ್ರಿಗೆ ಕಾಪೀಸ್.
ಕೊಡ್ತೀವಿ ಸಮಯ. ಇನ್ನೊಬ್ರು ಕೊಟ್ಟಿದ್ದೀವಿ.
ಇನ್ನೊಬ್ರಿಗೆ ಕೊಟ್ಟಿದ್ರಿ, ಇವ್ರಿಗೂ ಕೊಡಿ.
ಕೊಡ್ತೀವಿ.
ಒಬ್ಬರೇ ಇಲ್ವಲ್ಲ. Learned counsel appellant seeks 2 days time to file additional document. Furnish the document which is relying upon forthwith ಅಂತ ಅವತ್ತೇ ಮಾಡಿದ್ವಿ ಆರ್ಡರ್ ನಲ್ಲಿ. Sorry, counsel for R13 submits that he has not received any IA and also the additional document as per IA number 4 of 24. And hence appellant counsel is directed to furnish the IA and documents forthwith to counsel for R13. ನಿಮಗೆಲ್ಲ ಬಂದಿದೆಯಲ್ಲ?
I have received a copy.
ಆಯ್ತು. List this matter on ಯಾವಾಗ?
My lords, may I request a short date, my lords, kindly.
ಯಾವಾಗ ಬೇಕು? ಕಾಪೀಸ್ ಯಾವಾಗ ಸರ್ವ್ ಮಾಡ್ತೀರಿ? ನೀವ್ ಹೇಳ್ರಿ ಅವ್ರಿಗೆ.
ಇವತ್ತೇ ಸರ್ವ್ ಮಾಡಿ. ತರಿಸಿ
Forthwith ಅಂತ ಹಾಕಿ ನೆಕ್ಸ್ಟ್ Thursday ಡೇಟ್ ಕೊಡಿ ಮೇಡಮ್. 5/12.
Next Thursday is what date?
12/12. 12/12. ಆಯ್ತು. ನೆಕ್ಸ್ಟ್ Thursday ಅಲ್ಲ?
Next Thursday.
ಆಯ್ತು 12/12.
Please.
Okay with your terms?
No problems.
A 1 of 24 for amendment of cast title and schedule in plaint.
Yes, my lord. Matter settlement ಆಗಿದೆ, compromise has to be filed. But at that time, suit schedule property ನಲ್ಲಿ 98 and 97 ಅಂತ there was some confusion. All along in the plaint, I have mentioned the site number as 97. Only in the schedule 98.
ಅದರ್ ಸೈಡ್ ಆರ್ ನೀವೇನ್ರಿ? ಏನ್ ಅಬ್ಜೆಕ್ಷನ್ ಇದೆಯಾ? ಇಲ್ಲ. ಅಯ್ಯೋ 1 ಗೆ ಅಮೆಂಡ್ಮೆಂಟ್ ಏನೋ ಕೇಳಿದಾರಲ್ಲ ಅವರು. ಏನೋ ಸೆಟ್ಲ್ ಆಗಿದೆ ಅಂತಾರ ಅವರು.
My lord, I have no information about settlement.
ಸೆಟ್ಲ್ ಆಗಿ ಇನ್ನೊಂದು 98 ಕೂಡ there was another suit. ಆ ಸೂಟ್ ಅಲ್ಲಿ ಕಾಂಪ್ರಮೈಸ್ ಆಗಿ ಮೀಡಿಯೇಷನ್
ಈ ಕೇಸ್ ಅಲ್ಲಿ ಸೆಟ್ಲ್ ಆಗಿದೆಯೇನ್ರಿ?
ಈ ಕೇಸು ಸೆಟ್ಲ್ ಆಗತ್ತೆ ಅಂತ ಆ ಮೀಡಿಯೇಷನ್ ಟರ್ಮ್ಸ್ ಅಲ್ಲಿ ಕೂಡ ಇದೆ ಅಂಡ್ ವಿ ಆರ್ ಪೇಯಿಂಗ್ ದಮ್ ಅಮೌಂಟ್. ಅದರಲ್ಲಿ ಡಿಡಿ ಇದಾಗೋಗಿದೆ, ಡಿಲೇ ಆಗೋಗಿರೋದ್ರಿಂದ ರಿವ್ಯಾಲಿಡೇಟ್
ಮಾಡ್ಬೇಕು. ಹೇಳಿ, ಕಾಪಿ ಸರ್ವ್ ಮಾಡಿದಿರ ಅಯ್ಯನ್ ಅವರಿಗೆ ಅದರ್ ಸೈಡ್ಗೆ?
No, my lords, I have no.
A 1 of 24 ಗೆ ಅಮೆಂಡ್ಮೆಂಟ್ ಆಫ್ ಕಾಸ್ಟ್ ಟೈಟಲ್ ಅಂಡ್ ಶೆಡ್ಯೂಲ್ ಇನ್ ಪ್ಲೈಂಟ್ ಅಂತ ಕೇಳಿದಿರಿ.
ಅಲ್ಲ, ಅದರಲ್ಲಿ
My lords, I have only informed.
ಏನ್ರಿ? ಹೇಳಿ ಏನು?
Matter has been settled.
ಆಯ್ತು.
Mediation ಅಲ್ಲಿ agreement ಸೈನ್ ಆಗಿದೆ.
ಈಗ ಅಯ್ಯ ಹಾಕಿದಿರಲ್ಲ, ಕಾಪಿ ಸರ್ವ್ ಮಾಡಿದಿರ?
ಕಾಪಿ ಸರ್ವ್ ಮಾಡಿದೀನಿ. ಕಾಂಪ್ರಮೈಸ್ ಪಿಟಿಷನ್ is also duly served. Since my lord last date ಅಲ್ಲಿ we could not place it on record. My lord today it has come up.
ಅವ್ರಿಗೆ ಏನು ಗೊತ್ತೇ ಇಲ್ಲ.
ಅವ್ರಿಗೆ ಗೊತ್ತಿಲ್ಲ. ಕೊಲೀಗ್
ಪಾಸ್ವರ್ಡ್ ಮಾಡ್ಬೇಕಾ ಏನು?
May I request it on Monday, my lord. By that time we'll get the DD revalidated.
Appellant counsel seeks time on the ground that matter already been settled and going to revalidate the DD and report settlement, and hence list this matter on 9 ಜಾಸ್ತಿ ಇದೆ, ಬೇರೆ ದಿವಸ ಕೊಡು ಇಲ್ಲ ವೀಕೆಲ್ಲ ಇದೆಯಾ? ಕೊಡಿ 11th
please.
11, 12. Non-filing
lordship.
of memo in respect of deceased R1 and R3. ಹೇಳಿ ಮೇಡಮ್.
My lordship, needful has been done with respect, needful has been done, my lordship, with respect.
Non-filing ಅಂತ ಇದೆ ಇದರಲ್ಲಿ.
Yes, today,
Non-filing of
it's been
memo
done.
in respect of deceased R1 and R3 by order dated
Yes, my lordship,
26/11/24.
memo also has been filed, my lordship,
ಯಾವಾಗ?
with respect to dispensation, my lordship, on
ಯಾವಾಗ
3rd
ಹಾಕಿದ್ರಿ?
December, my lordship.
ಇಲ್ಲಿ ನಾನ್ ಫೈಲಿಂಗ್ ಅಂತ ಇದೆ, ನೀವು ಮೆಮೊ ಹಾಕಿದೀನಿ ಅಂತ ಹೇಳ್ತೀರಾ. ಈಗ ತಂದು ಕೊಟ್ಟಿದ್ದಾರೆ. ಆಯ್ತು, ಏನದು ಹೋಗ್ಲಿ ಮೆಮೊ ಏನು. Memo to dispense the notice against LRs of R123 na?
Yes, my lordship.
123 and 527.
Yes, my lordship.
The apparent counsel has filed memo to dispense the notice against LRs of R123 and R527. And hence, in terms of the memo, dispensed the notice against LRs of R123 and R527 at the risk of the appellant. Next.
Yes, my lordship.
Next.
And then process with respect to.
Non-furnishing of PV of correct address with issue notice to R2, R4, R4. ಹೇಳಿ.
Yes, my lordship, that has been dispensed, my lordship. We have filed the memo, my lordship, for dispensation of.
ಇಲ್ಲಿರೋದು LRs of R123 na? ಆಯ್ತು ತೊಗೊಳ್ಳಿ. In view of the filing, in view of the dispensation of notice against the LRs of R123. But ಇಲ್ಲಿ R2 ಗೆ ಇದೆ ಇಲ್ಲಿ.
With respect to R2, it has been furnished, my lordship.
ಹೌದು, 123.
123, my lordship.
4 ಕೊಟ್ಟಿಲ್ಲ. PF ಕೊಡ್ಬೇಕಲ್ಲ 4 ಗೆ.
Yes, my lordship, we have given the PF, my lordship. Today it has been done, my
The
lordship.
council submits that going to pay PF to issue notice against R4 today itself. If PF paid, issue notice against R4. Next, ಆಮೇಲೆ.
Notice to R8 and 9.
8 and 9 ಗೂನು ಸರ್ವಿಸ್ ಆಗಿಲ್ಲ.
Yes, my lordship, today it has been done. my
ಕೊಡ್ತೀರಾ
lordship.
ಇವತ್ತು? ಕೊಟ್ಟಿದ್ದೀರಾ?
Yes, my lordship.
Council submits that already paid PF to issue notice
R8
against
and.
R8 and R9.
Yes, my lordship.
R9. If PF paid, issue notice against R8 and R9 also. ಅಷ್ಟೇನಾ?
Yes, my lordship.
Recalling ಏನಿದ್ರು ಆಮೇಲೆ ಅಲ್ವಾ? ನೋಟಿಸ್ ಜಾರಿ ಆದ್ಮೇಲೆ. This matter after winter vacation.
Obligement.
16. There are serious matters ಇದೆಯಲ್ಲ?
In this case, therefore, some of the two important issues of but some of the
Again,
matters.
common notification.
Common notice.
Same notification.
Some of the matters where it appears that valuation is more than 15 lakhs. So I don't know whether it has go to division, but.
ಅಲ್ಲ, valuation more than 15 lakhs.
Out of 18 cases.
ಇದರಲಿಲ್ಲ. Eitherly, my lord, your lordship, these matters were listed before your lordship. Wherever, my lord, there where the valuation is more than 15 lakhs, my lord, your lordship.
Division bench.
ಹೋಯ್ತು. ಇದರಲಿ ಎಲ್ಲ ಕರೆಕ್ಟ್ ಆಗಿ ಇದೆ.
ಇದೆಲ್ಲ below 15 lakhs ಇದೆ.
Below 15 lakhs, except one, my lord, which has come. ಅದು serial number 16.15.
15.
ಹೌದು.
ಅದ್ರಲ್ಲಿ ಜಾಸ್ತಿ ಇದೆಯಾ?
ಅದರಲ್ಲಿ ಜಾಸ್ತಿ ಇದೆ.
ನಾರಾಯಣ ಭಟ್ ಯಾರು?
ನಾನೇನು?
ನೀವೇನಾ?
ಹೌದು.
ಇದ್ರಲ್ಲಿ ನೀವೇನೇ ಅಪಲೆಂಟಾ?
ಅದ್ರಲ್ಲಿ ಮಾತ್ರ ನಾನು ಅಪೆಲೆಂಟ್, ಬಾಕಿ
more than
15 lakhs.
ಹಾಗಾದ್ರೆ ಇದನ್ನ ಡಿಲಿಂಕ್ ಮಾಡಿ ಡಿವಿಷನ್ ಬೆಂಚ್
ಅದು ಹೋಗ್ಬೋದು.
ಹೌದಾ?
ಹೌದು.
ನೋಡಿ, ಅಪಲೆಂಟ್ ಕೌನ್ಸಿಲ್.
In other matters also, I request for lordship to see in the.
ಯಾವ್ದು ಬೇರೆದ್ರಲ್ಲಿ ಇದೆಯಾ?
6331 of 2000.
ಮೊದ್ಲಿಂದ ಹೇಳ್ಬಿಡಿ, ಫಸ್ಟ್ ಸ್ಟಾರ್ಟ್ ಆಗದೆ 16.1.
For your kind reference, my lord, I am.
ಯಾವ್ದು ಹೇಳಿ ಕೊಡಿ.
Table. This matter, my lord, in first matter, kindly referred.
ಅಲ್ಲ, ನೀವು ಅಪೀಲ್ ಮೆಮೋದಲ್ಲಿ ಯಾವ ಅಮೌಂಟ್ ಜಾಸ್ತಿ ಇದೆ?
6331 of 2021.
ಅದರಲ್ಲಿ ನಿಮ್ದು ಈಗ ಡಿಫರೆನ್ಸ್ ಅಮೌಂಟ್ ಏನು? ಡಿಫರೆನ್ಸ್ ಬಿಟ್ವೀನ್ ಕೋರ್ಟ್ ಅವಾರ್ಡ್ ಅಂಡ್ ಡಿಗ್ರಿನಾ?
awarded 11,71,565.
ಅಲ್ಲ, ನನಗ್ ಬೇಡ, ನನಗ್ ಅದ್ ಬೇಡ. ಅಪೀಲ್ ಅಲ್ಲಿ ಯಾವ್ದು ಮೋರ್ ದೆನ್ 15 lakh ಇದೆ ಅದನ್ನ ಹೇಳ್ಬಿಡು. ಎಲ್ಲ ಇದ್ದಂಗಿದೆ ಇದ್ರಲ್ಲಿ?
ಹೌದು ಸರ್.
ಇಲ್ಲ
ಅಲ್ವಾ?
No, only for 5 or 6 cases.
ಡಿಫರೆನ್ಸ್ ಬಿಟ್ವೀನ್ ಕೋರ್ಟ್ ಅವಾರ್ಡ್ ಅಂಡ್ ಡಿಗ್ರಿ ಅಂತ ಇದೆಯಲ್ಲ? ಈಗ ನೀವು ಚಾಲೆಂಜ್ ಮಾಡಿರೋದು ಯಾವ್ದ್ರಲ್ಲಿ ಅಮೌಂಟ್ ಕಡಿಮೆ ಇದೆ ಅಷ್ಟು ಮಾತ್ರ ನಾವ್ ಇಟ್ಕೋಬಹುದು ಅಷ್ಟೇ.
6331 of 2021. Table ಅಲ್ಲಿ first matter.
ಫಸ್ಟ್ ಮ್ಯಾಟರ್ ಅಲ್ಲಿ
ಕಾಲಮ್ ನಂಬರ್ 6. Enhanced by reference quote 16,85,001.
ಎನಾನ್ಸ್ ಆಯ್ತ್ರಿ, ಈಗ ನೀವು ಚಾಲೆಂಜ್ ಮಾಡುವಾಗ ನಿಮಗೆ ಎಷ್ಟು ಬರ್ಬೇಕು ಅಂತ ಕ್ಲೈಮ್ ಮಾಡಿರಿ, ನೀವು ಎನಾನ್ಸ್ಮೆಂಟ್ ಕೇಳಿದಿರಿ.
Against enhancement.
ಬೆನಿಫಿಷಿಯರಿ ನೀವೇ ತಾನೇ ಎನಾನ್ಸ್ಮೆಂಟ್ ಕೇಳಿರೋದು.
No, please. Against enhancement they have.
Huh?
Against enhancement.
ಎಗೇನೆಸ್ಟ್ ಎನಾನ್ಸ್ಮೆಂಟ್ ಬಂದಿರೋದಾ? ಆಯ್ತು, ಎಗೇನೆಸ್ಟ್ ಎನಾನ್ಸ್ಮೆಂಟ್ ಅಲ್ಲಿ ಯಾವ್ದು ಮೋರ್ ದೆನ್ 15 lakh ಇದೆ ಅದನ್ನ ಹೇಳಿ.
First matter 6331 of 2021.
ಅದರಲ್ಲಿ
16,85,113 enhanced by.
ಹಾಗಾದ್ರೆ ಇದು ಡಿವಿಷನ್ ಬೆಂಚ್ ಹೋಗ್ತದೆ. ಆಯ್ತು, ನೆಕ್ಸ್ಟ್
Matter may not 6334 of 2021.
44
34.
ಅದರಲ್ಲೂ 15 lakh ಮೋರ್ ದೆನ್
74,000 enhanced by
ಆಯ್ತು.
reference quote.
ಆಯ್ತು.
Then
even 6335 ಆಲ್ಸೋ
2021.
ಅದು ಕೂಡ ಹೋಗುತ್ತೆ.
19 lakh.
ಆಯ್ತು. ಆಮೇಲೆ
One
ಇನ್ನೊಂದು ಯಾವ್ದೋ ಒಂದು ಇದು 6341 ಒಂದು ಇದೆ ನೋಡಿ. 6341
ಇದೆ.
ಅದು ಕೂಡ 20 ಲಕ್ಷ ಇದೆ. ಅಷ್ಟೇನಾ? ನಿಮ್ಮ ಅಪೀಲ್ಸ್ ಅಲ್ಲಿ
16.15 my lord.
ಆಮೇಲೆ ಇದೊಂದಿದೆ ನೋಡಿ 17 5953 ಆಫ್ 23 ಒಂದಿದೆ ನೋಡಿ, ಅದ್ರಲ್ಲಿ 16,87,966 ಇದೆ.
ಅದು 18 ಆಲ್ಸೋ.
ಹೌದಾ? 5953. ಆಮೇಲೆ ಮತ್ತೆ ನೆಕ್ಸ್ಟ್ ಮ್ಯಾಟ್ರ್ ಅಷ್ಟ 7840 ಆಫ್ 23. ಅದು ಕೂಡ 38 lakh ಇದೆ. ಅಂದ್ರೆ ನಿಮ್ದ್ರಲ್ಲಿ 1 2 3 4 5 6 ಇಷ್ಟು ಮ್ಯಾಟ್ರಸ್ ಡಿವಿಷನ್ ಬೆಂಚ್ ಹೋಗ್ತದೆ. ಹೌದಾ? ನಿಮ್ದು MF ಯಾವುದು?
16.15 MFA 6830 of 20.
MFA ನಂಬರ್ ಇಲ್ಲಿ
68 30 20 22 2022.
ಒಂದೇನಾ?
ಒಂದೇ.
ನೋಡು. These matters are listed before this court. And respected counsel pointed out that MFA 6331 of 21, MFA 6334 of 2021, MFA 6335 of 2021, MFA 6341 of 2021, MFA 5953 of 23, MFA 7840 of 2023, and MFA 6830 of 2022. All these matters appeal value is more than 15 lakhs and hence matter may be referred to the division bench. And in view of the said submission and also taking into note of enhanced award by reference court, these appeals are may be listed before the division bench for consideration and the value of the appeal is more than 15 lakhs. And hence registry is directed to delink these appeals and post the same before the division bench. Remaining ಉಳಿದಿದ್ದೇನಾರು ಹೇಳ್ತೀರಾ ಅಥವಾ ಏನಾರು ಡೇಟ್ ಬೇಕಾ?
ಇದು one more submission.
We are ready.
One more.
We are ready.
One more submission. But the main issue involved in this case is valuation of trees. The trees were not mango trees. We claim a lot it is nati, they claim a lot it is badami. And in the report of the horticulture department itself, there is an inconsistency and variations are there. I'd like to bring to point out. Meanwhile, my lord, we got the RTC also for the relevant survey numbers of the land, which clearly shows, my lord, there was no crop at all. Forget about nati or badami. So I would like to find this.
ಸಾಕಾದಾರ along with application.
ಅದಕ್ಕೆ ಸ್ವಲ್ಪ next week.
With application.
Next week ತಾವು ಇಟ್ಕೊಂಡ್ರೆ.
ನೀವ್ ಯಾರು ಅಪಿಯರ್ ಆಗೋದು ಇದ್ರಲ್ಲೆಲ್ಲ? Appellants ಗ? Appellants. ನೋಡಿ ಯಾವ್ದ್ರಲ್ಲಿ?
All cases.
All cases ಅಲ್ಲಿ ನೀವೇ appellant counsel submits that he intend to file additional documents with necessary application.
One submission.
ಹೇಳಿ.
Their own inventory, my lord, drawn at the time of acquisition shows the existence of trees. James is there. My lord, joined by.
ಅವ್ರು ಹಾಕ್ಲಿ, ನೀವು ತಕರಾರು ಹಾಕಿ, IAS will be considered along with main appeal.
Please, my lord.
ಅಷ್ಟೇ. ಅಲ್ವಾ?
ಇದರಲ್ಲಿ ಏನಾಗಿದೆ ಅಂದ್ರೆ ಕೆಲವುದರಲ್ಲಿ
ಸರಿ, ಈಗ ಅವ್ರಿಗೆ ಡಾಕ್ಯುಮೆಂಟ್ ಹಾಕೋದ್ನ ನಾವು ಪ್ರಿವೆಂಟ್ ಮಾಡಕ್ಕಾಗಲ್ಲ.
ಅಲ್ಲ, ಅದನ್ನು last 3 occasions, my lord, they are repeating the same submission.
ಯಾಕ್ರಿ?
No, I got it last night.
My lord, in some cases they have produced, my lord, just to buy time, my lord, they are doing it.
I want.
Last time also they submitted, they will file application for additional evidence.
Well, I pray for a week's time, not more.
ಆರ್ಡರ್ ಶೀಟ್ ಕೊಡಿ.
2010 notification, my lord.
And my lord, exhibit P1 is their own document.
2003 na.
10 notification. 2010 notification. 14 years is left.
Last time ಅದೇ ಹೇಳಿದೆ, learned
Yes, please.
counsel for the appellant seeks a week's time to get instructions from the concerned secretary.
That's
And
what
learned
we have
counsel for the
received.
respondent submit that they are ready.
That's what we have received the
These documents and so on.
department by now.
So intent to file ಏನು madam? Additional documents along with application. And hence, 1 week time granted to file such any documents with appropriate application. ಈಗ ಫಿಕ್ಸ್ ಮಾಡಿದ್ರು ಅವ್ರ ಹಾಕ್ಬೇಕು, ಅದಕ್ಕೆ ತಕರಾರು ಹಾಕ್ಬೇಕು.
because
ಆಯ್ತು ಲಿಸ್ಟ್ ದಿಸ್ madam ಒಂದ್ ವಾರ ಬಿಟ್ಟು ಕೊಡ್ರಿ.
12th your lordship my kindly.
and division bench ಮುಂದನು ಅದು ಇದೇ reason ಗೆ time
ಆಯ್ತು ಲಿಸ್ಟ್ ದಿಸ್ matter on 12th.
Apply.
ಅಷ್ಟೊಳಗೆ ಡಾಕ್ಯುಮೆಂಟ್ಸ್ ಹಾಕಿ
Entry matter is there, kindly extend.
ಎಂಟ್ರಿ ಮಾಡ್ರಿ ಇದೆಯಾ, ಎಂಟ್ರಿ ಮಾಡ್ರಿ ಗ್ರಾಂಟೆಡ್ ಅಲ್ಲಿಯರ್ ಇಸ್ ಎಕ್ಸ್ಟೆಂಡೆಡ್ ಟೇಬಲ್ ಕೊಡಿ.
My lord, in 3 matters, they did not deposit, my lord, 50% as ordered by your lordships.
ಆಯ್ತು ನೀವು ಎಕ್ಸಿಕ್ಯೂಷನ್ ಹಾಕೊಳ್ಳಿ ಅಷ್ಟೇ.
ಇದರಲ್ಲಿ ಏನಾಗಿದೆ ಅಂದ್ರೆ ಸ್ಟೇ ಎಕ್ಸ್ಟೆಂಡ್ ಆಗಿದೆ.
ಅದರಲ್ಲೂ ಸ್ಟೇ ಎಕ್ಸ್ಟೆಂಡ್ ಆಗಿದೆಯಾ? ಯಾವ್ದು?
ಈಗ 16.16, 16.17, 16.19.
ಏನ್ರಿ ಅದು?
They did not deposit.
ಡೆಪಾಸಿಟ್ ಮಾಡಿದ್ರೆ ಇಲ್ಲ. ಲಾಸ್ಟ್ ಟೈಮ್ ಏನು ಆರ್ಡರ್ ಶೀಟ್ ಅಲ್ಲಿ ಇರ್ಬೇಕು ನೋಡಿ ಅದು.
We'll make a submission.
Mostly ಅದನ್ನು.
With the officer.
Same submission last time also.
Same submission was made on the last occasion also. My lord, in one matter, my lord, it is recorded.
Please, sir, the 800 authorized on the matters of members. Members look at the lies as you. With the no document.
ಇದ್ರಲ್ಲಿ ಡೈರೆಕ್ಷನ್ ಇದೆಯಲ್ಲಿ learned counsel appellant is directed to serve a copy. Learned counsel for the appellant is directed to produce the document for having deposited the amount as directed by this court by the next date of hearing ಅಂತ MFA 7842 of 23 ನಲ್ಲಿ ಆರ್ಡರ್ ಇದೆಯಲ್ಲ,
Then that is to be the case, we'll compare the order.
ಅದೊಂದ್ರಲ್ಲೇ ಆರ್ಡರ್ ಇದೆ. ನಿಮ್ ಪ್ರಕಾರ ಯಾವ್ದಾದ್ರಲ್ಲಿ ಆರ್ಡರ್ ಇಲ್ಲ?
MFA 5943 of 23.
ಸೀರಿಯಲ್ ನಂಬರ್ ಹೇಳ್ಬಿಡಿ.
Serial number 16.16,
16
17, 19.
ನೋಡಿ, the counsel for the appellant would submit that in MFA 5943 of 23. ಯಾಕೆ ಎರಡು ಸೀರಿಯಲ್ ಎಷ್ಟಾಗಿದೆ ಇದು? ಎರಡು ಸೇಮ್ ನಂಬರ್ ಇದೆಯಲ್ಲ ಮೇಡಮ್?
ಒಂದು 43 ಮತ್ತೊಂದು 53 ಸ್ವಾಮಿ.
ಸರಿ MFA ನಂಬರ್ 5953 of 23 and MFA number
7842 of 23.
7842 of 23. The amounts are not deposited as per the order of this court, and this court already directed in respect of MFA 7842 of 23 to produce the document, and till date not produce the document, and hence directed to produce the document within 1 week from today for having deposited the amount. If no such deposit is made by the appellant, and not filed any document for having deposited the amount, the respondent is given liberty to proceed against them in accordance with law. ಇನ್ನೊಂದೇನು ಕ್ಲಾರಿಫಿಕೇಶನ್ ಏನೋ ಇದೆ ಅಂತ ಒಂದು 16
ಪರವಾಗಿಲ್ಲ ಇಷ್ಟ ಆಯ್ತಲ್ಲ
ಯಾರು? ಹಾ 40. ನಂಬರ್ ಏನಾದ್ರು ತಪ್ಪ ಹಾಕಿದಿರಾ ನೋಡಿ.
2010 14 years ಆಗಿದೆ.
7842 ಇವತ್ತಿದೆಯಾ? 40 ಇದೆ, 7842 ಅಂತಾರೆ ಇದ್ರಲ್ಲಿ. ಏನಿದೆ?
7842.
ಆಯ್ತು. In the meanwhile, the office, the appellant is directed to comply with office objections ಅಂತ ಹಾಕ್ಬಿಡಿ. 16.80 ಅಲ್ಲಿ ಇದ್ರಲ್ಲೇ ನೋಡ್ರಿ, ನಂಬರ್ ಏನಾರು ಹೆಚ್ಚು ಕಡಿಮೆ ಇದೆಯಾ ನೋಡಿ ಹೇಳಿ. ಕರೆಕ್ಟ್ ನಂಬರ್ ಕೊಡಿ, ಆಮೇಲೆ ಮತ್ತೆ ಟ್ರಾನ್ಸ್ಫರ್ ಆಗೋಗಿ ಬೇರೆ ಕೋರ್ಟ್ಗೆ ಇನ್ನೇನು ಹಾಕ್ಬಿಡಿ. ಆಯ್ತು. ನೆಕ್ಸ್ಟ್,
Let's, if they want to file application, let them serve a copy in advance so that we will also file objection.
ಕಾಪಿ ಸರ್ವ್ ಮಾಡಿ ಅವ್ರಿಗೆ.
And the next date of hearing, we will be ready for.
ಆಯ್ತು. within 1 week ಅಂತ ಆಯ್ತಲ್ಲ ಅಲ್ಲಿ, ಫೈಲ್ ದಿ ಡಾಕ್ಯುಮೆಂಟ್ಸ್ and also
12th.
ಸರ್ವ್ ದಿ ಕಾಪಿ on the other side well in advance ಅಂತ ಹಾಕ್ಬಿಡಿ ಅಷ್ಟೇ, or before filing the application.
Let it be in the final hearing.
ಬೇಡ ಇರ್ಲಿ.
ಆಯ್ತು, admission. ಅಲ್ಲ 2010 ಇಂದ they are suffering.
ಆಯ್ತು. 12. Serial number 17. ಕನೆಕ್ಟೆಡ್ ಅಲ್ಲಿ ಏನೋ ಫರ್ನಿಶಿಂಗ್ ಆಫ್ PF ಅಂತ ಇದೆಯಲ್ರಿ? R1, R2 and R4 ಕೊಟ್ಟಿದ್ದೀರಾ? ಕೊಟ್ಟಿದ್ದೀರಿ ಯಾವಾಗ? The council submit that paid the PF in MFA number 1258 of 23 to issue notice against R1, R2 and R4 and hence issue notice against R1, R2, R4. This entry ಮಾಡಿದ್ಯಾ? Entry ಮಾಡಿದೆ. Entry order granted earlier is extended till next date of hearing. ಹೇಳಿ.
I am the contesting defendant. Interim order was paid against me. Not I have entered appearance. Not
ನೀವು ಇದ್ರಲ್ಲಿ ಅಪಿಯರ್ ಆಗಿಲ್ವಾ R5 and R6 ಗೆ? ಈ MFA ನಲ್ಲಿ ರಿಲೀಫ್ ಯಾರ ಮೇಲೆ ಕೇಳಿರೋದು?
ನಮ್ಮ ಮೇಲೆ.
ನಿಮ್ಮ ಮೇಲೆ ಮಾತ್ರನಾ? ಇನ್ ಯಾರ ಮೇಲೆ ಕೇಳಿಲ್ವಾ?
ಬೇರೆಯವ್ರ ಮೇಲೆಲ್ಲ ಮೆಮೊ ಹಾಕ್ಬಿಟ್ಟು
ಬೇರೆಯವರೆಲ್ಲ ಹಾಕ್ಬೇಕು ಮತ್ ಪಾರ್ಟಿ. ಸರ್ವಿಸ್ ಆಗಿಲ್ಲ ಸರಿ, ಅವ್ರ ಮೇಲೆ ರಿಲೀಫ್ ಕೇಳಿದಿರಾ?
ಇಲ್ಲ ಇದರಲ್ಲಿ ಕಾಸ್ಟ್ ಇಲ್ಲಿ ಕೆಳಗಡೆನೆ ಅವರು ಕೆಳಗಡೆ
ಮೇಲ್ಗಡೆದ್ರಲ್ಲಿ R5 R6 ಅಂತಿದೆ ಅಲ್ವಾ? ಬಾಕಿಯವ್ರಿಗೆಲ್ಲ ಡಿಸ್ಪೆನ್ಸ್ ಆಗಿದೆಯಾ?
ಅಪ್ಲಿಕೇಶನ್
1273 ನಲ್ಲಿ ಡಿಸ್ಪೆನ್ಸ್ ಆಗಿದೆಯೇನ್ರಿ?
ಅಲ್ಲ ತಾವು ಅಪ್ಲಿಕೇಶನ್ ನೋಡಿದ್ರೆ ಅಪ್ಲಿಕೇಶನ್ ಹಾಕಿರೋದೇ ನಮ್ಮ ಮೇಲೆ. ಸೂಟ್ ಅಲ್ಲಿ ಎಷ್ಟೊಂದ್ ಜನ ಇದ್ದಾರೆ. ಆ ಇಂಟ್ರಿಮ್ ರಿಲೀಫ್ ನಮ್ಮ ಮೇಲೆ ಮಾತ್ರ ಕೇಳಿರೋದು. ಅದಕ್ಕೆ ತಾವು ಒಂದು ಪೇಜ್ ನಂಬರ್ 22
ನೋಟಿಸ್ ಆರ್ಡರ್ ಆಗಿಲ್ಲ, ಅದೇನೆ ಅದಕ್ಕೆ ಕೇಳ್ತಾ ಇದ್ದೀನಿ. ಕಾಮನ್ ಆರ್ಡರ್ ಇದು?
ಸೂಟ್ ಫಾರ್ ಡಿಕ್ಲರೇಷನ್ ಅಂಡ್ ಪೊಸಿಷನ್.
ಅಲ್ಲ IML ಕಾಮನ್ ಆರ್ಡರ್ ಕಾಮನ್ ಆರ್ಡರ್ IA number 10 and 12. IA 10 is filed under 13 rule 102 reduce section with the plaintiff praying temporary injunction against the legal heirs of defendant number 5 ಅಂತಿದೆ. ನೀವೇನಾ? ನೀವು ಮಾತ್ರ. ಆಮೇಲೆ ಇನ್ನೊಂದು ಯಾವ್ದು?
ಇನ್ನೊಂದು ವೆಕೇಟಿಂಗ್ ಅಪ್ಲಿಕೇಶನ್. ಒಂದು ಅಪ್ಲಿಕೇಶನ್ ಫಾರ್ ಇಂಜಂಕ್ಷನ್ ಸ್ಟೇಟಸ್ ಕೊಟ್ರು. ನಾವು ಹೋಗಿ ವೆಕೇಟ್ ಮಾಡಿ ಅನ್ನೋ ತರ ಕೇಳ್ಕೊಂಡ್ವಿ.
ಬೇರೆಯವರೆಲ್ಲ ಯಾಕೆ ಬೇಕು ಪಾರ್ಟಿ ಇದ್ರಲ್ಲಿ? ಏನ್ ಹೇಳಿ?
ಟ್ರಯಲ್ ಕೋರ್ಟ್ ಅಲ್ಲಿ
ಏನಾಗಿದೆ? ಇಂಜಂಕ್ಷನ್ ಟ್ರಯಲ್ ಕೋರ್ಟ್ ಅಲ್ಲಿ
ಸೂಟ್ ಫಾರ್ ಡಿಕ್ಲರೇಷನ್ ಅಂಡ್ ಪೊಸಿಷನ್
ಇವೆಲ್ಲ ರಿಜೆಕ್ಟ್ ಆಗಿದೆ.
ಡಿಕ್ಲರೇಷನ್
ಎಂಟ್ರಿ ಮಾಡಿದ್ಯಾ?
ಇಲ್ಲಿ ಕೊಟ್ಟಿದ್ದಾರೆ, ಇಲ್ಲಿ ಕೊಟ್ಟಿದ್ದಾರೆ.
ಇಲ್ಲಿ ಎಂಟ್ರಿ ಮಾಡ್ರು ತಗೊಂಡು ಯು ಆರ್ ಎಂಜಾಯಿಂಗ್. ಮತ್ತೆ
ಗಲಾಟೆ ಆಗ್ತದೆ.
ಎಂಟ್ರಿ ಮಾಡ್ರೆ ಆಗಿರೋದು ಯಾವಾಗ? 23 ನಲ್ಲಿ. ವೈ ಯು ಆರ್ ಟೇಕಿಂಗ್ ಸ್ಟೆಪ್ಸ್ ಅಗೇನ್ಸ್ಟ್ ಅದರ್ಸ್? ನೀವಿಲ್ಲಿ R5 ಗೆ LRs ಗೆ ಎರಡರಲ್ಲೂ ಅಪಿಯರ್ ಆಗಿದ್ದೀರಾ?
ಹೌದು.
Restraining them from putting up any construction.
ಟ್ರಯಲ್ ಕೋರ್ಟ್ ಅಲ್ಲಿ ಸೂಟ್ ಫಾರ್ ಡಿಕ್ಲರೇಷನ್ ಅಂಡ್ ಪೊಸಿಷನ್.
ಆಯ್ತ್ರಿ, ನಮಗೆ ಈಗ IA MFA ಮಾತ್ರ ಬರೋದು. ಇಲ್ಲಿ ರಿಲೀಫ್ ಕೇಳ್ತಾ ಇರೋದು R5 and R5 ಮೇಲೆ ಮಾತ್ರ.
ನಾವೇ
ಬೇರೆಯವ್ರು ಹಾಕ್ಬೇಕ್ರಿ. ಮೆಮೊ ಹಾಕಿ ಈಗಲ ಡಿಸ್ಪೆನ್ಸೇಷನ್ ಮೆಮೊ ಹಾಕಿ ಪಾಸ್ ಅವರು. ಅವ್ರಿಗೆ ನೋಟಿಸ್ ಇಟ್ಕೊಂಡು ಎಂಟ್ರಿ ಮಾಡ್ರನ್ನ 10 ವರ್ಷ ಎಂಜಾಯ್ ಮಾಡೋದು ಬೇಡ. ಫೈಲ್ ಮೆಮೊ ಎಕ್ಸೆಪ್ಟ್ LRs of R5, no other parties are necessary for deciding this MFA. Pass over. Vasudevan PV.
My lord, in this I filed the writ petition seeking the succession certificate in favor of the appellants, my lord. There are no respondents.
ಏನಾಯ್ತು?
One Shobha Setu Madhavan
ಏನಾಗಿದೆ? ರಿಜೆಕ್ಟ್ ಆಗಿದೆಯಾ?
ಟ್ರಯಲ್ ಕೋರ್ಟ್ ಅಲ್ಲಿ ರಿಜೆಕ್ಟ್ ಆಯ್ತು.
ರೆಕಾರ್ಡ್ಸ್ ಬಂದಿಲ್ಲ.
ಬಿಕಾಸ್
ಬಂದಿಲ್ಲ. ಕಾಲ್ ಫಾರ್ ರೆಕಾರ್ಡ್ಸ್. ಲಿಸ್ಟ್ ದಿಸ್ ಮ್ಯಾಟರ್ ಇಮಿಡಿಯೇಟ್ಲಿ ಆಫ್ಟರ್ ವೆಕೇಶನ್. Prakash MH. CD of 69 days in filing. Other side are D Manjunath for R1 to R3. Wakalat not filed ಅಂತಿದೆ. ಮತ್ತೇನು ಅವ್ರಿಗೆ ನೋಟಿಸ್ ಆಗಿತ್ತ? ಏನಾಗಿತ್ತು ನೋಡಿ ಮೇಡಮ್? ಪ್ರಸನ್ನ ಕುಮಾರ್ ಫಾರ್ R4 to R8. ಅವರು ವಕಾಲತ್ ನಾಟ್ ಫೈಲ್ಡ್.
Appearing for R1 to R3, my lord.
Why you are not filed wakalat?
I'll file it in a week's period. I'll file it in a week's period, my lord. And then
print the name of D Manjunath as a learned counsel for respondent 1 to 3 and released on 11/4/23. ವಕಾಲತ್ ಹಾಕ್ದಲ್ಲೇ ಪ್ರಿಂಟ್ ಏನ್ ಮಾಡೋದು?
On the previous occasion, counsel had made a submission that he will take the notice and file wakalat Lordship.
ಆಯ್ತು ಮೇಡಮ್, ಅಂಡರ್ಟೇಕಿಂಗ್ ಮಾಡ್ಕೊಂಡ್ರು ವಕಾಲತ್ ಹಾಕ್ಬೋಲ್ಲ. ರಿಜಿಸ್ಟ್ರಿ ಪ್ರಿಂಟ್ ದಿ ನೇಮ್ ಆಫ್ CS ಪ್ರಸನ್ನ ಕುಮಾರ್ as learned counsel appearing for respondent 4 to 8. List the admission immediately after summer vacation. Office objections are kept in abeyance. Comply with the order dated so and so. Show the name of the CS Prasanna Kumar. ಏನ್ರಿ ಇಬ್ರು ವಕಾಲತ್ ಹಾಕಿರಲ್ಲ?
It seems that the notice to the advocates is served on citizen.
Hmm.
Appellate counsel must ನಮಗೆ ನೋಟಿಸ್ ತಗೊಂಡಿದ್ದಾರೆ ನಾವು ಇನ್ಫಾರ್ಮ್ ಮಾಡಿರ್ತೀವಿ ಎಲ್ಲ ಮೋಸ್ಟ್ ವಕಾಲತ್ ಕಲೆಕ್ಟ್ ಮಾಡ್ಕೊಂಡು ಫೈಲ್ ಆಗಿದೆ.
ಏನ್ ಮಾಡ್ಬೇಕು ಹೇಳಿ, ಟೈಮ್ ಕೊಡ್ಬೇಕಾ ವಕಾಲತ್ ಹಾಕಕ್ಕೆ?
ನಾನು ವಕಾಲತ್ ಫೈಲ್ ಮಾಡ್ತೀನಿ ಸ್ವಾಮಿ 1
ನೋಡಿ,
week.
counsel for D12 ಅಲ್ಲ R1 to R3 seeks time and counsel for R4 to 8 is absent but not filed the wakalat, and finally 1 week time granted to file wakalat both the counsel. If both the counsel fails to file wakalat on behalf of respondent number 1 to 8 and their name will be going to delete in the cause list and list this matter after 1 week ಬಿಟ್ಟು ಕೊಡಿ madam. 12.
A pleasure, Lord.
The appellant. Lords, in this, my lords, they're auditing their accounts, my lords, they're auditing their accounts, my lords, the appellant, to check whether they can settle the matter with the respondent, my lords. So short accommodation may be granted beyond.
ಯಾವಾಗ ಹೇಳಿ?
The one more matter was there 3 days back, my lords, that is been
ಅದು ಯಾವತ್ತಿ ಪೋಸ್ಟ್ ಆಗಿದೆ?
ಅದು after vacation ಆಗಿದೆ sir.
ಇದನ್ನು after vacation ಹಾಕೊಂಡು.
Yes, all 4 matters, any date after vacation may be fixed, my lord.
The counsel appearing for the appellant would submit that matter has been settled.
Not has been settled, they're auditing their accounts to see if a set, because it's a money suit, my lords. They're seeing if.
Auditing.
They're auditing.
Auditing ನಮಗೂ ಏನು ಸಂಬಂಧ ಇಲ್ಲ. ಈಗ ಹೇಳಿ ಏನು?
ಅಲ್ಲ, they're.
IFI is rejected. ಅದ್ರ ಮೇಲೆ ಹೇಳಿ.
ಅಲ್ಲ, the IA.
ನಿಮ್ಮ ಆಡಿಟಿಂಗಿಗೂ ನಮಗೂ ಏನು ಸಂಬಂಧ? ಇಲ್ಲಿ ಆರ್ಡರ್ 9 ರೂಲ್ 13 ಅಪ್ಲಿಕೇಶನ್ ಡಿಸ್ಮಿಸ್ ಆಗಿದೆ. ರೀಸನ್ಸ್ ಏನ್ ಸರಿ ಇದೆಯಾ ಇಲ್ಲ ನೋಡ್ಬೇಕು.
ಅಲ್ಲ, only on the ground of delay, my lords. In the meanwhile, they're trying to settle the matter with them, my lords.
ಆಯ್ತ್ರಿ, ನೀವು ಆರ್ಗ್ಯುಮೆಂಟ್ ಮಾಡಿ ಏನ್ ನೋಡೋಣ. ವಾಟ್ ಇಸ್ ದ ರೀಸನ್ ಗಿವನ್ ಬೈ ದಿ ಟ್ರಯಲ್ ಕೋರ್ಟ್?
ಅಲ್ಲ, the court does not go into it on merits, my lords. It only decides it on the delay application.
Limitation ಮೇಲೆ ಕೊಟ್ಟಿದ್ದಾರೆ
ಅದೇ 210 days.
Whether it is correct or not will.
ಅದಕ್ಕೆ I produced documents.
Documents ಈಗೇನ್ ಬರೋದಿಲ್ಲ. ಕೆಳಗಡೆ ಕೋರ್ಟ್ ಅಲ್ಲಿ ಏನ್ ಕೊಟ್ಟಿದ್ರು?
ಅಲ್ಲ, the authorized signatory was in he had a brain stroke, my lords. Other the documents I produced it.
Case is made out by the petitioner for having taken any action against the advocate not having furnished the information of status of the case. Besides, no sufficient reasons are shown to condone the delay of 210 days. This regard also except serving statement, there is no supportive evidence placed. In the course of cross-examination of PW1 for the first time introduced an information that frequently his father falling ill. Therefore, he could not pursue the original suit. Pursue the original suit. In this regard also, PW1 admits that he has not produced any document to prove that his father was suffering from some ailments.
My lord, the father was the authorized signatory in the suit. He was the managing director of the appellant company.
What is the error in the reasoning in paragraph number 10?
Allah, I have produced those documents, my lords. If my lords.
Illen produce ಮಾಡೋದು ಬರೋದಿಲ್ರಿ.
Allah, this was because of the fact.
ಕೋರ್ಟ್ ಅಲ್ಲೇ ಕೊಡಬೇಕಿತ್ತು ನೀವು.
Allah, our time when we filed that appeal also, my lords, the in between also he was hospitalized, my lord. I produced those documents also. In that 210 days also there have been repeated hospitalizations, right? Right from 2013 to 2000 for the relevant period.
Sheet ಗಳು ಕೊಡಿ ಮೇಡಮ್.
IA 1 ಜೊತೆ ನಾನು ಪ್ರೊಡ್ಯೂಸ್ ಮಾಡಿದ್ದೀನಿ ಸರ್.
Why you have not produced these documents before the trial court?
My lords, these are all from the hospital, my lords. That was a lab. Literally, the difficulty is, my lords, the advocate stopped appearing, my lords. He did not communicate to the party also, my lords. If my lord sees, even the certified
trial court ಹೇಳಿದ್ದಾರೆ, what action you have taken against the advocate? ಇದೊಂದು
I cannot keep
ಬೇರೆ ಲಾಯರ್ ಮೇಲೆ ಇಲ್ಲಿ ಬಂದು ಅಲಿಗೇಷನ್ ಮಾಡೋದು.
That's what, my lords. I cannot keep filing cases against my own advocates.
Sir, the documents of the year 2018, why you have not placed these documents before the trial court?
ಅದಕ್ಕೆ, my lords, if my lord sees even the certified copy of the OS judgment, my lords, it is applied after a period of 5 months, my lords. The judgment is in July. Or apply ಮಾಡದೆ January ನಲ್ಲಿ. So the party doesn't even know that the matter is.
The appellant counsel seeks time and hence list these matters after winter vacation. ಎಲ್ಲಾನು ಡೇಟ್ ಹಾಕ್ಬಿಡಿ ಮೇಡಮ್.
8/1 my lords.
22, 23, 24, 25. All matters after winter vacation. ಬೇರೆದು ಇನ್ನೊಂದು ಯಾವ್ದಾದ್ರು ಡೇಟ್ ಕೊಟ್ಟಿದೀವಾ?
ಇಲ್ಲ, ಅದ್ರಲ್ಲಿ
ಕೊಟ್ಟಿಲ್ಲ. ಅದು after winter vacation ಆಗರ. 26 ವೆಂಕಟ ಸುಬ್ಬರಾವ್. Delay of 307 days in filing.
307 days.
Kurli N. Idara?
Take up on tomorrow. Take up on tomorrow, my lord.
ಸೀನಿಯರ್ ಡೆತ್ ಆಗಿ ಒಬ್ರು ಅಲ್ಲಿ ಹೋಗಿದ್ದಾರೆ ಸೀನಿಯರ್ ರಿಲೇಷನ್ ಡೆತ್ ಆಗಿ ಅಲ್ಲಿ ಹೋಗಿದ್ದಾರೆ ಕೆನ್ ಯು ಟೇಕ್ ಅಪ್ ಆನ್ ಟುಮಾರೋ ಮೇಲೆ ಕಾಪಿ ಸರ್ವ್ ಮಾಡಿದೀವಿ ಅದೇ ಸೈಡ್ ಎಲ್ಲಾನು
ಯಾರು ಬಂದಿದಾರಲ್ಲ ಅಡ್ವೊಕೇಟ್ ಮುರಳಿ ಅಂತ
ಬಂದಿದೆ
ಪಾರ್ಟಿ ಹೆಸರು ಇದು ಅಡ್ವೊಕೇಟ್ ಮೇಡಮ್ ಅಡ್ವೊಕೇಟ್ ನೋಡಿ ಅಪಲೆಂಟ್ ಕೌನ್ಸಿಲ್ ಪ್ರೆಸೆಂಟ್ ಅಂಡ್ ಕೌನ್ಸಿಲ್ ಫಾರ್ ರೆಸ್ಪಾಂಡೆಂಟ್ is absent and also not filed any objections to IA 1/24 since there is a delay of 307. However, in the ends of justice, 2 weeks time granted to file objections to IA 1/24. If objections not filed within 2 weeks, it will be taken as no objections to IA 1/24. List this matter immediately after winter vacation.
ಡೇಟ್ ಬಿಗ್
After winter vacation, ನಾನು ಡೇಟ್ ಕೊಡೋದಿಲ್ಲ, ಮೂವ್ ಮಾಡ್ಕೋಬಹುದು.
ಇದರಲ್ಲಿ 2-3 ಸತಿ ಅಬ್ಜೆಕ್ಷನ್ ಟೈಮ್ ತಗೊಂಡಿದ್ರು ಅವ್ರು ಹಾಕಿಲ್ಲ ಸೊ
ಆರ್ಡರ್ ಶೀಟ್ ಇದೆಯಾ ನೋಡಿ ಮೇಡಮ್, ಹಿಂದೆ ಏನಾದ್ರು ಬಂದು ಅಬ್ಜೆಕ್ಷನ್ಸ್ ಹಾಕಿಲ್ಲ ಅಂತ ಏನಾದ್ರು
ಕಾಪಿ ಸರ್ವ್ ಮಾಡಿದ್ದೆ ಸಬ್ಮಿಷನ್ ಮಾಡಿದ ಅಬ್ಜೆಕ್ಷನ್ ಆಗ್ತದೆ ಅಂತ ಮಾಡಿಲ್ಲ
ಹಿಂದಿನ ಡೇಟ್ ಕೊಡಿ, ಆರ್ಡರ್ ಶೀಟ್ ಕೊಡಿ. Statement ಇಲ್ಲ, learned counsel for the appellant has filed statement of objections and copies also served.
ಫಿನಿಶ್ ಮಾಡಿದ್ವಿ
ಏನ್ ಸ್ಟೇಟ್ಮೆಂಟ್ ಆಫ್ ಅಬ್ಜೆಕ್ಷನ್ಸ್ ಅವ್ರೇನಾರ ರೈ ಹಾಕಿದಾರ?
Appear for the respondent.
ಹುರುಳಿ ನೀವೇನ್ರಿ? ಹಾ
But I filed my statement of objection.
ಹಾಕಿದಿರಾ?
ಹಾಕಿದ್ದೀನಿ.
Statement of objections IA 108 filed by the advocate for respondent ಇದೆಯಲ್ಲ ಮೇಡಮ್ ಇಲ್ಲಿ.
Copy served to him.
ಕಾಪಿ ಕೊಟ್ಟು ಸರ್ವ್ ಆಗಿದೆ ಆಗಿದೆ ಸರ್ವ್ ಆಗಿದೆ
IA 1/23 also filed by the advocate for respondent. 1/23 for
So far
TI.
as the delay application is concerned.
ಎರಡಕ್ಕೂ ಹಾಕಿದಾರಲ್ಲ ಅಬ್ಜೆಕ್ಷನ್, ಸ್ಟೇಟ್ಮೆಂಟ್ ಆಫ್ ಅಬ್ಜೆಕ್ಷನ್ಸ್ ಇದೆಯಲ್ಲ ಎರಡರಲ್ಲೂ. ಮತ್ತೇನ್ ಫೈಲಿಂಗ್ ಅಬ್ಜೆಕ್ಷನ್ಸ್ ಏನಿಲ್ಲ, ಹೇಳಿ ಏನ್
28 ಮೇಡಮ್
ತೋಳಿ ಅಪಲೆಂಟ್ ಕೌನ್ಸಿಲ್ seeks time to address arguments.
28
ಅಡ್ಮಿಷನ್ ಇದೆ ಅಲ್ವಾ ಇದು?
ಅಡ್ಮಿಷನ್ ಮೇಡಮ್
ಹಾ
ಜೆನ್ಸಿಸ್ ಬಂದು ಇವತ್ತು ಸೀನಿಯರ್ ಡಿರ್ತಾ ಅಂತ ಅಲ್ಲಿ ಹೋಗಿದ್ದಾರೆ ಹಾಗಾಗಿ ಬರಕ್ಕಾಗಲಿಲ್ಲ ಸೀನಿಯರ್.
But this is the second round of litigation. Second round of litigation, of course, I am not the party here. ಮುಂಚೆ ಒಂದು ಸೂಟ್ ಹಾಕಿದ್ದಾರೆ and they implead the private.
ಆಯ್ತು, ಟೈಮ್ ಕೇಳ್ತಾರ ನೋಡೋಣ.
Please
ಅಪಲೆಂಟ್
note.
ಕೌನ್ಸಿಲ್
ಸ್ಟಾರ್ಟ್ ಡೇಟ್
seeks time on the ground that ಏನು ಎಲ್ಲಿ ಡೆತ್ ಯಾರು?
ಮಧುಗಿರಿ ರಿಲೇಷನ್ ಡೆತ್ ಆಗಿದ್ದಾರೆ ಅಲ್ಲಿ ಹೋಗಿದ್ದಾರೆ ಮೇಡಮ್. ನಾಳೆ ಆದ ನಾಳೆನೇ ಮಾಡ್ತೀನಿ
ಸೀನಿಯರ್ ಕೌನ್ಸಿಲ್ ರಿಲೇಟಿವ್ ಪಾಸ್ಟ್ away went to cremation.
10th or 12th.
And hence list this matter next week ಅಲ್ಲಿ ಯಾವಾಗ್ಲಾರು ಕೊಡಿ ಮೇಡಮ್.
10th or 12th.
13 12
13 ಮೇಡಮ್ 13 ಇನ್ಕಮ್ ಇಸ್ 14th or 10 or 14.
14 is holiday. 14 ರಜೆ.
After winter vacation?
Urgency yes. Urgency yes.
Matter may be posted for final hearing. It requires. The short question, my lord, is.
Admission ಗೆ ಬಂದ್ರೆ ಫೈನಲ್ ಹಿಯರಿಂಗ್.
ಅಲ್ಲ, my respectful submission, my lord.
Admission ಗೆ ಬಂದ್ರೆ ಫೈನಲ್ ಹಿಯರಿಂಗ್ ಮಾಡೋದ್ರಿ. List this matter on 16/12.
Much obliged.
28 ಇಲ್ವಾ? Section 9.
They appear for the appellant. Lord, I have not received full instructions for time breaks.
MS Rajendra, Vineet Reddy for KVATR. ಏನ್ರಿ?
I am for the respondent.
Last time ಆರ್ಡರ್ ಶೀಟ್ ಕೊಡಿ ಮೇಡಮ್.
Last time ಅದು ವಕಾಲತ್ ಹಾಕಿ
9 ಅಲೋ ಆಗಿದೆ. within 90 days ಅಂತ.
ವಕಾಲತ್ ಹಾಕಿದೀನಿ.
ಅಪ್ಲೆಂಟ್ ಕೌನ್ಸಿಲ್ ವಿಪಿನ್ ಹೆಗಡೆ seeks time on the ground that he has received NOC ವಕಾಲತ್. ಇವತ್ತೇನು?
ಇವತ್ತು ಇನ್ನೂ ಇನ್ಸ್ಟ್ರಕ್ಷನ್ಸ್ ಫುಲ್ ಬಂದಿಲ್ಲ.
ಬಂತು ಅಂದ್ರೆ ಅದು ವಿತ್ ಇನ್ಸ್ಟ್ರಕ್ಷನ್ಸ್.
ಇನ್ಸ್ಟ್ರಕ್ಷನ್ಸ್ ಬಂದಿಲ್ಲ.
Appellant counsel again seeks time. List this matter after winter vacation. Counsel for the respondent also present ಅಂದ್ಬಿಡಿ. JB Sastri.
Hearing for respondents.
Mohan R. Last time new time ಕೇಳಿದ್ರಿ. ಈ ಸರಿ ಅವ್ರು ಇಲ್ವಾ?
ಇಲ್ಲ.
Order 9 Rule 13. Respondent seeks time. Learned counsel appellant says no objection. Third, appellant counsel is absent. Counsel for respondent present. List after vacation. Winter vacation.
Grateful.
My lord, in this case, I'm
Kavita T.
Respond number 6 and 7.
HM Murlidhar.
Pray time to
I
file
file an-
statement of objection.
no, my lord, here
ಏನಕ್ಕೆ objection ರೀ?
objection.
IA objection.
They are later, my lord.
Main disposal ಹೇಳಿ ಏನು?
Pray time, my lords. ಇವತ್ತು senior ಇಲ್ಲ ಸ್ವಾಮಿ.
My lord, in
Next
this
week
case,
ಅಲ್ಲಿ
my
ಯಾವಾಗಾರ
lord,
ಹಾಕೋಬಹುದು ಸ್ವಾಮಿ.
in this case, I filed an IA for status quo to be continued, my lord, as per the trial court.
ಟ್ರಯಲ್ ಕೋರ್ಟ್ ಅಲ್ಲಿ ನಾಟ್ ಎಲಿಮಿನೇಟ್ ಮಾಡಿದಾರಲ್ಲ.
No, my lord, that
Not really,
order
like-
has been modified.
B schedule property ಏನೋ ಮಾಡಿದಾರೆ.
B schedule. That status quo may be continued, my lord.
Allowed in part modifying vacate the possession.
Possession of B schedule. On that basis, my lord, they are encroaching the B schedule property. That status quo may be continued, my lord, till the disposal of the.
Earlier entry ಮಾಡಿರ್ತಾ?
Itu ಇಲ್ಲ
ಪರವಾಗಿ-
ಇದು ಸ್ವಾಮಿ ಅದು
No, my lord.
modify
In,
ಮಾಡಿ.
in trial court, it was there from 23/1/24.
B schedule property ಮಾತ್ರ ಮಾಡಿದಾರೆ.
ಹೌದು ಸ್ವಾಮಿ.
IA 3 ಅದು ಕೂಡ allowed in part.
Allowed in part.
Modified and modified and vacated insofar as possession is concerned. Possession ಗೆ vacate ಮಾಡಿದ್ದಾರೆ.
Possession, we were in possession, my lord, that has been vacated, that has been challenged here, my lord.
ಇಲ್ಲ ಸ್ವಾಮಿ, we are in
Because,
possession, my lords.
no,
We are
my
the
lord.
buyers,
Let-
ಸ್ವಾಮಿ.
I'll-
They are the
let them prove
developers,
it.
ಸ್ವಾಮಿ. Our developers, ನಾವು buyers, ಸ್ವಾಮಿ.
After,
ಅವ್ರಿಗೂ ಲ್ಯಾಂಡ್ ಓನರ್ಸ್ಗೂ
Ready ಇದೀರೇನ್ರಿ ಹಿಯರ್ ಮಾಡೋಣ ಏನು?
ಇಲ್ಲ ಸ್ವಾಮಿ, next.
after obtaining orders
After,
in a WP, they are encroaching the scheduled property yesterday, my lord. That again, they are telling false submission before the
ನೋಡಿ, counsel
court.
for respondent seeks time. ನೀವು KVT R6 R7 ನಿಮ್
ಹೌದು
ಮಾತ್ರನಾ?
ಹಾ, ನಮ್ದು ಇದೆ ಸ್ವಾಮಿ. We are the
ಬೇರೆಯವ್ರ ಮೇಲೆ ಪ್ರೇಯರ್ ಇಲ್ವಾ ಮೇಡಮ್?
ಬೇರೆಯವ್ರ ಮೇಲೆ ಏನಿಲ್ಲ
ಹಾ?
ಸ್ವಾಮಿ, ಏನಿಲ್ಲ. ಬಟ್ ಇಲ್ಲ ಸ್ವಾಮಿ, ನಮ್ ಪ್ರೇಯರ್ ಎಲ್ಲಾರ ಮೇಲೂ ಇದೆ ಸ್ವಾಮಿ. R2 to R7.
ನೋಟಿಸ್ ತಗೋಬೇಕಲ್ಲ ಮೇಡಮ್
Notice
ಬೇರೆಯವ್ರ
ತಗೊಳ್ತೀನಿ
ಮೇಲೆ.
ಸ್ವಾಮಿ. ಹ್ಮ್.
Appellant counsel is directed to serve the copy of the appeal memo on the counsel who appeared on behalf of other respondents who
I'll
have
take-
who have
to-
contested the IA number 1 and IA number 3 before the trial court.
Take
ಯಾರು
such
contest
time,
ಮಾಡಿದಾರೆ ಅವ್ರಿಗೆ ಮಾತ್ರ ತಗೊಳ್ಳಿ.
take
List
such
and
time that
counsel
you-
for the R6 and R7 also seeks time. This matter on
My lord, till such time that status quo may be continued, my
Date
lord.
mention
Otherwise,
again.
they'll encroach the property, my lord, with the
Ah.
police protection.
police protection order ಆಗಿದೆಯಾ?
ಆಗಿದೆ
My
ಸ್ವಾಮಿ.
lord, they have
We have,
obtained,
we have,
oh, they have obtained the order in WP 21412, my lord. As per that, they have entered, extended. We have stopped.
ಆ WP ಆರ್ಡರ್ ನೀವು ಚಾಲೆಂಜ್ ಮಾಡ್ಬೇಕು ಅಷ್ಟೇ.
I have filed appeal, my lord.
ಅಷ್ಟೇ.
No, here, because of that status quo modify.
ಆರ್ಡರ್ ನೀವು ಚಾಲೆಂಜ್ ಮಾಡೋದಲ್ಲ ಈ ಕೋರ್ಟ್ ಅಲ್ಲಿ ಹೆಂಗೆ?
No, no, I am not seeking any relief on that order, my lord.
ಪೊಲೀಸ್
Here,
ಪ್ರೊಟೆಕ್ಷನ್ ಮೇಲೆನೇ ನೀವು ಕೇಳ್ತಿರೋದಲ್ವಾ?
no, here only that order on status quo, my lord.
ಸ್ಟೇಟಸ್
that has-
ಆದ್ರೆ ಆಟೋಮೆಟಿಕ್ ಆಗಿ ಆರ್ಡರ್ ಇಟ್ ಬಿಕಮ್ಸ್ ಇನ್ಫ್ರಕ್ಷಿಯಸ್ ಅಲ್ಲೇನ್ರಿ? ರಿಟಲ್ ಪಾಸ್ ಆಗಿರೋ ಆರ್ಡರ್.
ಹೌದು ಸ್ವಾಮಿ.
ಮತ್ತೆ
No, because,
ಟ್ರೈ ಟು ಮಿಸ್ಲೀಡ್ ದಿ ಕೋರ್ಟ್.
no, no, my lord,
ಮತ್ತೆ?
I'm not doing that.
If
my
this
lord.
court grants the status quo, automatically the order
Trial
passed in
court
the
order
writ
may be
petition,
continued.
writ petition will become infructuous, is it not?
Yes, my lord.
Then you pursue the remedy in the writ appeal,
Yes, my lord.
alva? Don't try to mislead the court and get an order.
No, my lord, because of that writ petition order, they are
This
encroaching with the
matter
police
16,
protection.
12 pursue ಮಾಡಿ remedy ಅಲ್ಲಿ
Please,
writ
my
appeal
lord.
ಅಲ್ಲಿ.
Chocolate.
ಬರೀ ಇಂಥದ್ದೇ ಬೆಳಗ್ಗೆ ಎದ್ದು ನೋಡೋದು ಇಂಥದ್ದೇ ಬರೀ ನಾವು. Murtuza Ali Beg.
This case I appear for
1
the
2 3 dismiss
the
care
petitioner
Krishnamurthy
counsel,
for
Your Lordship.
R3.
My appeal before the court. The
ಇದ್ರಲ್ಲಿ
plaintiff's appeal, my lord.
ಇದರಲ್ಲಿ ರಿಲೀಫ್ ನೀವು ಯಾರಿಗೆ ಕೇಳ್ತಾ ಇದ್ರಿ? ಅಗೇನ್ಸ್ಟ್ ಬೇರೆಯವ್ರಿಗಿಲ್ವಾ?
Only 3 to 6 only I am confined to the relief against the,
R 3 to 6
yes.
3 to 6 ಯಾರು
3
ಅಪಿಯರ್
to 6
ಆಗಿದಾರಾ?
are by virtue of a joint development agreement, they are
3
developing
to
the
6
property.
I am appearing.
ನೀವು ಅಪಿಯರ್ಸ್ ಓನ್ಲಿ ಫಾರ್ 3 ನಾ?
3, 4 and 6 are along with me.
ಹಾ.
Common statement was filed. I have already filed the counter also here.
ಹಾ.
My learned friend, if argues, I am ready.
4 ಗೂ 4 to
ಅವ್ರಿಗೂ
6
ಅಲ್ಲೂ ವಕಾಲತ್ ಹಾಕಿದ್ದೀನಿ. ಇಲ್ಲಿ ಸಿಕ್ಲಿಲ್ಲ, ಅವ್ರು ವಕಾಲತ್ ಹಾಕಿಲ್ಲ.
ಈಗ ಏನ್ ಮಾಡ್ತೀರಿ ಹೇಳಿ? ಅವ್ರು ರಿಲೀಫ್ ಕೇಳ್ತಾ ಇದಾರಲ್ಲ ನಿಮ್ಮ ಮೇಲೂನುವೆ.
ಹೌದು, ಅಲ್ಲ ಅವ್ರು ಆರ್ಗ್ಯೂಮೆಂಟ್ ಮಾಡ್ಲಿ, ನಾನು ಆರ್ಗ್ಯೂ
ಅಂಡರ್ಟೇಕ್ ಮಾಡ್ಕೊಳಂಗಿದ್ರೆ
I will undertake.
ತಗೊಳ್ಳಿ. ಕೌನ್ಸಿಲ್ KR Krishnamurthy undertakes to file ವಕಾಲತ್ ಫಾರ್ R 4 to 6. ಹಾ ಹೇಳಿ, ಏನ್ ಹೇಳ್ತೀರಾ?
This is a plaintiff's appeal, my lord. The court below, trial court, the learned judge has rejected an order. The order at annexure page 24, my lord, annexure A. The suit is one for a partition and a separate possession and for a consequential relief of an injunction. Your lordship may kindly appreciate the scheduled property in question. I'll take my lord to the first instance, the genealogical tree of the relationship of the parties. May I request page 85 is the relevant page. 85, my lord. Genealogical tree. Now your lordship may kindly, the fourth, Indrajit Gorpade and wife of the next, Sarvajit and the Partha. They are the present plaintiff before this court. Your lordship may kindly see the
Actually, who is the plaintiff?
the Sarvajit
Gorpade.
and Partha. Yes, Sarvajit Gorpade and they are the present plaintiff. Partha Gorpade are the present plaintiff before the court below. Your lordship may kindly.
These two are the plaintiffs.
Yes, yes.
Then who are the defendants?
Defendants are all the, your lordship, the first defendant is the father, the Indrajit Gorpade. That is his father. Your lordship may kindly, as on the date of the legal position, my lord, the position of law involved in this case is whether the ancestral proprietary property or not. That your lordship may kindly appreciate the dates are relevant, my lord. 12/3/1956. There was by virtue of a registered sale deed, the present, the great grandfather great grandfather, that is, your lordship purchases the property. One is Bujanga Yashwanta Gorpade. Is a great grandfather, my lord. And the Dattatreya Bhujangra Gorpade jointly purchases an extent of 21 acres, 15 guntas in survey number 109. Your Lakshmi kindly on 3/6/1966, great grandfather Bhujanga Yashwant Gorpade was passed away and died on the that is date is relevant 3/6/1966. Your Lakshmi kindly will is created, will has been because this
One of the giant purchaser passed away.
passed away. Exactly, madam. Your Lordship kindly on 28/1/2008. This is
You
relevant.
said will andre, yaar will execute.
Will that has been Dattaji Rao Bhujangrao Gorpade. That is a great grandfather.
On what date?
And to 28/1/2008. 28/1/2008.
2008.
8. 2008 ಮೇಲೆ.
But ಇವನೇನ ಸತ್ತೋಗಿರೋದು 3/6/66.
66 ಸತ್ತಿರೋದು ಅವ್ರ ಗ್ರೇಟ್ ಗ್ರ್ಯಾಂಡ್ ಫಾದರ್.
Great grandfather.
ಗ್ರೇಟ್ ದಟ್ ಇಸ್ ಭುಜಂಗರಾವ್ ಯಶವಂತರಾವ್ ಗೋರ್ಪಡೆ.
ಅವ್ನು ಸತ್ತೋದ.
ಹೌದು 66 ಸತ್ರು.
ಆಯ್ತು.
Your Lordship kindly by virtue of this will, the creates the share was allocated. If your Lordship were to kindly may request trouble my lord to for a genealogical tree, that is a I'll refer page 85. The except the 1 and 3 they are eliminates. He gives the property, he creates a will bequeath the property in favor of second, fourth and fifth. A schedule is given to second son. B schedule is given to fourth son. C schedule is given to third son. The present plaintiffs are the sons of the Indrajit Gorpade, that is the third son, my lord. I'll take my lord to the schedule kindly for a minute. The sale deed that is been your lordship kindly for a sale deed I'll show my lord. I produce the sale deed also that has been 91 man. Schedule your lordship kindly. C schedule is bequeathed in favor of the present in favor of the
ABC.
Yeah, that is a C. All the piece and parcel of the dry land bearing survey number 109(1)(B). This was the 2 acres, 24 guntas that has been bequeathed in favor of the first defendant. This was by virtue of a registered will. Your Lordship kindly now I'll the copy of the yes. Your Lordship kindly page 95 may be kindly be taken. Your Lordship 3 acres. Kindly, your Lordship, 90 finally. Survey number 109/2, C schedule, 3 acres, 3 guntas, and 2, that is a Gorpade, that is 109 These are the two things. Your Lordship, kindly, now by virtue of the, in 28/5/2010, this is date is relevant, my lord. 28/5/2010, Dattaji Rao Bhujan, that is a Gorpade, was passed away. That is the great grandfather was passed away. That is the first defendant father was passed away. Now, as on the date, your Lordship kindly, as on the date of the will, that is on 28/1/2008, it is an ancestral coparcenary property. For all purpose, there the present plaintiffs are warrant. That's why now the learned judge, now may request the parent, the learned judge given a finding, but I'll take my lord to the page 30 of the order of the learned judge. The relevant the reasons assigned by the learned judge is, your Lordship kindly, I'll request my lord to the paragraph 7, page 31. It is important to note that the plaintiff have filed the suit for a partition and for a separate possession for their 1/3 share each in the scheduled property. The devolution of the property in the hands of plaintiff and the adjudication of the nature of the property is a matter of trial. Admittedly, defendant one has sold the scheduled property in favor of the defendants. However, it is pertinent to note that the property sold in favor of the defendants also involve the share of the defendants one, as there is no demarcation of the property pertaining to the defendant one. That is, in which part of the defendants have purchased this by this court at the initial stage cannot come to a conclusion that the defendant should be restrained from interfering with the possession of the plaintiff. The possession of the plaintiff at this stage is not definite and it constrains the court to grant any temporary injunction to restrain the defendants from interfering with the plaintiff peaceful possession and enjoyment of scheduled property. Further, the plaintiff seeks the indulgence of this court to restrain the defendant from putting up construction and also restrain them from alienating the suit scheduled property. It is the case of the plaintiff that the suit scheduled property is a vacant property, while the defendants have categorically stated that defendants have built up a villas and multi-story building. In this regard, in order to substantiate the same, the defendants have furnished the photographs. Photographs have been defendants is not disputed this by the plaintiff, and it's not the case of the plaintiff that photographs do not pertain to the suit scheduled property. Therefore, it is clear indication of the property is vacant land and the buildings have come up. And in certain case, substantial magnitude of construction completed by the defendant by investing huge amount. The judgments relied upon relied upon by the plaintiffs and are relating to concept of proportionary property. However, in order to ascertain proportionaryship, the properties have to undergo trial. At this stage, without evidence, this court cannot draw a line that the suit scheduled property is ancestral and proportionary property, and therefore the decision relied upon by the learned advocate for the plaintiff cannot come in at the aid of the plaintiffs at the inception. The right of the plaintiffs, your lordship may kindly appreciate. The right of the plaintiff, their share, ETC had to be adjudicated based on a material that will be placed on record, whether the suit scheduled property is a proportionary property, is a matter of trial. Since the devolution of the interest is involved, and as the defendant one has acquired the scheduled property by virtue of the will executed by his father, at this stage, it is the duty of this court to decide as to the nature of the property in the hands of plaintiff, also for their entitlement. Therefore, this court is of the opinion that a full dress trial is required. Hence, the plaintiff has not made out a prima facie case and an all application. Since the defendants have invested huge amount in the development and construction in the scheduled property, comparative hardship is caused to the defendants rather to plaintiff for a reason. Plaintiff has succeeded in the truth. In addition to say, the plaintiff have a sufficient to prove the scheduled property is a proprietary property. My submission is, Your Lordship, I am relying upon the three judgments of the Supreme Court. Your Lordship, kindly appreciate whether, as on the date of the filing of the suit, whether it is an ancestral proportionary property. At the first judgment, I am relying upon paragraph 9. Your Lordship, kindly the paragraph 9 may be kindly be. We respectfully agree with the view observation of this court. In Vasant's case, the joint family property does not cease to be a joint family property when it passes to the hands of a sole surviving co-partner. If a son is born to the sole surviving co-partner, the said property becomes the joint family property in the hands of in his hands and in the hands of his son. The only difference between the right of a manager of a Hindu joint family and over the joint family property is where there are two or more co-partners, and the right of the sole surviving co-partner in respect of the joint family is that. Next judgment, my lord, Your Lordship, kindly 2013, that is a paragraph. This is the relevant paragraphs, my lord. I'll take my lord to the relevant. The first that is in beginning held as next. Your Lordship, kindly for a
paragraph.
Para 11. Para 11 of 2013, part 9, SEC 419. Para 11, madam. We have bestowed our consideration to the rival submission. We find a substance in the submission of Mr. Rao. In our opinion, co-partnership property means the property which consists of an ancestral property, and a co-partner would mean a person who shares equally with the others in the inheritance in the estate common ancestor. Co-partner is a narrower body than the joint Hindu family. And before commencement of the Hindu Succession Act Amendment of 2005, only male members of the family used to acquire by birth on an interest in the co-partnership property. A co-partner has no definite share in the co-partnership property, but he has an undivided interest in it, and one has to bear in mind, and it enlarges by deaths and diminishes by births in the family. It is not static, Your Lordship may kindly appreciate. We are of the further opinion that so long on a partition and an ancestral property remains in the hands of a single person, it had to be treated as a separate property, and such a person shall be entitled to dispose of the co-partnership property, treating it to be a separate property. But if a son is subsequently born, the alienation made before the birth cannot be questioned. But the moment a son is born, the property becomes a co-partnership property, and the son would acquire the interest in that, become a co-partner. Your Lordship, further paragraph 14. A person, Your Lordship, may kindly, the person who for the time being is the sole surviving co-partner in the present case, that is that, and the co-partnership property as it were is a separate Gulab Singh till the birth and then facts and also. But in the present case, it is an admitted position that the property which defendant number 2 got as a partition was an ancestral property until the birth of the plaintiff. He was the sole surviving co-partner. But the moment plaintiff was born, he got a share in the father's property and became a co-partner. As observed earlier view, settled legal position, the property in the hands of defendant to allotted to him in a partition was a separate property till the birth of the plaintiff. And therefore, after his birth, defendant too could have alienated the property only as a karta for a legal necessity. It is nobody's case. The defendant too executed a sale deed and released as a karta for legal necessity. Hence, the sale deed and the release deeds of the thing to an extent of entire co-partnership was illegal and null and void. And one more judgment, recent judgment, 2018 Part 7, SEC, my lord. So, last may kindly, para 12. Your last may request, my lord, paragraph 12 of the 2018 Part 7 of the judgment. It is settled that a property inherited by a male Hindu from his father's father is an ancestral property. The essential future of an ancestral property, according to Mitaksara law, is the sons, grandsons, and great-grandsons of the person who inherits it acquire an interest and the rights attached to such property at the moment of their birth. The share which a co-partner obtains in a partition, the ancestral property, as regards its male issue. After a partition, the property in the hands of the son will continue to be ancestral property, and the natural and the adopted son of the son will take the interest in it. It is entitled to a survivorship. And your paragraph 15 of the same judgment. The contention was raised by defendant, and after the Hindu joint family, the land allotted to share defendant became the self-acquired property, and he was competent to transfer the property in the manner desired. It was held that a property which defendant got by virtue of partition decree amounts his father and father's a separate property other than the relation, but it attains a characteristic of the co-partnership property the moment a son was born to defendant too. It was further paragraph 16, my lord. This is the paragraph 60. Therefore, the properties acquired by the defendant in a partition, although they are separate properties, other relation, but it is a co-partnership property. In so far as sons and the grandsons are concerned, in the instant case, there is a clear finding of the trial court that properties are ancestral property which have been divided as per the deed of partition of the property which had been fallen to the share of defendant to retain the characteristics of the co-partnership property, and plaintiff being his sons and grandsons have a right to this said property. Hence, it cannot be said that the suit filed by the plaintiff was not maintained. My submission is this manner. You will actually kindly appreciate here in a facts and learned judge now, and it is an undisputed fact, as on that now here, my lord, the plaintiffs, the moment the plaintiffs were born, that is a ancestral co-partnership property, they have got a share. The father alone, now I question the legality of the correctness of the sale deed executed by the first defendant, and relating to the that is dated 10/2/2016, my lord. The sale deed of the first defendant executes in favor of the present contesting respondent, that is the contesting parties, that is the 3 to 6. That is sale deed is produced at annexure K, page 96, my lord. Page 96 may be kindly be seen. This is the sale deed. My prayer in the plaint may be kindly be seen, my lord. Your lordship may kindly, what I try to pursue, my lord, is here. Now, prayer in the plaint is, your lordship, now I'll request my lord to the prayer, the relief sought in the plaint before the court below is page 44. Wherefore the plaintiff prays this honorable court be pleased to pass a judgment and decree for a partition and a separate possession of the plaintiff, 1/3 share each of our scheduled property by metes and bounds, and put them in a separate possession of the shares. Declaring the sale deed dated 10/2/2016, that had been in the office, that had been defined 3 to 6, in so far as the scheduled property is illegal, void and fraudulent and not binding on the plaintiff. Third relief, declaring the agreement of sale dated 6/8/2014, that is illegal, and the conduct an inquiry. Now my relief before this honorable court by filing an application order 39 rule, only I am confining to not to alienate the property and let them not reserve, there is the entire property, they are under a process construction of villas. That according to them, they invested so many crores. And now there is a, let there be, my share is definite because it is an ancestral compulsory property as on the date of filing the suit. That is my submission. I am entitled for equitable relief, and let them not alienate the property and to create a third party's interest. That's my submission.
My lord, the entire suit is misconceived, in fact. The reason is, kindly see they have produced the family tree along with a separate memo on 28/10/24. Produce what is it, sir?
Along with the memo, appeal memo.
28/10.
28. ನನ್ನ ಕಾಪಿ ಕೊಟ್ಟಿದ್ದಾರೆ.
28/10 ಅನ್ನೋ ಒಂದು ಹಾಕಿದ್ದಾರೆ ಸರ್ ಡಾಕ್ಯುಮೆಂಟ್ಸ್.
ವಂಶವೃಕ್ಷ
ಭುಜಂಗರಾವ್
ಯಶವಂತರಾವ್ ಗೋರ್ಪಡೆ, ತಾರಾಬಾಯಿ. ಭುಜಂಗರಾವ್ ಒಬ್ಬರೇ ಮಗ ದತ್ತೋಜಿರಾವ್ ಭುಜಂಗರಾವ್ ಗೋರ್ಪಡೆ and his wife is Chandravati Dattojirao Gorpade. All are not alive now. And this Dattojirao has got 5 children. One is Kumar Gorpade, Pratap Gorpade, Lalita Gorpade, Indrajit Gorpade. He is the defendant number 1 before your lordship now. I mean, respondent number 1 before your lordship. And Shailendra Gorpade. And they have got 2 children. They are totally 5 children. Totally 5 children. Now, kindly see para 4 of the plaint which they have produced. Now here succession has happened under section 8, not under section 6. So therefore, none of these judgments, though principle is nobody can this one, but that is under section 6, not under section 8. Now, lordship, kindly see para 4 of the plaint. May I read only some lines in that. The plaintiff submits that portion of paragraph 4. Plaintiff submits that a portion of land in survey number 109, Dodgobi village, Bedralli Hobli, Bangalore South Taluk, measuring 21 acre 15 guntas, was purchased jointly by Bhujangrao Yashwantrao Gorpade and Dattajirao Bhujangrao Gorpade. Father and son jointly purchased. They are not the brothers. Under sale deed dated 12/3/1956. The said land was ported and assigned survey number 109/1 by revenue authorities. Bhujangrao Yashwantrao Gorpade died intestate on 3/6/1966. Now, succession happened insofar as his share is concerned under section 8, not under section 6. That I will point out from section 8 by reading that section. The entire property measuring 21 acre 15 guntas was inherited by only son and co-owner Dattajirao Bhujangrao Gorpade. Accordingly, the Katawar property was mutated in his name. Dattajirao Bhujangrao Gorpade, during his lifetime, sold the land measuring 13 acres 24 guntas in 109/1 and retained the extent of 7 acre 31 and 3/4 guntas in survey number 109/1. Dattojirao Bhujangrao Gorpade also owned adjoining land measuring 19 guntas in survey number 15, situated at Dodgobi village, Bidralli Hobli, Bangalore South Taluk. This land measures 7 acres 31 guntas. 3/4 guntas was assigned new number 109/1A and subsequently assigned 109/1A2. Dattojirao Bhujangrao Gorpade got the portion of the land in 7 acres and 109/1A2 situated Dodgobi village, so and so. This is the subject matter of sale in my favor. Now, your lordship may kindly see the parties in this suit. The Indrajit Gorpade is the father of this plaintiff. Then the Metrocorp is a agreement holder from Indrajit Gorpade and his brothers Kumar Gorpade, Shailendra Gorpade, and sisters, all this one. Then this Metrocorp failed to purchase the whole property. Then this VDB infra-reality and one portion was purchased by VDB infra-reality and another 2 portion was purchased by Anand Pramod, Pradeep Roy and Veluswamy together. totally makes 7 acre, 31.5 guntas, though that 15 guntas as well as this one. That is the under one sale deed, they have purchased the entire property. Now, the entire purchase is made not only from Indrajit Gorpade, also from his brothers, Shailendra Gorpade and other things. Now, they talk about the will. There is no dispute about the para 6, kindly see the para 6. Para 5 and 6. The plaintiff submits that Dattojirao Bhujangrao Gorpade, through a registered will dated 28/1/2008, registered in the office of Senior Sub-Registrar, Bomnalli, so and so, above landed property bearing 101 in favor of 3 sons, Pratap D. Gorpade, Shailendra D. Gorpade, and Indrajit Gorpade, by describing A, B, and C schedule properties respectively. Now, this suit is in respect of this C schedule property. Whatever under the will father has got for that, father has already sold it. Now, only question remains is whether this father has got an absolute right or he has got a limited right, or his right is shared with these children. Now, kindly see section 8 of Hindu Succession Act.
General succession in case of male Hindu.
Male Hindu. Now there is no dispute, even according to the plaintiff, that the property was belonging to this Dattajirao Gorpade, because he is the only son. He succeeded to the estate of his father, being the sole surviving legal heir, and he's become the absolute owner. Then he executed a will in favor of his children. Now, under the will, this father has sold its property to me. So, on the prima facie case, insofar as the prima facie case is concerned, now section 8 applies, not the section 6. Now, when section 8 applies, then all these decisions may not be relevant. On the other hand, there is a Supreme Court
Who
judgment.
executed the will actually?
Father.
Dattatreya.
Dattatreya Bhujangrao.
He is also one of the purchaser along with the father.
Father. Father. 50% ಅವರದ್ದಿತ್ತು. Father's 50% ಇತ್ತು. Father's 50% being the sole surviving, he has succeeded. Father's 50% ಗೆ. Now entire 100% he is the absolute owner. Father. Now father executed the will. There is no dispute about the will. Now under the will, ABC schedule was made and he distributed on the, it is kind of a settlement between the children, which he has entitled.
Different number 3 to 6. I had purchased the property from whom?
From Indrajit Gorpade as well as in Vamsharukshal, our brother, sister.
Dattatreya maga.
Haudu.
Hauda?
Haudu.
Indrajit Gorpade.
Haudu.
Haudala?
Haudu. So Indrajit Gorpade mattu our brother, Shailendra Gorpade, Kumar Gorpade, Vamsharukshal ತೋರಿಸಿರೋದು ಅವರೆಲ್ಲರಿಂದ ಪರ್ಚೇಸ್ ಮಾಡಿದ್ರು.
ಅದೇ ABC ಇದೆ.
ABC entire ABC property na ಎಲ್ಲರಿಂದ ಪರ್ಚೇಸ್ ಮಾಡಿದ್ರು.
3 C ನುವೆ.
ಹೌದು.
ABC ನುವೆ.
Common sale deed which they have produced, in fact. The sale deed is produced at annexure.
Annexure. That has been
96, page 96, annexure K.
ಇಲ್ಲಿ by inheritance ಅಂತಾನು ಮೆನ್ಷನ್ ಮಾಡ್ತಾರೆ. Page at
They might have used some this one. Now law is applicable because there is no dispute, there is no quarrel, and that is the fact. Even I am saying the same thing. Indrajit Gorpade is the his father was the absolute owner, and his father purchased the property along with his father, that is grandfather of Indrajit Gorpade.
Now whether at the time of disposal at the hands of Dattatreya,
yes,
whether the children are born or not.
No, the Datta
Indrajit ಅವರೆಲ್ಲ ಅವಾಗ ಹುಟ್ಟಿದ್ರ ಇಲ್ಲ?
Indrajit ಅವರು ಹುಟ್ಟಿದ್ದು. ಹೌದು ಹುಟ್ಟಿದ್ದು. Now the question is, this Dattatreya Bhujangrao Gorpade is the absolute owner under section 8 for the entire property. Now he executed the will in favor of this Indrajit Gorpade.
3 sons.
3 sons. Now these 3 sons have sold it to me. Now when these 3 sons have sold it to me, now the question is whether they have got the absolute right or a limited right.
Now the challenge is made by whom?
Challenge is made by children of Indrajit Gorpade.
Indrajit Gorpade. Partha Gorpade.
Partha Gorpade and Sarojit Gorpade. They are the children of Indrajit Gorpade. Only one son. The others are not made parties. Other brothers are not made parties. Now, your lordship may kindly see one judgment of the Supreme Court in Uttam versus
Hmm.
2016.
And also, for that I want to show division bench of this honorable court has considered a similar situation. ಮೊನ್ನೆ ಕೊಟ್ಟಿದ್ದೀನಿ.
ಇನ್ನೊಂದಿದೆ ನೋಡಿ, division bench ಇದೆ. ಮತ್ತೆ with ಇವ್ರ್ದು, ರಮೇಶ್.
This is a case under section 8 which arose. Kindly see para 10.
Para?
10. Para 9 onwards, I may permitted it. 9 and 10, only 2 paras. After coming into force of Hindu Succession Act 1956, self-acquired property, self-acquired or separate property of
Which
male.
para you are reading?
Para 9, my lord. Para 9.
9.
9. My lord. In the High Court decision, my lord. ILR 2006. After coming into force of Hindu Succession Act 1956, self-acquired or separate property of a male Hindu, when devolved on their heirs, would assume the character of a self-acquired property in their hands, and they hold it as an individual and separate property. It is relevant to state that there was a divergence of judicial opinion as to whether a son who inherits the self-acquired or co-partnership property of his father takes it as his separate property or holds it as property of his own joint family. Till the decision of Supreme Court in Commissioner Kanpur versus Chandrasen. It is appropriate to refer the following observations made therein. It is necessary to bear in mind preamble to Hindu Succession Act 1956. The preamble states that it was an act as to amend and codify the law relating to interstate succession among Hindus. In view of the preamble to the act, that is, that to modify whether necessary to codify the law, in our opinion, it is not possible when schedule indicates heirs in class 1 and only includes sons and does not include son's son, but does include son of a predeceased son. To say that when a son inherits the property in the situation contemplated by section 8, he takes it as karta of his own individual family. The Gujarat High Court's view noted above, if accepted, would mean that though the son of a predeceased son and not the son of a son who is intended to be excluded under section 8 to inherit, the latter would apply in the old Hindu law get a right by birth of the said property contrary to the scheme outlined in section 8. Furthermore, as mentioned by the Andhra Pradesh High Court, the Act makes it clear that section 4 that one should look into the Act in case of doubt and not to the pre-existing Hindu law. It would be difficult to hold today. The property which devolved on a Hindu under section 8 of the Hindu Succession Act would be HUF property in his hand with his own son. That would amount to creating two classes among the heirs mentioned in class 1. The male heirs in whose hands it will be the joint Hindu family property, and vis-a-vis son and female heirs, which with respect to whom no such concept would be applied or contemplated. It may be mentioned that heirs in the class 1 of schedule under section 8 of the Act included widow, mother, daughter, and predeceased son, etc. It is also relevant to refer to the following observation made by the Supreme Court in Yudhishthir versus Ashok Kumar. This question has been considered by this court in Commissioner of Wealth Tax Kanpur versus Chandrasen, where one of us observed that under the Hindu law, the moment a son is born, he gets the share in the father's property and becomes part of the co-partnership. His right accrues to him not on the death of the father or inheritance from the father, but with the very fact of his birth. Normally, therefore, whenever the father gets a property from whatsoever source, from the grandfather or from any other source, be it separate property or not, his son would have a share in that, and it will become part of the joint Hindu family of his son and grandson and other members who form joint Hindu family with him. This court observed that this position has been affected by section 8 of the Hindu Succession Act 1956, and therefore after the act, when the son inherited the property in the situation contemplated by section 8, he does not take it as a karta of his own undivided family, but takes it in his individual capacity. As stated above, after coming into force of Hindu Succession Act 1956, self-acquired property or a separate property of a male Hindu on his dying intestates devolves on his heirs in their individual capacity and not as a co-personary property. And in such cases, their children will not acquire any right by birth in such property. So therefore, in the present case also, since it was a purchase made by, there is no dispute about that. Purchase made by the great-grandfather along with the grandfather, and grandfather is the only sole surviving son of the great-grandfather. He got it under Section 8 as absolute property because my great-grandfather died in 1966 after the coming into force of 1956 Act. Now, when he is the absolute owner, now he is entitled to make a will. He did it in favor of his three sons. Now, three sons take it as absolute property. His children, their children will not get any right because they have succeeded to his father's property, as well as there is a will. So, under that circumstances, it is the absolute right of Indrajit Ghorpade insofar as C-schedule property is concerned. Therefore, whatever I have purchased, the purchase is without any affecting any existing right of these plaintiffs. They don't have any right at all. So therefore, my humble submission is the prima facie case is not made out. The balance of convenience, anyway, the judge also held in my favor. And irreparable injury may not arises in this case because prima facie case itself.
According to you, Dattatreya purchased the property and also got the property under Section 8.
Yes.
The property of his father.
Yes.
It becomes his separate property.
Separate property.
And during his lifetime, he disposed of the property.
Yes.
And it is an absolute property of the Dattatreya.
Yes.
And hence the grandchildren claim the right. That
Yes,
is your argument.
Now, kindly see 2016 Supreme Court judgment, which is also again
Uttam.
Uttam case. Thank you, Lordship has seen already in many cases. The same para 14, 15, your Lordship may kindly see, their Lordships have considered that Commission of Wealth Tax versus Chandrasen, para 15. And then extracted para 21 of this one. Same what is extracted by division bench, same is done. I will not trouble your Lordship once again. Before we conclude para 23 in that. Para 22, I'm sorry, para 22, which is extract.
22.
22 andre, para 15 alli internal para 22.
Judgment.
Yes, yes.
We conclude.
It is 21 and it is necessary to bear in mind the preamble to the Hindu Succession 1956. The preamble states that as an act to amend and codify the law relating to interstate succession among Hindus. In view of the preamble to the act, that to modify whether necessary and to codify the law. In our opinion, it is not possible when schedule indicates heirs in class 1 and only includes son and does not include son's son, but does include son of a predeceased son. To say that when son inherits the property in the situation contemplated by Section 8, he takes it as karta of the his own undivided family. Gujarat High Court, in view noted above, same thing extracted earlier, I have read it.
Extracted.
Yes. Before we conclude, we may therefore, next para 16, again Yudhishthir Ashok Kumar was also referred. Then in para 17, this court followed the Chandrasen case and various judgments following the Chandrasen case. This court held Puran case. The act brought about a sea change in the matter of inheritance and succession amongst the Hindus. Section 4 of the act contains the non-obstante provision in terms whereof any text, rule or interpretation of Hindu law or any custom or usage as part of that law in force immediately before the commencement of the act cease to have effect with respect to any matter for which provision is made therein, save as otherwise expressly provided. Section 6 of the Act, as it stood at the earlier time, provided for devolution of interest in the co-personal property. Section 8 lays down the general rules of succession that the property of a male dying intestate devolves according to the provisions of chapter as specified in clause 1 of the schedule. In the schedule appended to the act, natural sons and daughters are placed as class 1 heirs, but a grandson, as long as father is alive, had not been included. Section 19 of the act provides that in the event of succession by 2 or more heirs, they will take the property as per capita and not per stripes, as also tenants in common and not as a joint tenants. So therefore, even going by section 19, only Indrajit Gorpade will take it as per capita, not per stripes. So his sons will not have any right as long as Indrajit Gorpade is alive. So therefore, the plaintiffs have absolutely no right insofar of this property is concerned. Since it is an admitted fact under the para 4 that the property is absolute property, the great grandfather and the father, grandfather. Now, the other issues may not arise in this case. In fact, I have also filed Order 7 Rule 11 application. Of course, the trial court has rejected my application, but I approached this court. This court has already stayed the proceedings before the trial court. Of course, notice is ordered and stay has been granted.
Trial court allowed the application?
No, it rejected the application.
Rejected. Order 7 Rule 11.
Order 7 11. Against which I filed the CRP. CRP is now pending.
Yes.
2018 judgment, this is what my learned friend refers 2016 and of the both the division bench and 2016 of the Supreme Court. The 2018, the view it is, my lord, it is a settled, just I'll take, I'll repeat it for a limited purpose. That is the 2018 judgment para 12. It is settled that the property inherited by a male Hindu from his father's father or father's father is an ancestral property. The essential feature of an ancestral property, according to Mitaksha law, is the sons, grandsons, and the great grandsons of the person who inherits it, acquire an interest and the rights attached to such property at the moment of their birth.
Which para you are reading?
Now I am reading 2018 part 7. The just held the para 12 ali.
Para 12?
Para 12, my lord.
Already was.
Yes. That is the only they am retreating. And in view of the your lordship may kindly appreciate here. In the, what I try to point out, the your lordship may kindly see that dates is relevant rather than the date of the will. That was, and the will was on 28/1/2008. The great grandchildren was by birth they acquire. This is an ancestral compulsory property for all purpose. Father as a first dependent has no exclusive right to sell to create a document or to sell the property. In fact, may I request my lord, their own document that has been the sale deed itself, they specify just paragraph 106 of my petition. Whereas after the demise of Dattaji Rao Bhujangrao Gorpade, the Karta with respect to entire extent of land 7 acres 31 guntas and has been transferred in the name of Pratap D. Gorpade, Venda, number 3. Shailendra Gorpade in the revenue record by way of inheritance. Now here, my lord, ultimately, my lord, whether the property in question is the scheduled property, is the ancestral compulsory property, is the subject matter of the suit. Now, when such being as a first dependent has no exclusive right to sell the property, that is my contention. The court below auto, it is a under these circumstances, let them not alienate the property, let them not create a further charge on this property.
It's a project, my lord. If I should not alienate means, then I will, the company will die. Now at this stage. This is, in fact, there was earlier suit filed by
Plaintiffs are great grandchildren of the Bhujanga Rao.
Dattoji Rao.
Bhujanga Rao.
Bhujanga Rao.
Bhujanga Rao and Dattatreya jointly purchased the property.
Exactly.
Father and son.
Yes.
Also, the Dattatreya having 3 sons.
Yes.
But these plaintiffs are the sons of the
First defendant.
Indrajit.
Yes.
One of the son of the. They are the great grandchildren of original Bhujanga Rao.
Bhujanga Rao.
Howda?
Bhujanga Rao.
Sorry.
And only 2018, I want to make a distinction is 2018, what Learned Senior Counsel has argued is by way of partition, he's got the property. By way of partition, ancestral property. Whereas this is a clear case where succession happened throughout. So facts of the case are distinct
The
from.
main argument, fundamental argument is section 8 applies, not section 6.
Yes.
Exact.
That's all. Third reserved.
Plaintiff's appeal. Suit for bare injunction.
Hmm.
Interim order was granted for not to restraining the defendants from interfering. At the course of the defendant evidence, they file an application, my lords, under section 151 to maintain status quo in respect of the scheduled property, alleging that, my lords, I am putting up a construction not in my property, but in the defendant's property by encroaching upon their land. My lords, the plaintiff's specific case is that, my lords, he is the absolute owner of a site bearing 11-A, layout formed by the Talkaveri House Building Cooperative Society, and the site measurement is 3,200. My lords, in 2017, my lords, when the defendant contractors, my lords, interfere with my possession, my lords, I filed this suit, my lords, and an interim order has been granted. Subsequently, my lords, written statement is filed denying the plaintiff amendments and saying that I am trying to encroach upon their land, which is adjacent land, survey number 170.
170.
170. Namad bandu survey number 171. Matte mikit survey number nal idagate. And my lords, in my plaint itself, my lords, I have specifically stated, my lord, at page 42, my lords, para 9. Submitted that on 20th June 2017, the defendant along with some of their contractors had attempted to encroach upon the suit scheduled property and tried to demolish the structure constructed in the suit scheduled property. The plaintiff has resisted the attempt made by the defendant with the help of the neighbors and approached the judicial police, but the judicial police have refused to take any action against the defendant and their servants as this matter was a civil in nature. It is submitted the defendant is asserting that defendant has filed a suit in OS number 4901 of 2011 on the file of the Honorable City Civil and Session Judge at Bangalore against Sri Swanagila Shivacharya Swamiji for a permanent injunction. In the said suit, the defendant herein has sought for an injunction restraining the said Swamiji for interfering with the western portion of survey number 170 and survey number 199 of Vibhutipura village and bounded on east by road, west by 197 and 198, north by survey number 171 and road, and south by compound wall belonging to Shivacharya Swamiji. This property was morphily described in Schedule B property in the plain in OS number 4901 of 2011. A mere perusal of the pleadings in OS 4901 and the sketch provided along with 4901 of 2011 established that the defendant has admitted that it has no right, title, or a claim or any sort of any portion of the land in survey number 171 of Vibhutipura village, out of which the scheduled property is carved out. A copy of the plaint, so and so and so. It is submitted to the plaintiff, who is a bona fide purchaser for a value without any notice or any defect in title. The defendant, a public sector company whose officer very influential, are trying to interfere into possession of the scheduled property and change the nature of the scheduled property. This was the specific pleadings, my lords. Interim order was granted. They have not filed any application, my lords, to vacate the interim order. I led my evidence, my lords. Evidence was concluded. Even the cross-examination they had made. After, my lords, when it was posted for defendant evidence, my lords, they filed, my lords, an application for appointment of a commissioner. Trial court rejected, my lords. However, this honorable court, my lords, permitted to for a inspection of a survey be conducted, my lords. My lords, the survey report, my lords, have produced, my lords, at page 59. There, my lords, though there was a specific instructions of memo of instructions were given, my lords, to the commissioner to be conducted in respect of measuring the plaintiff's property, as well as the entire extent of the defendant's property, my lords. The defendant's property survey number 170, my lords, measures 7 acres, 18 guntas. Out of 7 acres, 18 guntas, my lords, already they have put up a compound wall and there is a structures are there, my lords, where present LAC building is situated. After that, my lords, there is a public road, my lords, of a 40 to 60 feet road is there, my lords. After that, there is a marginal land, my lords. After that, my lords, layout is there, as well as there is a boundary demarcation, as well as this has been part of the layout plan site, my lords. My lords, now, my lords, on the basis of that, the adjacent owner, my lords, where there was an interference, they file a suit. And they say nothing about my survey number or there is an encroachment by the society, my lords. Now they file an application, my lords, that a status quo has to be maintained since I am encroaching upon their land and putting up a construction. I have obtained a plan sanction in respect of the scheduled property, my lords. I am putting up a construction according to the plan sanction. Now, my lords, the interim order, my lords, they filed the application under section 151. Courts grants an interim, my lords, under order 39 rule 1 and 2, restraining me from putting up any construction as well as them also not to put up any construction in respect of the disputed
Both
land.
plaintiff and defendants are directed not to put up construction.
Not to put up construction, my lords. My only grievance is that, my lords, I'm only claiming in respect of my property. My specific case is that I'm putting up a construction in like respect of 3,200.
What is the report of the commissioner?
The commissioner says, but now the entire site comes under survey number 170.
170.
170. 170 ನಲ್ಲಿ ಬಂದಿದೆ ಅಂತ ರಿಪೋರ್ಟ್ ಹಾಕ್ತಾರೆ. ಅಟ್ ಲೀಸ್ಟ್ ಇದು 171 ಎಲ್ಲಿಗೆ ಎಂಡ್ ಆಗುತ್ತೆ, ನನ್ನ ಸೈಟ್ ಎಲ್ಲಿ ಬರುತ್ತೆ ಅಂತ ಆದ್ರೂ ಡಿಮಾರ್ಕ್ ಮಾಡ್ಬೇಕಲ್ಲ. ಏನು ಮಾಡಲ್ಲ. ಆದ್ರೂ ಅದರಲ್ಲಿ ನನ್ನ ಸೈಟ್ ಮೆಷರ್ ಮಾಡಲ್ಲ. And my lords, this is the site, my lords, which I purchased in way back in 2013.
Anyhow, both plaintiff and defendant both are restrained from putting up construction. According to you, case is already set down for defendant's evidence. Get an order on merits, that's all.
My lords, direction may be to, because they are not leading evidence, my lords, they keep on taking adjournments.
Time bound, man.
Time
bound.
Please.
Heard the appellant counsel and also the counsel appearing for the respondent. This appeal is filed, being agreed by the order of the trial court passed on IA number 12, wherein temporary injunction was granted not to put up any sort of construction for the suitable property pending disposal of the suit. And also passed an order restraining the defendant also putting up of any sort of construction over the disputed site. Since there is an allegation of encroachment, the claim of the plaintiff is that his site 11A formed out of survey number 171.
And other survey numbers, my lords. And other survey numbers.
And other survey numbers. And case of the defendant is
170. Adjacent site, survey number 170.
Adjacent land of survey number 170.
Yes. If your honor sees page number 61, the survey sketches before your honors, it clearly shows 170 where the boundary ends. And it also says in item number 3, ABCD ಎಂದು ನಮೂದಿಸಿರುವುದರಲ್ಲೂ ಸರ್ವೆ ನಂಬರ್ ಅನುಭವದಲ್ಲಿ ಸರ್ವೆ ನಂಬರ್ 170
sketch ಅಲ್ಲ.
ಹೌದು ಪೇಜ್ ನಂಬರ್ 61.
sketch ಇದ್ರದ್ದು.
ಹೌದು. ಇದರಲ್ಲಿ ತಾವು ಐಟಮ್ ನಂಬರ್ 3 ಕೊಟ್ಟಿದ್ದಾರೆ ಕೆಳಗಡೆ. ಅದರಲ್ಲಿ ವರದಿ ಹಾಕಿದ್ದಾರೆ.
ಎಂದು ನಮೂದಿಸಿರುವ ಜಾಗವು ವಾದಿಯವರ ಅನುಭವ ಜಾಗವಾಗಿರುತ್ತದೆ.
And it comes under 170. It is so that site he has encroached in my site and he's putting up a construction that he admits. There is no approved plan or anything. It is a false statement. He has put up a board for selling of apartments on a public land, and after the court grants an order, he again puts up a fresh board in violation of the court's order. Your honor sees third party interest will be created.
Other site numbers. In case of the defendant is exclusive property of survey number 170. And when the trial court comes to a conclusion that both parties to not to put up any construction in a disputed land. And when the case is also set down for defendant's evidence, and appellant counsel also submits that a time bound direction may be given to the trial court. And also counsel for the respondent also not disputes the same. And having considered the said submission, as well as when the case is set down for defendant's evidence, only to conclude the evidence of defendant and consider the suit on merits. And when such being the case, when there is a restraint order against both plaintiff and defendant, it is appropriate to direct the trial court to dispose of the matter within a time bound period of 4 months or 3 months.
4 months.
4 months. And 4 months. On merits and takudi. Both the appellant as well as the respondents are parties as well as respective counsels are directed to assist the trial court in disposal of the suit within a period of 4 months from today. Both counsels are directed to place this order before the trial court forthwith.
Please. Your honor, now in the light of this survey report, I will require to examine him further, cross-examine him. That permission may be given.
ನೀವು ಅಲ್ಲೇ ಕೇಳಬೇಕು.
ಅದೊಂದು
ನಾನು ಹೆಂಗೆ ಇಲ್ಲ ಹೇಳಕ್ಕ.
ಅಪ್ಲಿಕೇಶನ್
ಅಲ್ಲ,
ಹಾಕಿದ್ರೆ ಅಲ್ಲ
ಅಲ್ಲೇ ಕೇಳ್ಬೇಕು ನೀವು.
ಗ್ರೇಟ್
ಹಾ
ಗ್ರೇಟ್
ಅಲ್ಲಿ ಹಾಕೋ ಅಪ್ಲಿಕೇಶನ್ ನಮ್ಮ ಮುಂದೆ ಹಾಕ್ತಿರಂಗ.
ಅಲ್ಲ ಬಿಕಾಸ್ ಯು
ಇದಕ್ಕಿಂತ ಮುಂಚೆ ಬಂದು ಡಿಫೆಂಡೆಂಟ್ ಎವಿಡೆನ್ಸ್ ಅಂತ 4 ಸತಿ ತಗೊಂಡ್ರು ಟೈಮ್.
ಆಯ್ತು
ಈಗ ಬಂದು ಅಪ್ಲಿಕೇಶನ್ ಹಾಕ್ತಿವಿ ಅಂತ ಇದ್ದಾರೆ.
ಆಯ್ತು ಅಲ್ಲ
ಅದ್ರಲ್ಲಿ
ಓಕೆ
ಇನ್ನ
ಆಯ್ತು ಟೈಮ್ ಬೌಂಡ್ ಪೀರಿಯಡ್ ಇದೆ. ನೀವು ಇಬ್ರು ಈ ಆರ್ಡರ್ ಕಾಪಿ ತಗೊಂಡು ಟ್ರಯಲ್ ಕೋರ್ಟ್ ಅಲ್ಲಿ ಕೊಡಿ ಅಷ್ಟೇ.
ಗ್ರೇಟ್.
Seek for pass over, your lordship.
ಪಾಸ್ ಓವರ್ ಎಲ್ಲ ಇಲ್ಲ. ನೋಟಿಸ್ ಆರ್ಡರ್ ಏನಾಗಿದೆ ಅಯ್ಯೇ?
Your lordship, this is on the territorial
ನಾಟ್
jurisdiction.
maintainable want of jurisdiction ಆರ್ಡರ್ ವಾಸ್ ಪಾಸ್ಡ್ ಅಲ್ವಾ?
Yes, your lordship.
ಏನ್ ಟೈಮ್ ಬೌಂಡ್ ಲಿಮಿಟ್ ಇದೆಯಾ?
No, time bound.
Directed to return the plaint along with the original documents to the plaintiff upon proper identification and verification.
In fact,
time bound
it is not fixed, your lordship. In fact, the territorial jurisdiction is within this Bangalore only, your lordship.
ಆಯ್ತು
But
ಪಾಸ್ ಓವರಾ?
yes, your lordship.
ಆಯ್ತು ಪಾಸ್ ಓವರ್ ನೋಡಿ.
Grateful.
ರೀಚ್ ಆಗೋ ಡೌಟ್ ಅದಕ್ಕೆ.
Pass over, my lords.
ಪಾಸ್ ಓವರ್ ರೀಚ್ ಆಗೋದಿಲ್ರಿ.
Senior is held up.
After winter vacation ಕಾಪಿ
No, but
ಅದರ್
there is
ಸೈಡ್
a
ಅಪಿಯರ್ ಆಗಿದಾರ ತುಂಬಾ ಇದಾರಲ್ಲ. ಹಾ
There is urgency, my lords. Kindly pass over. my lords.
ಪಾಸ್ ಓವರ್ ಆಯ್ತು. ಬಿ ರಮೇಶ್ ಉಮಾದೇವಿ. ಇಲ್ವಾ? ಬೆಳಿಗ್ಗೆ ಯಾರೋ ಟೈಮ್ ಕೇಳಿದ್ರಲ್ಲ ಇದರಲ್ಲಿ ರೆಸ್ಪಾಂಡೆಂಟ್ ಅವರೇ ಕೇಳಿದ್ರು. ರೆಸ್ಪಾಂಡೆಂಟ್ ಕೌನ್ಸಿಲ್ 6 ಟೈಮ್. ಅಪ್ಲೈಂಟ್ ಕೌನ್ಸಿಲ್ ಇಸ್ ಆಬ್ಸೆಂಟ್. ಲಿಸ್ಟ್ ದಿಸ್ ಮ್ಯಾಟರ್ ಆನ್. ಯಾವಾಗ ಬೇಕು ನಿಮ್ಗೆ?
Any day, next week.
ಬೆಳಿಗ್ಗೆ ಇವ್ರು ಅಪೋಸ್ ಮಾಡಿದ್ರ ಅದರ್ ಸೈಡ್ ಅಲ್ಲ ಮತ್ತೆ ಅವ್ರು ಇಲ್ವಲ್ಲ ಈಗ?
Oppose model.
ಹಾ ಪಾಸ್ ಓವರ್ ಬರ್ಲಿ ನೋಡ್.
For appellants in this case. The suit for specific performance filed by the respondent number 1 against appellants and respondent number 2 to 5. The alleged sale agreement executed on in the year 2011. The suit filed on 2023. The
any time stipulation in the agreement?
Stipulation is not there, but the jailor who is the executed the sale agreement in favor of the plaintiff, she is not a owner of the property at that time. There is a pending suit in OS number 2023 by 2011. As time stipulation ಏನು ಕೊಟ್ಟಿಲ್ಲ ಸ್ವಾಮಿ. ಯಾಕಂದ್ರೆ ಆಗ ಸೂಟ್ ಪೆಂಡಿಂಗ್ ಇತ್ತು. ಸೂಟ್ ಅಲ್ಲಿ ಇನ್ನು ಸಮನ್ಸ್ ಸ್ಟೇಜ್ ಅಲ್ಲಿ ಇತ್ತು. ಆಗ 2011 ಅಲ್ಲಿ ದ ಮದರ್ ಆಫ್ ದಿ ರೆಸ್ಪಾಂಡ್ ನಂಬರ್ 2 ಡಿಫೆಂಡ್ ನಂಬರ್ 1 is the mother of the respondent number 2. The defendant number 1 and plaintiff collided with each other because plaintiff is the mother-in-law of defendant number 1, and they have issued any notice to the other defendants. Only issue notice to defendant number 1.
ಆಯ್ತು ಸರ್ ದಿ ಕಾಪಿ ಆನ್ ದಿ ಅದರ್ ಸೈಡ್.
ಅದರಲ್ಲಿ ಸ್ಟೇ ಒಂದು ಅಪ್ಲಿಕೇಶನ್ ಹಾಕಿದೆ ಸರ್.
ಅದೇ ನಾಟ್ ಟು ಎಲಿನೇಟ್ ಕೊಟ್ಟಿದ್ದಾರೆ ಅದರಲ್ಲೇ ಸ್ಟೇ ಮಾಡೋದು.
ಅಲ್ಲ ಯಾಕಂದ್ರೆ ಇದು ಕನ್ವರ್ಷನ್ ಲ್ಯಾಂಡ್ ಸರ್. ನಾನು ಆಲ್ರೆಡಿ ಐ ಆಮ್ ಪೀಸ್ಫುಲ್ ಪರ್ಸನ್ ಎಂಜಾಯ್ಮೆಂಟ್ ಆಫ್ ಪ್ರಾಪರ್ಟಿ.
ಆಯ್ತು ಇರಿ ಏನ್ ತೊಂದ್ರೆ ಇಲ್ಲ.
ಅಲ್ಲ ನನಗೊಂದು
ಬಟ್ ದೇರ್ ಇಸ್ ಎ ಸೇಲ್ ಅಗ್ರಿಮೆಂಟ್.
ಸೇಲ್ ಅಗ್ರಿಮೆಂಟ್ ಅದು 2011 ಸೇಲ್ ಅಗ್ರಿಮೆಂಟ್
ಮಾಡ್ರಿ. ಅವ್ರನ್ನು ಕೇಳೋಣ ಇಬ್ರು ಸೇರಿ ಕ್ಲಿಯರ್ ಮಾಡಿ. ಯಾವಾಗ ಮಾಡ್ಕೊ ಬರ್ತೀರಾ ಹೇಳಿ.
ನಾನು ಒಂದು 2 days ಅಲ್ಲೇ ಮಾಡ್ತೀನಿ ಸರ್.
ಆಯ್ತು ಮಾಡಿ. Counsel for the appellant is directed to serve the copy of this appeal memo on the counsel who appeared
ಯಾಕಂದ್ರೆ ಅಲ್ಲಿ ಟ್ರಯಲ್ ಕೋರ್ಟ್ ಅಲ್ಲಿ ಒಬ್ರು ಅಪಿಯರ್ ಆಗ್ತದೆ
on behalf of the trial court and list this matter on Monday, Tuesday ಕೊಡಿ 10-12 ಸರ್ವ್ ಮಾಡ್ಕೊ ಬನ್ನಿ. ಹೇರ್ ಮಾಡಿ suit for specific performance not to alienate ಇದೆ ಅದಕ್ಕೆ. ನೆಕ್ಸ್ಟ್ ಸಂಜಯ್ ನಾಯರ್
for the respondent.
Appeal for the respondent.
ಏನಾಯ್ತು ಸೆಟ್ಲ್ ಆಗಿದೆಯಾ?
Settlement is not possible. Settlement is not possible.
ಆಗಿಲ್ಲ. MF 2015
Yes, madam.
ಸೂಟ್ ಇನ್ನು ಪೆಂಡಿಂಗ್ ಇದೆಯಾ?
Suit is dismissed, madam. Arbitration award has been challenged by the appellant, madam.
Arbitration ಆಯ್ತು. ಆರ್ಬಿಟ್ರೇಷನ್ ಚಾಲೆಂಜ್ ಮಾಡಿ. ಇಲ್ವಾ ಯಾರು? ಸಂಜಯ್ ನಾಯರ್, ಸುರೇಶ್ ರೆಡ್ಡಿ.
This is the third round, your lordship,
Third
with
round.
respect to the same thing. Award was
ಆರ್ಡರ್
passed,
ಶೀಟ್ ಕೊಡಿ ನೋಡೋಣ.
award was passed which was questioned before the under
ಲಾಸ್ಟ್ ಟೈಮ್
34.
ಇಬ್ರು ಹೇಳಿದಿರಿ ಮ್ಯಾಟರ್
No,
ಸೆಟಲ್ಡ್ ಅಂತ.
the terms are not very happy.
Today the respondent counsel submits that the matter has not been settled. And in the previous occasion, both the counsel have submitted that matter has been settled and going to report the same. And appellant counsel is absent. Hence, list this matter next week al kodi. List this matter on 11-12. If the appellant counsel doesn't appear in the next date of hearing, the appeal will be dismissed for non-prosecution since this is the appeal of the year 2015.
Well, for the appellate one. Well, this is a matter, my lord, wherein the trial court was pleased to grant an injunction restraining sale of the property, as against which I filed the appeal, and my lord was pleased to stay the order, the first. May I submit the brief facts, my lord, leading to the case? My lord?
Notes idea nodi madam. I think this matter was heard.
A few, my lord, I had requested my lord permission to place some documents on the file of the honorable court, and I've served the other side. What my contention was, my lord, as per the additional documents.
You have already filed documents?
Yes, my lord.
Already served on the other side
Yes,
also?
my lord.
Yes.
You got it. I've given you the documents. You've given it.
Order sheet kodi madam.
Huh? My colleague has given it to you. We have even filed it in the registry after acknowledgement.
No further adjournment would be made on so and so.
Yes. My lord, the brief facts for this.
On what date you have served the copy? Copies? ಎಲ್ಲಿದೆ ಡಾಕ್ಯುಮೆಂಟ್ಸ್ ಹಾಕಿರೋದು ನೀವು ಇದೇನಾ?
Yes, my lord.
ಏನು ಕಾಪೀಸ್ ಆರ್ ಸರ್ವ್ಡ್ ಅಂತ ಇದೆಯಲ್ರಿ ಇಲ್ಲಿ ಅಕ್ನಾಲೆಜ್ಮೆಂಟ್ ಇದೆಯಲ್ರಿ? ಕಾಪಿ ರಿಸೀವ್ಡ್ on 13/9/24. ಇದು ಹಳೇದಿರ್ಬೇಕು ಮೇಡಮ್ ಇದು. ಈಗ ಮತ್ತೆ ಹಾಕಿರ್ತಾರೆ ಇವರು.
Twice I filed, my lord.
4/6
4/6/24.
39 4/6/24.
Yes, twice I filed. Same set of documents.
Same set of documents.
Yes, 4/6/24.
OS 8623 ಇದೆಲ್ಲ ಹಾಕಿದಿರಿ?
Yes, yes.
ಸೇಮ್ ಅಲ್ಲ ಇದು ಸೇಮ್ ಸೆಟ್ ಐತೆ?
4620.
2923 3924 ಕಾಪಿ ಸರ್ವ್ ಮಾಡಿದಾರಲ್ರಿ? ಯಾರ್ದು ಇದು ಸಿಗ್ನೇಚರ್?
I only have 4624 said that was.
Oh, that my lord friend has.
46
4624 we have, not for the other date.
ಇದು
Not
ಸೇಮ್
for-
ಇದೆ ಅಲ್ಲ?
4624 we have.
Yes.
ಸೇಮ್ ರೀ, ಅದು ಇದು ಸೇಮ್. ಒಂದೇ ಸೆಕೆಂಡ್. OS number 8623 2923 4324 14 OS 2923 ಸೇಮ್ 13924 ಏನಿದೆ ಅದನ್ನು ಕೂಡ 4624. ಯಾಕೆ ಎರಡು ಸೆಟ್ ಕೊಡಿದವ್ರಿಗೆ ವಾಪಸ್? ಇಲ್ಲಿ ಒಂದ್ ನಿಮಿಷ, ಇಲ್ಲಿ 395 ಪೇಜ್ ಇದೆ, ಅದ್ರಲ್ಲಿ ಎಷ್ಟಿದೆ ನೋಡಿ? 25 413 ಇದೆ. 415 415. ಯಾಕೆ ಎರಡೆರಡು ಸೆಟ್ ಹಾಕಿ? ಎರಡ್ ಸರಿ ಕೊಟ್ಟಿರ್ಬೋದು, ಬಟ್ ಸೇಮ್ ಡಾಕ್ಯುಮೆಂಟ್ಸ್ ಅಲ್ಲ. ಒಂದ್ ಸೆಟ್ ವಾಪಸ್ ಕೊಡಿ. ನಿಮಗೆ ಕೊಟ್ಟಿಲ್ಲೇನ್ರಿ?
ಇಲ್ಲ ಕೊಟ್ಟಿಲ್ಲ.
ತಗೊಳ್ಳಿ, ಹೋಗ್ಲಿ ಕೊಡಿ, ತಗೊಳ್ಳಿ. ಅಲ್ಲ ನಿಮಗೆ ಹೆಂಗ್ರಿ ಕೊಡದೆ ಇರ್ತಾರೆ? ನೀವ್ ಯಾರಿಗೆ ಅಪಿಯರ್ ಆಗೋದು?
ನಾವೇ ಕಂಟೆಸ್ಟ್.
ಇದು ಯಾರು ಸಿಗ್ನೇಚರ್ ಯಾರು ನೋಡಿ ತೋರಿಸಿ ಅವ್ರಿಗೆ ಫಸ್ಟ್.
Alva. MB Alva.
ನಿಮ್ಮಿಬ್ರಲ್ಲಿ ಯಾರ್ದು ನೋಡಿ? ನಿಮ್ದೇನು ಅವ್ರಿಗೆ ತೋರ್ಸಿ. ಅವರೇ ಇರ್ಬೇಕಾಗಾರೆ. ಅವ್ರಿಗೆ ಬಂದಿದೆಯಲ್ಲ ಕಾಪೀಸ್?
So this
Not.
ಇಬ್ರದ್ದು ಅಲ್ಲ?
Not us.
ನಾವೊಂದೊಂದು ಪೋರ್ಟಲ್ ಒಂದು ಆಯೋಗ ಮಾಡ್ಬೇಕಿನ್ನ. ಯಾವ ಕೇಸಲ್ಲಿ ನೋಡಿದ್ರು ಕಾಪಿ ಸರ್ವ್ ಆಗಿರುತ್ತೆ, ಅಕ್ನಾಲೆಜ್ಮೆಂಟ್ ಆಗಿರುತ್ತೆ, ಅದು ನಮ್ದಲ್ಲ ಅಂತಾರೆ. ಮತ್ತೆ ಇದು ಯಾರು ಇದು ಕಾಪಿ ರಿಸೀವ್ಡ್? ನಿಮ್ಮವ್ರು ಯಾರಿಗೆ ಸರ್ವ್ ಮಾಡಿದಾರೆ? ನಿಮ್ಮವ್ರು ಯಾರು ಸರ್ವ್ ಮಾಡಿದಾರೆ ಯಾರು ಇದನ್ನ? ಟು ಹೂಮ್ ದೇ ಹ್ಯಾವ್ ಸರ್ವ್ಡ್ ದಿ ಕಾಪಿ?
one MB Alva, my lord.
ಕಾಪಿ ರಿಸೀವ್ಡ್ ಏನೋ ಹೆಸರಿಲ್ಲ.
On behalf of
17 to 25 ಅಂತಿದೆ. 17 to 25 ಯಾರು ಅಪಿಯರ್ ಆಗೋದು?
That's 8 to 15. Respondent 8 to 15 I appear.
You are appearing 8 to
8 to 15 where?
You are appearing
Respondent number 1.
1. Then who appears on behalf of 2 to 7?
Not.
You are the only two contesting.
Flight tip, I only flight tip.
For the plaintiff, he's the main person, my lord.
Main person.
Well, sir, I'm not even the contesting party. There's nothing sorted. I'm not a contesting party. I'm
You
only
are
a
not contesting.
I'm only formal party. Else nothing has been sought against.
ಆಯ್ತು, ಮತ್ತೆ ನೀವು plaintiff ಗೆ ಕಾಪಿ ಶುರು ಮಾಡ್ಬೇಕಲ್ರಿ ಮೇನ್. MJ ಆಳ್ವಾನ ನೀವು MJ ಆಳ್ವ ಆಫೀಸ್ ಏನ್ರಿ?
ಅಲ್ಲ
ಮತ್ತೆ ಅವರಿಗೆ ಕಾಪಿ ಸರ್ವ್ ಕೊಡು ಮಾಡ್ಬೇಕಲ್ಲ?
I think my learned friend has an extra set, my lord.
ಯಾರು?
I only one set, sir.
You can give it to him.
Then this is not an RQ.
ಒಂದ್ಸಟ್ ನೀವು ಅವ್ರಿಗೆ ಕೊಡ್ಬೇಕು ಆಳ್ವಾರ್ಗೆ. ಆಳ್ವಾ ಇಸ್ ದಿ ಪ್ಲೇಂಟಿವ್ ಕೌನ್ಸಿಲ್.
ಅಲ್ಲ, ಶಿವಕುಮಾರ್ ಪಟೀಸ್, ರೆಸ್ಪಾಂಡ್ ನಂಬರ್ 1 ಇಸ್ ಪ್ಲೇಂಟಿವ್.
R1 is plaintiff counsel. ನಿಮ್ಗೆ ಈಗ ಡಾಕ್ಯುಮೆಂಟ್ಸ್ ನಾನು ವಾಪಸ್ ಕೊಟ್ಟನಲ್ಲ ಅದನ್ನ ತೊಗೊಳ್ಳಿ. ಯಾರಿಗೆ ಕೊಟ್ಟಿಲ್ಲ ನೋಡ್ರಿ, ಇನ್ನೊಂದು ಕೊಡ್ರಿ ಅವ್ರಿಗೆ. ಹೇಳಿ. ಈಗ ನೀವು ನೋಡ್ಕೋಬೇಕಾ ಏನಿದೆ ರೆಕಾರ್ಡ್ಸ್?
It's all their plaints, my lord. It's their plaints,
ಆಯ್ತು.
their documents. My lord is pleased to see. My lord,
Suit is for
partition.
partition.
This is one of the 4 suits filed by the same plaintiff.
4
My lord,
suits.
yes. Now, my lord is pleased to see, ink page 74, there is a sale deed executed in my favor. My lord, I am the defendant number 2017 to 24 in the trial court.
D17 to 24.
Yes. My lord, Annexure B is a sale deed executed by one Chartered Housing Limited in our favor. And my lord is pleased to see page 83, second unnumbered paragraph, where the contesting defendants sold this property, paragraph 3, whereas the above said persons jointly sold the property to Chartered Housing Private Limited, the vendors under a sale deed dated January 2007. I'm placing an argument for my lord for delay. So in January 2007, the defendants who are Mayana's family sold the property to Chartered Housing in 2007. After that, my lord, the sale deed is executed in my favor on 2nd April 2008. Thereafter, my lord, I request my lord to kindly see page 152. 152 is a residential apartment building put up on the appeal schedule property.
152.
Yes, my lord. In page 152 is a residential apartment building. Therefore, there is notice to the plaintiff with regards to this. And in page number.
This construction was made in which year?
Yes, my lord. This plan sanction is at in page 156. Plan sanction is in page 156. The plan would be sanctioned, my lord, in 2008. 2008. Plan sanction for an apartment building. In page 157, I had obtained a title report from an eminent lawyer about the title. And in page 161 is another opinion. The legal heirs of one Mayana had obtained a final judgment and decree in OS 1407 of 1989 and page 178, 180. 178, the unnumbered paragraph 4 concerns the property of mine.
What happened that suit?
Well, Lord, that was compromise between the legal heirs of Mayana. The plaintiff in the present case was not a party. She claims to be one of the children of Mayana. She was not a party to it. And this was in 1995. And in page 180, item number 2 is the property which I'm concerned with. And in page 185 is the tax paid receipt. My lord, all this, keeping all this in mind, I request my lord to kindly see the plaint, which is at ink page 93. Therefore, when the plaint was filed in 2012, construction was going on the land, buildings were put up, land sanction was obtained, revenue records were obtained. Now she claims, my lord, her relief, she makes around 53 people as defendants, and para 3 at ink page 102, paragraph 3, he says that the plaintiff submits that the plaintiff is the daughter of one Appayana and the said Appayana had 3 wives, namely so-and-so, so-and-so, so-and-so. The said first wife of Appayana had only one son, Mayana. And my lord, Mayana's children are the one who settled that dispute. And second wife died issueless. And this plaintiff is the daughter of the third wife of the said Appayana. It is submitted that the father of the plaintiff and the said Appayana, said Appayana died in 1974, leaving behind his first wife and her son Mayana, and third wife Pilama and the daughter of the plaintiff as his legal heirs. Therefore, my lord, first aspect is 1974, the partition would open up. Then my lord is pleased to turn to para 6, the following page. Bottom, that means what happened in 1974. The plaintiff submits that after the death of her father, I request my lord, before that, the top line, my lord, please see, died on 2189. That is, Mayana died on 2189. So 1974, her father died. Her stepbrother died in 1989. And then para 6. The plaintiff submits that after the death of her father, the plaintiff has requested her brother. That means she has requested her brother in his lifetime. That is before 1989. And the said Mayana for her share of the said family property. The said brother of the plaintiff had agreed for partition, that is again before 1989, and has agreed to give the share to the plaintiff. It is submitted that after the marriage of the plaintiff, plaintiff started to reside in a matrimonial home with her husband. It is submitted that on 31/3/1980, the brother of the plaintiff, the said Mayana, had sold the property bearing municipal number so-and-so on St. John's Road. And then she gives that description, Schedule A. Plaintiff submitted said Mayana had no absolute right over the property. Then the next page, my lord is pleased to turn, para 7. The plaintiff submits that after the death of the father of the plaintiff and after the death of her brother Mayana, that's after 99, his children, defendants 1F to G to 2B, have managed to get the khata of the property, and this also they have not challenged. And they give the description of the property. Then para 8, plaintiff submits that after the death of the brother of her brother, death of brother of her brother, said Mayana, his children, defendants 1G to so-and-so, have sold another portion of the property, and this sale deed is in 1990. The next paragraph, my lord, is pleased to see para 9. The plaintiff submits that defendant 1F to so-and-so have sold this particular property in St. John's Road, and this also they refer to the Schedule B property. Therefore, I am submitting for my lords, 1974, her father dies. 1989, her brother dies. She claims for partition. The brother sells one property in 1980. His children sell one property in 1990. She admits khata. She does not file a case. Then she comes in 2012. And please see the relief, what she claims, my lord. In page 120, 120. She doesn't challenge the judgment or decree, what I referred to. She says that for partition of the property, then she seeks for declaration of a sale deed dated 1980. Then next is for a declaration of a sale deed dated 1990. And then is for the declaration of the sale deed which is concerning me, 2006. And declare another sale deed for 2005. Now in this background, my lord, the trial court passes the following order. The reasons, my lord, are given from ink page 70. 70. Para 29. In view of the said specific provision, the alienation made by the deceased Mayana, my lord, before I read this, I request my lord to kindly consider. She's saying I am a class 1 legal heir. That means according to her, she would have acquired the property. Now, in view of the said specific provision, alienation made by the deceased Mayana, deceased Appayana, as well as defendant so-and-so, prior to 20th December 2004 cannot be invalidated, and such plaintiff cannot seek the temporary injunction in respect to the alienations made prior to 20th December 2004. And the plaintiff arguments clearly show that the plaintiff has sought relief of injunction and declaration of sale deed of 1980-1990 in respect of A schedule property and C schedule is not binding, but does not hold any water in view of section 6 so-and-so. And as such, plaintiff has failed to make out prima facie case in respect to IA number 1 and 3, and balance of convenience does not lie in favor of the plaintiff. Plaintiff will not be put to irreparable loss or injury if temporary injunction is not granted. Now, para 30, which concerns me, the three tests, my lord: prima facie case, injury, balance of convenience. So far as IA number 4 and 5 are concerned, plaintiff has sought relief for portion of half share in Schedule D and E property, and she has sought the relief of declaration that the sale deed dated 2007 and favor of defendant 16 to 24 of the Schedule B, and for declaration of the sale deed dated 24/6/2005 in respect of Schedule E property 24 to 53 is not binding on her, will have to be decided only during the course of the trial. And in order to avoid multiplicity of proceedings, it is just and proper to restrain defendant 16 to 53 from alienating D and E schedule properties to third person. As such, plaintiff has made out prima facie case in respect of IA 4 and 5, and balance of convenience also lies in favor of plaintiff in respect of IA and 4, and plaintiff will be put to irreparable loss and injury if temporary injunction is not granted. Now, if I just go back to the Schedule D, my lord, where at ink page 123, she shows it as if it is a vacant land. So the description of the property at ink page 123 is itself wrong. When there's a definite case placed by me to saying that there is an apartment building on the property, to saying that I have got a plan sanction, to say, I would say this for my lord's kind consideration, that the three tests in Dalpat Kumar or in Gauri Shankar Swamigalu's case of prima facie case, balance of convenience is not met. Second aspect is, my lord, delay, that she has chosen her own time in 2012 to challenge a transaction which her first cause of action arose in 1974. Now, I want to place, my lord, these additional documents to show her conduct, where the additional document, that's why I sought leave of my lords to place it. My lord, after the suit is filed, I request my lord to kindly see the additional documents filed by the plaintiff. She files a plaint on OS 86233 of 2017. Please see, my lord, the cause title. Here she makes
Page number?
the first document, my lord, additional documents in 2017, and she makes another 75 people party to this suit. So while the first suit of partition she files one more suit, and in ink page 59, paragraph number 9. This is what she says. It is submitted that in the year 2012, defendants 1A to C, that is Mayana's children, refused to give partition to other properties, and hence plaintiff has filed suit in OS 8794/2012, seeking for partition and separate possession of other joint family properties. After filing of the said suit, plaintiff have agreed and have given share in terms of money with respect to the other joint family property, and this plaintiff has executed registered release deed in favor of defendants 1A to 2C. 1A to 2C, my lord, are the same Mayana's children. This is her averment. 1A to 2C. With respect to other joint family properties, it is submitted that at the time of execution of registered release deed, the defendant 1A to 2C, that the revenue documents of Schedule A to D property are not standing in the joint family names, and further have agreed to give partition and separate possession in the Schedule A to D properties after obtain the revenue records in the joint family property. Further, the defendants were requested to wait for some time, assuring the arrangement of partition of Schedule A to D properties, as Schedule A to D properties are large properties, hence there is no partition and separate possession. The copy of the registered release deed dated 4/3/2014 is produced herewith. And then she submits, my lord, para 12. It is submitted that the document dated so and so, executed by respect to the other joint family properties, goes to show that the plaintiff is a joint family member and she is the daughter of Appayana. And then, my lord, page 63, she seeks again for partition and separate possession of properties, my lord, which go on to around 21 items. All these are in Nagwara village, K.R. So one first suit she files, then she files another suit. Then my lord is pleased to see the release deed, which she executes at ink page 119. And here she recites, and all this, my lord, is when the suit is pending, the 2012. And page 127, she refers to the title. And then page 128, second paragraph, she refers to the present suit of 2012. And next paragraph, she refers to having received a sum of rupees 1.5 crores. And then the earlier paragraph, she says, I've received 1.5 crores. And she executes this sale deed. And in page 131,
Sale deed or release deed?
release deed, sorry, release deed. In page 131, she, after that consideration, she says, do hereby admit and acknowledge the same. Releaser do hereby acquit, relinquish, transfer, assigns, and makes over the rights and interest in the Schedule C property in OS 8479 of 2012. Then, my lord, at ink page 137, she files another case. That is in 2018. And here, my lord, she makes around nearly 354 people, parties to the case, ink page 186. And then please see para 6 at ink page 188. Here again she says, it is submitted that after the death of the father Apayana and after the death of her brother Mayana, due to change of circumstance and family states and ignorance, plaintiff has filed partition suit with respect to other joint family properties in OS so-and-so, and after filing the said suit, the defendant 1A to so-and-so and defendants 2A to 3 have allotted her share in portion of one joint family property, and hence plaintiff has executed the registered release deed with respect to the said property under the release deed. At the time of execution of the registered release deed, the family arrangement was going on for partition and separate possession of the scheduled properties between defendant so-and-so and the plaintiff. The copy of the registered release deed is produced herewith. It is stated that after execution of the registered release deed in the month of 2017, the plaintiff demanded defendants 1A to C for partition and separate possession of her share in the scheduled property. It was shocking that all of a sudden and so. Then she says, in the last three sentences before para 8, the scheduled property is larger property and hence has not filed any application in pending partition suit in OS so-and-so for the purpose of sake of convenience to disposal suits on merits without any confusion. Then my lord is pleased to see she describes all the property. Page 319 is her relief. And her prayer, my lord, goes on to, from page 319 to page 414 is the relief. That means more than 100 pages is the relief. I request my lord to kindly consider on the ground of delay and conduct, my lord. And I'm placing the following judgments for my lord's kind consideration. My lord, I've placed the proposition and reference not to trouble my lord. First judgment, my lord, is Yalaki Gowda's case. My lord is, that is, if the trial court, my lord, has not exercised its discretion,
Yes.
then Mandali Rangana's case, my lord, the conduct of the plaintiff is very important. Then Anil Reddy's case, my lord, this honorable court has held that if there is delay in filing the application, Then, my lord, insofar as Rameshwari Devi's case, in the cases of false pleading, and again Colgate-Palmolive, my lord, in the case of delay. And state project, my lord, insofar as reasons should be given. And if there is no reason, my lord, it shows that there is no, what went through the learned judge's mind should be reflected in the order. And the other judgments, my lord, Gauri Shankar Swamigalu and Dalpat Kumar, my lord, in terms of principles of prima facie case, and I'm willing to undertake, my lord, that if I alienate the property during the pendency of the suit, I will disclose this litigation. I will write in any sale deed. My lord, we are all if my lord is pleased to see the cost title itself, each person, my lord, Murray Joseph, when he filed the appeal, was 73. Then his wife now is, that time was 69. So nearly 10 years we add. All of them, my lord, they are in their senior citizen. And now they have invested their life savings, put up an apartment building. And what we undertake, my lord, is if ever we alienate, we will write in the sale deed that there is a suit pending before the trial court. On that basis, my lord, I request my lord to kindly allow my appeal, my lord.
Yes.
The sale deed executed on 10/1/2007 after amendment. Is plaintiff is entitled to in joint family shares. Hence, trial court rightly considered the plaintiff share and allowed the application. No errors.
What about earlier sale deeds of 1980, 89, and also the death in the year 1974?
Prior to amendment. Prior to amendment is transaction
Your
not
building also constructed. Why you kept quiet? Is it not acquiescence? Filing one or the other suit for the relief of partition, is it for an extraction? And your own release deed executed, having received the money of 1.5 crores. Release deed.
Yes. Undertaking told the other.
Then are there formal parties?
Only formal party.
Formal
parties. Heard the appellant counsel and also the counsel appearing for the respondent. This appeal is, miscellaneous appeal is filed against allowing of IA number 4 and 5. Allah, nimdu only
Yes, ma'am.
restriction only in respect of IA number 4 and
4
5.
and 5.
Wherein an injunction is granted.
IA number 4 only, madam. We are concerned with IA number
Only 4,
4.
IA number 4. Wherein injunction is granted against the appellant, restraining the defendant number 16 to 24 from alienating the D scheduled property till disposal of the suit. The factual matters of the case of the plaintiff respond number 1 before the trial court
Page 102, madam.
that plaintiff is the daughter of one Appayanna. And the said Appayanna had 3 wives. And she is the daughter of third wife. Houdala?
Yes, ma'am.
Daughter of third wife. And the Appayanna died on 11/10/1974, leaving behind his wife and her son Mayanna.
His son, madam. Because his son Mayana from his first wife.
his son, Mayanna, through the first wife.
First wife.
Through the first wife. And also third wife, Pillamma. And her daughter, who is the plaintiff. As only heir. As only they are the heirs of the said Apayana. There was no any partition in the family of the plaintiff. And all the properties were the joint family properties. The council also would contend that brother of the plaintiff, he said Mayanna, had two wives, namely Sitamma and second wife Vanajakshi. And brother of said plaintiff Mayanna also died on 21/1989. Prior to death of Mayanna, his first wife also died. The defendant number 1A to 1G are first wife children, and defendant number 2 is second wife, and defendant number 2A to 2C are the second wife of the said Mayanna. It is also the contention of the plaintiff that the said Apayana was the full and absolute owner of the property, which have been more fully described in the schedule. And also it is the contention that after the death of her father, the plaintiff has requested her brother, said Mayanna, for her share in the joint family property. And he had agreed for partition and to give her share. However, after her marriage, she started her to reside in her matrimonial home with her husband. It is also her contention that the said Mayanna on 31/3/1980 sold the property, which is more fully described as a scheduled property. And so also contend that he had no absolute right, since he is also having her equal share. It is also contended that after the death of the father of the plaintiff and after the death of her brother, Mayanna, his children, that is defendant number 1F, 1G and 2B, have managed to get the kata of the joint family properties. And in spite of her demand, no partition was taken place. It is also their case that the legal heirs of Mayanna have also sold the C-schedule property on 1/8/1990. And also it is our contention that defendant number 1F, 1G and 2B, further they have sold the property in the year,
10/1/2007.
10/1/2007.
And there itself it said, my lord, unfinished apartment building. Same page
And
108.
thereafter, the 16 defendant has constructed apartment in the D schedule property. And the same is unfinished apartment in favor of defendant number 17 to 24. It is also contended that the said sale transaction is illegal and same will not bind on this plaintiff. And this plaintiff not at all party to the said sale transaction and no right to vendors of the appellant to execute the sale deed in favor of D scheduled property. Having pleaded the same, sought for the relief of partition, claiming half share, and also sought for the release of declaration to declare the sale deed dated 31/3/1980, 1/8/1990, 10/1/2007, are and also the sale deed dated 24/6/2005 are not binding on the plaintiff and grant such other relief. Inter-alia also sought for the relief against the appellant in alienating the property till the disposal of the suit. The case of the appellant that sale deed was made in the year 2007 itself. And also subsequently sale was made on 2/4/2008 in favor of the appellant and constructed the apartment, and the same is in possession of the appellant. And even purchasing the property, opinions are also taken from the concerned the advocates with regard to the title is concerned. And also counsel would vehemently contend that earlier suit was filed in OS 1407 of 1989 and the same was compromised. The counsel also vehemently contend that this appellant claims that she is the daughter of Appayanna through the third wife, and also succession opens on account of death of the Appayanna in the year 1974. The counsel also vehemently contend that suit was filed in the year 2012, and in the meanwhile several transactions were taken place. And also counsel brought to notice of this court with regard to the conduct of the respondent filing of subsequent suits in 2017 and 18, Allah?
17 and 18.
17 and 18. And court has to take note of the delay in filing the suit, having the knowledge about all these transactions. Relief is sought.
And the release date, Manoj.
Relief is sought in 2012. The counsel also brought to notice of this court subsequent to the filing of this suit also got executed a release deed in the year 2014.
4/3/2000.
Which clearly discloses having received the amount of rupees 1 crore 50 lakhs, Allah?
Yes.
1 crore 50 lakhs. And also the court has to take note of conduct of the plaintiff filing suits subsequently in 2017 and 18, arraying the number of defendants in the subsequent suit. The counsel also would vehemently contend that when there is a clear delay in filing the suit, the very filing of the suit itself is not maintainable. And also counsel submits that going to undertake in case of any sales are made, going to disclose the pendency of this suit. With that undertaking, this appeal can be disposed of. The counsel appearing for the respondent plaintiff would contend that the sale deed was executed in the year 2007 and subsequently on 2/4/2008, and the same is subsequent to the amendment to the Hindu Succession Act. And trial court also, while passing an order, has given the reasoning that if any property is sold, it will leads to the multiplicity of proceedings. And hence plaintiff has made out the prima facie case in respect of alienating the property, D and E schedule property. And also the very contention of the plaintiff that the sale is not binding on her. And balance of convenience lies in favor of the plaintiff. And if injunction is not granted, he will be put to irreparable harm and injury. Having heard the appellant counsel and also the counsel appearing for the respondent, it is not in dispute that the property was originally belongs to Yara father Allah?
Yes,
Appayanna. And also specific pleading is that he married 3 wives and the plaintiff is the daughter of daughter through the third wife. And also when the Appayanna died, he left behind the third wife, that is the mother of the plaintiff, as well as the son through the first wife, that is Mayanna. It is also borne out from the records that the said Mayanna also sold the property in the year 1980 and also subsequently in the year 90. Some of the legal heirs of, that is different number 1F, 1G and 2C have sold the C schedule property, which is more fully described in the schedule. Present suit is with regard to the sale made by the LRs of different number 1F, 1G and 2B with respect to the D schedule property on 10/1/2007. and subsequent. You are concerned only the descheduled property.
Descheduled, only
Descheduled property. And having considered the very pleading of the plaintiff is very clear that relief is sought for not binding the sale deed of the year 31/3/1980, 1/8/1990, 10/1/2007, and also pleading also very clear that during the lifetime of the father, during lifetime of the brother Mayana, she has sought for the relief of partition, but no partition was taken place. And apart from that, also sale was made by the legal heirs of the said Mayana in the year 1990, and present suit is filed in the year 2012. And also the council appearing for the appellant brought to notice of this court before constructing the apartment. The plan was also obtained in the year 2008. And thereafter construction was made. And when such being the case, when there is a delay in filing the suit, even if the first sale was taken place in the year 1980 and subsequent sale was taken place in the year 1990, and the present sale transaction was also taken place in 2007, and suits are filed. The suit is filed in the year 2012, and also court has to take note of the conduct of the plaintiff in filing the one or the other suit in 2017 and 2018, making the subsequent purchasers, making the purchasers as parties to the proceeding. Apart from that, after filing this suit also, she has executed a release deed, having received the amount of 1.50 crores in the year 2014, and court has to take note of conduct, and also the same has been pleaded in the subsequent suit filed in the year 2017 and 18, having received the amount. When such being the case, it is appropriate to pass an order vacating the interim order of granting the not to alienate, and also the appellant given undertaking before this court that if the appellant is intent to sell the properties, that is apartment, going to make the averment in the sale deed itself with an undertaking to disclose the suit, present suit in the said title deed, and not going to conceal the same anything. And when such undertaking is also given, and also the sale deeds are made long back in the year 1980, 1990, and 2007, and question of acquiescence also will come into the consideration while considering the matter and merits while passing an order. And when such being the case, and when such undertaking is also given, and hence it requires interference of this court, since there is a delay in questioning the sale deed, as well as the court has to take note of conduct of the plaintiff filing one or the other suit for seeking the relief of the partition, and hence the judgment under the order passed by trial court requires interference, and the same has to be set aside, and trial court not discussed anything about the delay in filing the suit from, since the relief is sought for the relief of declaration of the sale deed of the year 1980, 1990, and 2007, and hence the order passed by the trial court is set aside, and made it clear that even if the appellant alienate the property in terms of the undertaking, disclose the same in the sale deed, the pendency of this suit, subject to the result of the suit, With this observation, appeal is disposed of.
Grateful.
PB Raju. ಎಷ್ಟೊತ್ತಾಗುತ್ತೆ
Ready.
ಎಷ್ಟೊತ್ತಾಗುತ್ತೆ ಅಂದೆ?
ಅರ್ಧ ಗಂಟೆ
ಮಧ್ಯಾಹ್ನ.
Please.
Remaining matters at 2:30. Any mention, he can make mention.
Serial number 41, my lords.
41.
They have filed a IA, my lords. I need to look into it and I'll to file objections to the same. RTC ಹಾಕಿದ್ದಾರೆ ಸ್ವಾಮಿ.
ಈಗೇನು ಏನ್ ಹಾಕಿರೋದು?
ಪಾರ್ಟಿಷನ್ ಡೀಡು ರೆಫರ್ ಮಾಡ್ತಾರೆ. ರಿಜಿಸ್ಟರ್ಡ್ ಪಾರ್ಟಿಷನ್ ಡೀಡು ಅದನ್ನ ಕೊಟ್ಟಿದ್ದೀವಿ. ಬೇರೆ ಅದ್ರ ಜೊತೆಗೆ
ಆ ಡಾಕ್ಯುಮೆಂಟ್ ನ ಟ್ರಯಲ್ ಕೋರ್ಟ್ ಇದು ಈಗ ಹೊಸದ ಅದು ಅಡಿಷನಲ್ ಡಾಕ್ಯುಮೆಂಟ್. ಆಯ್ತು, ಅಡಿಷನಲ್ ಡಾಕ್ಯುಮೆಂಟ್.
Look into it and I'll file the objection, my lords. ಅಬ್ಜೆಕ್ಷನ್ ಹಾಕ್ಬೇಕು.
ಈಗ
RTC ಗಳು ಕೊಟ್ಟಿದ್ದಾರೆ,
ಹೊಸದಾಗಿ ಹಾಕಿದ್ದಾರೆ.
ಹೊಸದಾಗಿ ಹಾಕಿದ್ದಾರೆ ಸರ್. ಇವತ್ತು ಬೆಳಿಗ್ಗೆ
ಟ್ರಯಲ್ ಕೋರ್ಟ್ ಅಲ್ಲಿ ದಟ್ ಇಸ್ ನಾಟ್
10:30ಗೆ ಕಾಪಿ ಸರ್ವ್ ಮಾಡಿದ್ದಾರೆ.
ಸರಿ ರೀ, ಅಲ್ಲಿ ಡಾಕ್ಯುಮೆಂಟ್ ಕೆಳಗಿನ ಕೋರ್ಟ್ ಅಲ್ಲಿ ಹಾಕಿದ್ರೆ
ಹಾಕಿಲ್ಲ.
ಅಡಿಷನಲ್ ಡಾಕ್ಯುಮೆಂಟ್.
ಹೌದು ಸರ್.
ತೊಗೊಳ್ಳಿ. Counsel for respondent seeks time to file objections to IA 2 of 24. ಇನ್ನೊಂದು ಹಾಕಿದೀರಾ? ಯಾರು ನೀವೇನೆ? And counsel for the appellant also submits that he had filed one more
ಅಬ್ಜೆಕ್ಷನ್.
ಈಗ ಹೊಸದ್ಕ ಅದ್ ಕೋರ್ಟ್ ಮುಂದೆ ಬಂದೇ ಇಲ್ಲಲ್ಲ ಇನ್ನು. ನಿಮಗೆ ಕಾಪಿ ಸರ್ವ್ ಮಾಡಿದಾರೆ.
ಬೆಳಿಗ್ಗೆ 10:30 ಕೊಟ್ಟಿದ್ದಾರೆ ಸ್ವಾಮಿ. 10:30 ಅವ್ರು ರಿಸೀವ್ಡ್ ದಿ ಕಾಪಿ.
ಆಯ್ತು ತೊಗೊಳ್ಳಿ, ಹಾಗಾದ್ರೆ ಈಗ ತೊಗೊಳ್ಳಿ. The counsel for the appellant submits that he had filed one more application under Order 41 Rule 27. And copy is also served on the other side, and counsel for the respondent seeks time to file objections to IA. And hence 2 weeks time granted to file objections to the said IA. And if objections not filed within 2 weeks, it will be taken.
Dates may be given next week ಅಲ್ಲಿ ಆಗ್ತೀನಿ.
Oh, part out matter.
ಹೌದು ಸ್ವಾಮಿ.
ಆಯ್ತು 1 week.
Date may be given.
1 week. And if the same is not filed within 1 week, it will be taken as not filed. And IA number 2 and IA number 3 will be considered along with main appeal. List this matter for final hearing on 12.
Serial number 34.
Final hearing andre part ಅಲ್ಲಿ ಇದೆ. List this matter on 12 for further arguments ಅಂತ ಹಾಕ್ತೀನಿ.
Your lordship, serial number.
Further arguments ಅಂತ ಅವ್ರು ಮತ್ತೆ part ತೋರ್ಸೋದೇ ಇಲ್ಲ. ಅದಕ್ಕೆ part ಇರ್ಬೇಕು.
Your lordship, serial number 34, your lordship.
34 ಎಲ್ಲ ಪಾಸ್ ಓವರ್ ಆಗಿದೆ. ಈಗೇನ್ ಮೆನ್ಷನ್ ಮಾಡಂಗಿಲ್ಲ.
Serial number 58.
58 ಏನಾಗ್ಬೇಕು ಹೇಳಿ. ನೀವ್ಯಾರಿಗೆ ಇವ್ರಿಗೆ ಹೇಳಿದಿರಾ? ವಿಷ್ಣು ಹೆಗಡೆ ಅವ್ರಿಗೆ ಹೇಳ್ಬೇಕು. ಯಾರು ಹೇಳಿದ್ರೆ ಮಾತ್ರ, ಇಬ್ಬರು ಇದ್ರೆ ಹೇಳಿ.
My lord, I request you.
43.
43
Opponent parties also informed me.
43 ಏನಾಗ್ಬೇಕು ಹೇಳಿ.
A short accommodation.
ಅದ್ರಲ್ಲಿ ಯಾರು ಅದರ್ ಸೈಡ್ ಯಾರು? ಯಾವ್ದ್ರಲ್ರಿ? ನೀವು ಮೆನ್ಷನ್ ಮಾಡಿ ಮಧ್ಯಾಹ್ನ ಹೇಳಿ. ಆಬ್ಸೆನ್ಸ್ ಅಲ್ಲಿ ಅದರ್ ಸೈಡ್ ಆಬ್ಸೆನ್ಸ್ ಅಲ್ಲಿ ಟೈಮ್ ನೀವು ಕೇಳಬಾರ್ದು, ನಾನು ಕೊಡಬಾರ್ದು. ಅರ್ಥ ಆಯ್ತಲ್ಲ?
My lord.
ನೀವು ಮೆನ್ಷನ್ ಮಾಡಿ ನಂಗೆ 2:30 ಹೇಳಿ. ಐ ವಿಲ್ ಗಿವ್ ದ ಡೇಟ್.
43 opponent parties.
ಅದರ್ ಸೈಡ್ ಹೇಳಿದ್ರೇನ್ರಿ? ನೀವ್ ಯಾರಿಗೆ ಹೇಳಿ?
Petitioner. Petitioner.
ಅಪಲೆಂಟ್ ರೀ.
Appel.
MFA ಅಲ್ವಾ? Appellant counsel seeks time. Counsel for respondent also present. List this matter after winter vacation. ಆಯ್ತಾ?
My lord.
65 ಏನಾಗ್ಬೇಕು ಹೇಳಿ. ನೀವ್ ಯಾರಿಗೆ? ಪೆಟಿಷನರ್ ಅಲ್ರಿ, ಅಪಲೆಂಟ್. ಹೇಳಿ.
I am for the respondent.
Respondent. Appellant counsel seeks time. Counsel for respondent also says no objection. List this matter after winter vacation.
My lord, please. My lord, request a matter to be taken at 2:30 because he has come with a JCP to the property and he is demolishing the property. Fresh matter.
2:30 ಬರುತ್ತಲ್ಲ.
ಅಲ್ಲ, ಈ ಮೂವ್ ಮಾಡ್ತಾ ಇದ್ದೀನಿ. ಈಗ 11:00 ಬಂದು JCBs, my lord, have been brought into the property.
ಈಗ ಮೂವ್
I'm moving a fresh matter, my lord, because half of way, my lord, he is already demolishing my property.
ಮಧ್ಯಾಹ್ನದೊತ್ತಿಗೆ ಏನ್ ಪೂರ್ತಿ
ಅದಕ್ಕೆ ಒಂದು end of the list is what I'm.
ಸರ್ವ್ ಆಗುತ್ತೆ.
My lord,
ನಿಮ್ಮ ಪ್ರಕಾರ, ಫೋಟೋ ಪ್ರಕಾರ ಆಲ್ರೆಡಿ ಡೆಮಾಲಿಶ್.
my lord, half of it is done, my lord. There is a hind of it.
30 ಎಲ್ಲ ಪೂರ್ತಿ ಡೆಮಾಲಿಶ್ ಆಗಿದೆ.
ಅದಕ್ಕೆ I'm requesting at 2:30.
ಮಾಡೋದು ಹೇಳಿ. ಡೆಮಾಲಿಷನ್ ಆದ್ಮೇಲೆ
My lord, portion of it, my lord, is being demolished and it is stationed there. So,
ಎಲ್ಲಿ ಉಳಿದಿರುತ್ತೆ ಅದು?
ಅಲ್ಲ, ಇನ್ನೂ ಆಗತ್ತೆ, ಟೈಮ್ ಆಗತ್ತೆ. I think I can save the property, my lord. There is
ನೋಡ್ಕೊಳ್ಳಿ.
ಅಲ್ಲ, ಅದಕ್ಕೆ
ಡೆಮಾಲಿಷನ್ ಅಷ್ಟೇನೆ. ಕನ್ಸ್ಟ್ರಕ್ಷನ್ ಆಗದ.
No, the property, my lord, that's a house property where I was there, my lord. He has come with.
ಪ್ರಾಪರ್ಟಿ ನಿಮ್ ಪ್ರಕಾರ ಆಲ್ರೆಡಿ ಅರ್ಧ ಡೆಮಾಲಿಶ್ ಆಗೋಗ್ಬಿಟ್ಟಿದೆ.
ಅದೇ the hind portion ಇದೆ, that is.
ಅದ್ರಲ್ಲಿ ನೀವು ಉಳಿಸ್ಕೊಂಡ್ರೆ ಏನ್ ಮಾಡಕ್ಕಾಗುತ್ತೆ ಈಗ?
ಅಲ್ಲ, I can, my lord, I can
Already
save
it
it. My lord, it's raining, that's the whole.
ಈಗ ಏನ್ ಮಾಡಕ್ಕಾಗುತ್ತೆ?
ಅದಕ್ಕೆ end of the list is what.
ತಗೊಂಡ್ರೆ ಏನ್ ಮಾಡಕ್ಕಾಗತ್ರಿ?
My lord, I'll show the property status, my lord.
ನಾನೇನ್ರಿ ತಗೊಂಡು ಏನ್ ಮಾಡೋಣ ಡೆಮಾಲಿಷನ್
My
ಆದ್ಮೇಲೆ?
lord, status quo is what I'm. Status quo is what I'll.
ಡೆಮಾಲಿಷನ್ ಸ್ಟೇಟಸ್
ಇಲ್ಲ, ಮುಂದ್ಗಡೆ ಪೋರ್ಷನ್ ಹೊಡಿತಿದ್ದಾರೆ, ಹಿಂದ್ಗಡೆ ಇನ್ನೂ ಪೋರ್ಷನ್ ಇದೆ ಪ್ರಾಪರ್ಟಿ. I get.
ಎಂಡ್ ಆಫ್ ದಿ ಲಿಸ್ಟ್ ಅಂದ್ರೆ 4:30 ಆಗುತ್ತೆ.
My lord, I'll take a chance, my lord. I'll bring what is the status of the
Waste of
property.
time ಅಷ್ಟೇ.
Please. Please.
ವೇಸ್ಟ್ ಆಫ್ ಟೈಮ್ ಅಷ್ಟೇ.
And I'll take a chance, my lord, because.
ಇದೇನ್ ಹಾಕ್ಸಿರಿ ಮಧ್ಯಾಹ್ನ?
Please.
ತಗೊಳ್ಳಿ.
Grateful.
ಅವ್ರ ಖುಷಿ. ಅವ್ರ ಖುಷಿಗೆ ತರ್ಸ್ಕೋಬೇಕಷ್ಟೇ.
Serial number 49.
49 ಏನಾಗ್ಬೇಕು ಹೇಳಿ.
Time ಕೊಡ್ತೀರಾ sir?
ಇಬ್ರು ಇದೀರಾ?
ಇಬ್ರು ಇದ್ದೇವೆ. For the respondent.
49
ಹೌದು.
Appellant counsel seeks time. Counsel for respondent also present and says no objection. List this matter after winter vacation. 29 ಎಲ್ಲ ಪಾಸ್ ಓವರ್ ಆಗಿರೋದೇನ್ರಿ? ಆಫ್ಟರ್ ವಿಂಟರ್ ವೆಕೇಶನ್ ಇರ್ಲಿಲ್ಲ. ಅಪಲೆಂಟ್ ಕೌನ್ಸಿಲ್ ಇರ್ಲಿಲ್ಲ. ಆಯ್ತು. ಈಗೇನು ಎಕ್ಸ್ಟೆಂಡ್ ಮಾಡೋದು? ಆಲ್ರೆಡಿ ಆಗಿದೆ, ಸೈನ್ ಹಾಕೋದು ನಾನು ಹೋಗಿ ಅಷ್ಟೇ. ಮಧ್ಯಾಹ್ನ ಹೋಗಿ ಸೈನ್ ಹಾಕೋದು. ಅದು ಅವ್ರು ಯಾರು ನೋಡಿ ಟೈಪ್ ಮಾಡೋದವ್ರಿಗೆ ಹೇಳಿ.
Lordship, serial number 17.
Earlier is extended ಅಂತ ಹೇಳಿ.
Lordship, serial number 17. Memo for dispensation ಹಾಕೋ ಕೇಳಿ. 17.
ಪಾಸ್ ಓವರ್ ಆಗಿದೆಯಾ?
ಹೌದು.
ಮಧ್ಯಾಹ್ನ ಬರ್ತೀನಿ ನಾನು. ಟೈಮ್ ನೋಡಿದಿರಾ? ಹ್ಮ್. ಹಾ 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 ಅದ್ರಲ್ಲಿ ಏನಾಗಿದೆ? ಹಾ ಹ್ಮ್ ಅಪ್ರೋಪ್ರಿಯೇಟ್ ಫೋರಮ್ ಅಂತ. ಹಾ ವಿತ್ಡ್ರಾ ಮಾಡ್ಕೊಂಡಿರೋದೇ ತಪ್ಪಾಗಿದೆ ಅಂತ ಅವ್ರು ನಮ್ಗೆ ಆ ರೀತಿ ಸಬ್ಮಿಷನ್ ಮಾಡ್ಲಿಲ್ಲ ಬೆಳಗ್ಗೆ. ಹಾ ಈಗ ಅದೇನ್ ಮೆಮೋನ್ ಅದು ಅವ್ರು ಸಬ್ಮಿಷನ್ ಮಾಡಿದ್ದೇ ಬೇರೆ. ಅದು ಕರೆಕ್ಷನ್ ಆಗ್ಬೇಕು. ಟು ಅಪ್ರೋಚ್ ಬಿಫೋರ್ ದಿ ಅಪ್ರೋಪ್ರಿಯೇಟ್ ಫೋರಮ್ ಅಂತಾನೇನೋ ಅಂದ್ರು ಬೆಳಗ್ಗೆ. ಹಾ ಸರಿ, ಅಡಿಯಲ್ಲಿ ಮೇಂಟೈನಬಲ್ ಅಂತ ಈಗ ಡಿಸ್ಮಿಸಲ್ ಆಗಿದೆ ಅಲ್ವಾ? ಪರ್ಮಿಟೆಡ್ ರಿಕಾಲ್ ಆರ್ಡರ್ ಹಾಕೋಬೇಕು. ಈಗ ಹಂಗೆ ಮಾಡಿ ಮೆಮೋದಲ್ಲಿ ಮಾಡಕ್ಕಲ್ಲ. ಇಫ್ ದೇರ್ ಇಸ್ ಎನಿ ಟೈಪೋಗ್ರಾಫಿಕಲ್ ಎರರ್ ದಟ್ ಕ್ಯಾನ್ ಬಿ ಸೆಟ್ರೇಟೆಡ್ ಬೈ ಬೀಯಿಂಗ್ ಸ್ಪೋಕನ್. ಅದ್ ಮಾಡಕ್ಕಲ್ಲ. ಹಾ ಅವ್ರಿಗೆ ಹೇಳ್ಬಿಡಿ ಬಂದವ್ರಿಗೆ. ನೀರು ಕುಡಿಲಿಲ್ವಾ?
ಮೇಡಮ್ 44 ನೋಡಿ, 44 ಅಡ್ಜರ್ನ್ ಆಗಿದೆಯಾ ಮೇಡಮ್? 44 ಹಂಗೆ ಇದೆಯಾ?
ಇಲ್ಲ 17 ಮೆಮೋ ಫಾರ್ ಡಿಸ್ಪೆನ್ಸೇಷನ್ ಹಾಕಿ ಅಂತ ಮಾತ್ರ ಇಟ್ಕೊಂಡ್ರ ಅಥವಾ ಹಿಯರ್ ಮಾಡ್ತೆ ಅಂತಂದ್ರೆ? ಓ
Madam, serial number 50. 59 series ಇದು ಅಜ್ಜನ್ ಆಗಿಲ್ಲ ಅಲ್ಲ?
Intimate ಮಾಡಿದೀರಾ? Serial number ನೋಡಿ. 58. Sorry, madam. Respondent counsel seeks time and counsel also submits that already intimated appellant counsel. Is this matter after winter vacation?
After winter vacation.
Serial number 45 my lord.
45 ಏನಪ್ಪ ಕೇಳಿ.
Respondent. Appellant inform ಮಾಡಿದ್ವಿ.
Respondent other side intimate ಮಾಡಿದಿರಾ?
ಮಾಡಿದ್ವಿ.
Respondent counsel seeks time and also submits that already intimated counsel for the appellant. Is this matter after winter vacation? Memo for posting morning, not in the afternoon. You move the matter in the early morning. Memo for posting only in the early morning. Not in the afternoon.
Sir, Kalburgi bench.
Kalburgi bench ಇದೆಯಾ?
Matter pertains to Kalburgi bench. Mahantesh Patil.
Lord, I appear for petitioner. This matter relating to the recovery of cylinders, Lord. The investigation.
Additional.
ಹೌದು ಸ್ವಾಮಿ ಹೌದು.
Investigation matter.
ಹೌದು.
Last time notice ಇದೆ ನೋಡಿ ಮೇಡಮ್ ಅದರಲ್ಲಿ.
I completed my arguments last time.
ಅವ್ರದ್ದು ಆರ್ಗ್ಯುಮೆಂಟ್ ಆಗಿದೆ.
ಹೌದು. HCGP ಅವರು ಇರ್ಲಿಲ್ಲ ಅಂತ.
ಆಯ್ತು. HCGP ಬಂದ್ರ ಇವತ್ತು?
Yes, sir. I am present, sir.
Yes, madam.
Your Lordship, earlier direction is regarding to filing the additional charge sheet.
Yes,
and that
madam.
in that additional charge sheet, 58 cylinders already recovered and remaining 438 cylinder sold by the accused. That is the statement recorded by the IO, Your Lordship. And right now they are saying that the quashing of they are praying that to quash the additional charge sheet also. So how can it is maintainable? That is my submission, Your Lordship. So previously our additional charge sheet na file ಮಾಡಿ ಅಂತ direction ತಗೊಂಡ್ರು. ಆಮೇಲೆ ಈಗ additional charge sheet file ಮಾಡಿ ನಮ್ಮ ಹತ್ರ cylinders ಇಲ್ಲ already accused sold ಮಾಡಿದಾಯ ಅಂತ ನಮ್ಮ additional charge sheet ಅಲ್ಲಿ ಬಂದ ಮೇಲೆ ಈಗ ಅವ್ರು ಮತ್ತೆ additional charge sheet quash ಮಾಡಿ ಅಂತ ಪ್ರೇ ಮಾಡಿದ್ದಾರೆ.
How many witnesses are examined subsequent to the direction of this court? ಎಲ್ಲೋದ್ರಿ ಡಿಸಪೇರ್ ಆದ್ರಲ್ರಿ ಅವರು?
ಇಲ್ಲ ಸ್ವಾಮಿ, present.
How many witnesses you examined after the further investigation ordered by this court?
Sorry, Your Lordship, only I have a petition copy. I am not able to.
Madam, last 3 occasions matter was adjourned.
Yes, pardon me.
On 2 occasions, additional government advocate not appeared before the court. However, this
Yes, Your
court
Lordship.
had some chance. Last time, the counsel
ಹೌದು
who
ಸ್ವಾಮಿ,
appeared
at a time
was not able to make any submission before the court. That's why I gave 1 week time. Now also you are unable to make present your case before the court.
Please, last chance may be given. I will be prepared for that. I will answer your question, Your Lordship.
How many witnesses are examined subsequent to the further investigation? And what is the recovery?
Yes, sir.
And who made the statement that other cylinders have already been sold and unable to recover the additional cylinders? All
Yes.
you have to give details.
Please, sir, I will make a submission by next week.
Mahantesh, first prayer angry nimdu.
ಇಲ್ಲ ಇಲ್ಲ ಅದು ಅದು ಫಸ್ಟ್ ಪ್ರೇಯರ್
ಫ್ಯಾಶಿಂಗ್ ಹೆಂಗ್ ಬರ್ತದೆ?
ಫಸ್ಟ್ ಪ್ರೇಯರ್ ಆಕ್ಚುಲಿ ಬರಲ್ಲ ಸ್ವಾಮಿ, ಅದು ಅಂದ್ರೆ ಯುವರ್ ಲಾರ್ಡ್ಶಿಪ್ಸ್ ಅರ್ಲಿಯರ್ ಆಲ್ಸೋ ಮಾಡಿಫೈಡ್ ದಟ್ molded and
only you can seek for further investigation.
further investigation.
If you are not satisfied with the further investigation done by the police, that's all.
ಹೌದು ಸ್ವಾಮಿ, I know.
Question of quashing the additional charge sheet doesn't arise.
ಹೌದು, in order to make out a case that the investigation is not done properly, we made that prayer.
Counsel for the state again seeks time. Finally, 1 week time granted. List this matter on 11th, madam. Next Wednesday, 11-12.
List one. Matter at 2:30, 69. Raju CN. First time non-compliant.
First time non-compliance, sir. Petitioner counsel is absent and hence 1 week time granted to comply with office objection. List this matter on 11-12.
Second time non-compliant, 70.
Manjunatha MR.
3 days, charge sheet entire.
Counsel seeks 3 days time to comply with office objection and hence list this matter on 11-12.
Please.
71.
Mohammad Noor Al Ain. Ilwar. Petitioner counsel absent, however, in the ends of justice, 1 week time granted to comply with office objection. List this matter on 11-12. If petitioner counsel doesn't appear in the next date of hearing, petition will be dismissed.
72. Third time non-compliant.
Third time, Sayyid Umar. Ilwa. Petitioner counsel is absent and even matter is listed for third time for non-compliance and not complied and hence on cost of rupees 500. Another 1 week time granted. If not complied and not paid the cost, petition will be dismissed in the next date of hearing, that is on 11-12.
First time orders.
Nitish Kumar
73.
Shetty.
Already notice is given, my lord.
First time, huh?
ಇಲ್ಲ, second time. Notice, last time notice is ordered, my lord. Notice was ordered and also to secure the medical records from the jail, my lord. ಎಲ್ಲ ಮ್ಯಾಟರ್ ಮಿಸ್ಟೇಕ್ ಆಗಿದೆ. SPP is directed to file statement of objections if any and also directed to get the medical records of the petitioner from the jail authority. Told. This case. Copies kotra other side ge. Additional SPP files the report along with memo. Copies kodi ಅವ್ರು ನೋಡ್ಕೊಡ್ಬೇಕಲ್ಲ ಏನ್ ನಿಮ್ಮ ಹತ್ರ ಏನ್ ರಿಪೋರ್ಟ್ ಇದೆ ಅಂತ ಮೇಡಮ್. I start the matter with the merits also, man. Merits are not, merits also with the merit. My lord, copies are also furnished on the petitioner counsel. Really. My lord, petition is medical ground, my lord. Medical, my lord, as well as the merit also, my lord, I have ground. Merit earlier agilwa? Merit, earlier this lordship has rejected the bail petition, my lord. Merit mail agide illa? Merit mail agide. Now the changes circumstances that eyewitnesses examined, my lord. Vikram. ಇಲ್ಲಾರು ಗೋಪಿ ಅಂತಿದೆ ಮೇಡಮ್. ಹೌದು, A7 my lord. ಇದಾರು ವಿಕ್ರಮ್ ಯಾವ್ದಾರ ಆರ್ಡರ್ ಇದೆಯಾ ನೋಡಿ ಮೇಡಮ್. ಅದು earlier this lordship has granted bail to the Vikram accused number 4 ಗೆ. This lordship has granted a bail to the other accused. Accused number 4 Vikram. Whether any order on merits in respect of this petitioner. Page number 50 ಹಾಕಿದಿರಾ? ಹಾಕಿದೀನಿ. ಏನು ರೀಸನ್ ಏನು ಹೇಳಿ? 51 my lord. On merit my lord. Then change circumstances. Change circumstances. Page number 50, my lord. Page number 50. 51, my lord. Page number 52 is the relevant para, my lord. 51, Gopi. Having got the respective counsel and also on perusal of the material and record, it is clear that specific allegation against this petitioner is that this petitioner, along with other accused persons, by forming an unlawful assembly with the common object, conspired with each other and assaulted the deceased with deadly weapon. The specific allegation against the petitioner is that he snatched the knife from accused number 5 and inflicted injury on shoulder of the deceased. And as a result, he sustained injuries. And PM report also reveals that there are 18 injuries. Out of that, specific injury corresponds with injury number 10, which is deep injury on the shoulder caused by this petitioner. When such specific allegation is made and common object is attributed and this petitioner along with the other accused persons inflicted injury with deadly weapon, particularly this petitioner inflicted injury with knife and merely the deceased had sustained injury on his shoulder is not a ground to enlarge him on bail in coming to the conclusion that injury is not an vital part of the accused, but an overt act of allegation against the deceased that a brutal attack was made on the deceased who sustained 18 injuries. Heli.
Page number 54, my lord, next, my lord. This
54
lordship-
is with regard to the victim.
Accused number 4, my lord.
Ah.
There is a 7 accused person, my lord.
Ah.
Petition is accused number 7, my lord.
Hmm.
54 is the order, my lord. This lordship has granted the bail on the ground that eyewitness turned hostile, my lord. ಇದರಲ್ಲಿ PW2, my lord, he is the eyewitness, my lord, during the chief examination, my lord.
ಯಾರು CW2?
CW2 is examined as PW2, my lord. He is the eyewitness, my lord. He initially, my lord, in a chief, my lord, he has not stated anything regarding the Vikram. That is accused number 4, my lord. And he stated
This petitioner is accused number?
Accused number 7.
7.
ಅವ್ನು ಚೀಫ್ ಅಲ್ಲಿ ಹೇಳ್ತಾರೆ ಇವ್ರು ಪ್ರೆಸೆಂಟ್ ಇದ್ರು ಅಂತ ಹೇಳಿ ಪಿಟಿಷನರ್ ಕ್ರಾಸ್ ಅಲ್ಲಿ ಹಾಸ್ಟೆಲ್ ಆಗ್ತಾರೆ
ಯಾವ್ದ್ರಲ್ಲಿ?
PW2
ಇವನ
ಗೋಪಿ ಬಗ್ಗೆ.
ಅದೇ ಗೋಪಿ
ಬಗ್ಗೆ.
But chief evidence he says.
He says that they are present in the spot. ಕ್ರಾಸ್ ಅಲ್ಲಿ ಅವ್ರು ಇರ್ಲಿಲ್ಲ ಅಂತ ಹೇಳ್ತಾರೆ.
ಯಾರು ಅಪ್ರಿಶಿಯೇಟ್ ಮಾಡ್ಬೇಕು?
PW2
ಅಪ್ರಿಶಿಯೇಷನ್ ಆಫ್ ಎವಿಡೆನ್ಸ್ ಯಾರು ಮಾಡ್ಬೇಕ್ರಿ?
ಅಲ್ಲ ನಾನು
whether this court can appreciate the evidence.
ಅಲ್ಲ ಅಲ್ಲಿ ಪ್ರೆಸೆಂಟ್ ಇದ್ರು ಅಂತ ಹೇಳ್ತಾರೆ ಬಟ್ ಇದರಲ್ಲಿ ಕ್ರಾಸ್ ಎಕ್ಸಾಮಿನೇಷನ್ ಅಲ್ಲಿ ಪೇಜ್ 122
ಅವನ ಎವಿಡೆನ್ಸ್ ಎಲ್ಲಿದೆ?
ನಾನು ಹಾಕಿದ್ದೀನಿ ಪೇಜ್ 122.
122.
ಚೀಫ್ ಅಲ್ಲಿ 115 ಅಲ್ಲಿ ಹೇಳ್ತಾರೆ ಪ್ರೆಸೆನ್ಸ್ ಬಗ್ಗೆ.
ಅವನೇ ಐ ವಿಟ್ನೆಸ್.
ಅವನ 4 ಜನ ಐ ವಿಟ್ನೆಸ್, ಒಬ್ಬರನ್ನು ಡ್ರಾಪ್ ಮಾಡ್ತಾರೆ, 3 ಜನ ಹಾಸ್ಟೆಲ್ ಆಗ್ತಾರೆ.
3 ಜನ ಹಾಸ್ಟೆಲ್.
ಹೌದು. ಇವರೊಬ್ರು ವಿಕ್ರಮ್ ಬಗ್ಗೆ ಹೇಳುದಿಲ್ಲ ಚೀಫ್ ಅಲ್ಲಿ, ಕ್ರಾಸ್ ಅಲ್ಲಿ ಯಾರು ಇರ್ಲಿಲ್ಲ ಅಂತ ಹೇಳ್ತಾರೆ. ಕೈಂಡ್ಲಿ ಸಿ ಪೇಜ್ ನಂಬರ್ 122, ಮೈ ಲಾರ್ಡ್.
120 ಚೀಫ್ ಫಸ್ಟ್ ಹೋಗ್ರಿ.
ಚೀಫ್
ಆಮೇಲೆ ಕ್ರಾಸ್ ಫೋನ್. ಚೀಫ್ ಅಲ್ಲಿ ಏನ್ ಹೇಳಿದಾನೆ?
ಚೀಫ್ 114, ಮೈ ಲಾರ್ಡ್.
ಅದೆಲ್ಲ ಬರೀ ಇದಿದೆ.
ಹೌದು, 115 ಅಲ್ಲಿ ಸೆಕೆಂಡ್ ಪೇಜ್ ಅಲ್ಲಿ ಅಲ್ಲಿ ಹೆಸರು ಹೇಳ್ತಾರೆ ನೋಡಿ. ಆಕಾಶ್ ಸಾರ್ವಜನಿಕ ಶೌಚಾಲಯದ ಹೋದ ಒಳಗಡೆ ಆರೋಪಿಗಳಾದ ರತೀಶ್, ವಿನೋದ್, ಶರತ್ ಕುಮಾರ್, ಸಗಯರಾಜ್, ಹರೀಶ್ ಕುಮಾರ್, ಗೋಪಿ ಇಸ್ ದ ಪಿಟಿಷನರ್ ಮೇಲೆ. ಇವರುಗಳು ಆಕಾಶನ ಹಿಂದೆ ಸಾರ್ವಜನಿಕ ಶೌಚಾಲಯ ಒಳಗಡೆ ಹೋಗಿದ್ರು ನಾನು ನೋಡಿರುತ್ತೇನೆ. ಈಶ್ವರ್ ಅಬೌಟ್ ದಟ್. ಸಾರ್ವಜನಿಕ ಶೌಚಾಲಯ ಒಳಗಡೆ ಇದ್ದ 3-4 ಜನ ಆಚೆ ಬಾಡಿ ಬಂದಿದ್ದು ಅದನ್ನು ನಾನು ನೋಡಿ ಶೌಚಾಲಯ ಒಳಗೆ ಹೋಗಿರುತ್ತೇನೆ. ಅಲ್ಲಿ ಶೌಚಾಲಯದ ಶೆಲ್ಟರ್ ಗೇಟ್ ಅನ್ನು ಮುಚ್ಚಿದ್ದು ಒಳಗಡೆ ಆಕಾಶನಿಗೆ ಇಮೇಲೆ ಹೇಳಿದ ಆರೋಪಿಗಳು ಆಕಾಶನಿಗೆ ಚಾಕು ಇತರ ಆಯುಧಗಳನ್ನು ಹೊಡೆಯುತ್ತಿದ್ದರು. ಗೇಟ್ ಹತ್ತಿರ ನಿಂತುಕೊಂಡು ನನಗೆ ಒಳಗೆ ಹೊಡೆದು ನನಗೆ ಕಾಣಿಸಿತು. ದಿಸ್ ಇಸ್ ದಿ ಎವಿಡೆನ್ಸ್, ಮೈ ಲಾರ್ಡ್.
ಪಬ್ಲಿಕ್ ಎಲ್ಲ ಓಡ್ ಬಂದ್ರು, ಆಗ ನಾನು ಹೋದೆ, ನೋಡಿದೆ, ಇವ್ನು ಹೊಡಿತಾ ಇದ್ರು ಎಲ್ಲರೂ.
ಕಾಮನ್ ಅಲಿಗೇಷನ್, ಮೈ ಲಾರ್ಡ್. ಪೇಜ್ 122, ಮೈ ಲಾರ್ಡ್. ಕ್ರಾಸ್ ಎಕ್ಸಾಮಿನೇಷನ್ ಆಫ್ ಅಕ್ಯೂಸ್ ನಂಬರ್ 1, 2, 3 and 6. 122, ಮೈ ಲಾರ್ಡ್. ಅದರಲ್ಲಿ 4ನೇ ನಾನು ಹೋಗುವಷ್ಟರಲ್ಲಿ ಗಲಾಟೆ ಮುಗಿದು ಹೋಗಿತ್ತು ಎಂದರೆ ಸರಿ. ನಾನು ಹೋಗುವಷ್ಟರಲ್ಲಿ ಒಳಗಡೆ ಆಕಾಶ ಬಿದ್ದಿದ್ದ, ಅಲ್ಲಿ ಯಾರು ಇರಲಿಲ್ಲ. ನಾನು ಹೋಗುವಷ್ಟರಲ್ಲಿ ಒಳಗಡೆ ಸಾಕಷ್ಟು ಜನರು ಸೇರಿದರು ಎಂದರೆ ಸರಿಯಲ್ಲ. ಸಾಕ್ಷಿಯು ಮುಂದುವರೆದು ಒಳಗಡೆ ಯಾರು ಇರಲಿಲ್ಲ ಎಂದು ನುಡಿತಾರೆ. ನಾನು ಹೋಗುವಷ್ಟರಲ್ಲಿ ಒಳಗಡೆ ಆಕಾಶ್ ಮೃತಪಟ್ಟಿದ್ದು, ಹಾಗಾಗಿ ಆತನಿಗೆ ಯಾರು ಹೊಡೆದರೆಂದು ನನಗೆ ಗೊತ್ತಿಲ್ಲ.
ಅವತ್ತೇ ಆಗಿಲ್ಲ, ಚೀಫ್ ಆದ ದಿವಸ.
ಅದು ಆಮೇಲೆ ಆಗಿದ್ದು.
ಆಮೇಲೆಲ್ಲ ಅಡ್ಜಸ್ಟ್ ಮಾಡಿದಿರಿ, ಆಯ್ತು.
ಆತನು ಯಾರು ಹೊಡೆದ ನನಗೆ ಗೊತ್ತಿರುವುದಿಲ್ಲ ಎಂದರೆ ಸರಿ. ಆಕಾಶನನ್ನು ಎತ್ತಿಕೊಂಡು ಹೋಗಿದ್ದ, ನನಗೆ ಬಟ್ಟೆಗಳಲ್ಲಿ ರಕ್ತ ಆಗಿತ್ತು ಎಂದರೆ ಸರಿ.
What you have suggested, that is admitted in the cross examination.
ಹೌದು
ಅಷ್ಟೇ.
ಹೌದು. ಇದರಲ್ಲಿ then he was turned as hostile by the prosecutor. ನೀವು ರಾಜಿ ಮಾಡಿದ್ರಿಂದಾಗಿ ಅಂತ ಹೇಳಿ ಆಮೇಲೆ ಅವ್ರು ಕ್ರಾಸ್ ಮಾಡ್ತಾರೆ.
PW2.
ಹೌದು.
ರಾಜಿ ಮಾಡಿದ್ಕೆ ಏನಂದ? ಹೂನ್ನ
ಇಲ್ಲ ಅಂತ ಹೇಳ್ತಾರೆ.
ಆಯ್ತು, ನೆಕ್ಸ್ಟ್.
ರಿಕವರಿ ಇಲ್ಲ. ಅದು ಆಕ್ಚುಲಿ ತಮ್ಮ ಅರ್ಲಿಯರ್ ಆರ್ಡರ್ ಅಲ್ಲಿ ರಿಕವರಿ ಇದೆ ಅಂತ ಬಂದಿದೆ. PPO ಸಬ್ಮಿಟ್ ಮಾಡಿದ್ದಾರೆ ಅಂತ ಹೇಳಿ. ದೇರ್ ಇಸ್ ನೋ ರಿಕವರಿ ಫ್ರಮ್ ಅಕ್ಯೂಸ್ ನಂಬರ್ 6 ಓನ್ಲಿ. ರಿಕವರಿ ವಿಟ್ನೆಸ್ is also turned hostile. They are examined at PW 15 and 17. There is no recovery from the petitioner though. Recovery from accused number 6. They are also turned hostile. ಇವ್ರ ಮೇಲೆ ಇರೋದು accused number 5 ಇಂದ ತೆಗೆದು ಭುಜಕ್ಕೆ ಹೊಡೆದ್ರು ಅಂತ, that is an allegation.
ಅದೇ ಅವನಿಂದ ಸ್ನ್ಯಾಚ್ ಮಾಡಿ.
ಹೌದು. ಸಿಕ್ಕಿರುವುದೆಲ್ಲ 2 ಚೂರಿ ಮತ್ತೆ 1 ಲಾಂಗ್ ಸಿಕ್ಕಿರುವುದು accused number 6 ಇಂದ. That was recorded in the presence of the PW 15 and 17. They are also turned. Entire witness is turned hostile, my lord. Now now matter was posted for 313 statement, my lord. Now because of the medical, my lord, I have hurriedly approached the trial court.
Medical and ground.
Medically spine problem ಇದೆ. Surgery.
Got himself discharged.
ಅಲ್ಲ, ಅವರು ಹೇಳಿದ್ರು ಧೈರ್ಯ ಕೊಡಕ್ಕಾಗಲ್ಲ ಅಂತ ಹೇಳಿದ್ರು. ಅದಕ್ಕೆ ಧೈರ್ಯ ಕೊಡಕ್ಕಾಗಲ್ಲ, ಎಷ್ಟು ಹೌದು, ಅದಕ್ಕೆ ಅವನು ಡಿಸ್ಚಾರ್ಜ್ ಆದ್ರ.
ಮತ್ತೆ ಇನ್ಯಾಕ್ಬೇಕು ನಿಮಗೆ ಧೈರ್ಯ ಕೊಡಕ್ಕಾಗಲ್ಲ ಅಂತ ವಾಪಸ್ ಬಂದ್ಮೇಲೆ ಮತ್ತೆ ಸರ್ಜರಿಗೆ ಬೇಕು?
ಅಲ್ಲ, ಅಲ್ಲಿ ಅಂತ ಹೇಳಿದ್ರೆ ಗವರ್ಮೆಂಟ್ ಹಾಸ್ಪಿಟಲ್, ಮೈ ಲಾರ್ಡ್, ದಟ್ he doesn't want to take a risk.
ಆಯ್ತು, ಈಗ ಪ್ರೈವೇಟ್ ಹಾಸ್ಪಿಟಲ್ಗೆ ಹೋಗ್ತಾನೆ ಇವನು.
ಹೌದು. ಹೌದು
ಅಲ್ಲಿ ಮಾಡಿಸ್ಕೋತಾನ?
ಹೌದೌದು
ಎಲ್ಲಿ ಮಾಡಿಸ್ಕೋತಾನೆ ಹೇಳಿ, ಆಮೇಲೆ ನೋಡೋಣ. ಡೈರೆಕ್ಟ್ ಮಾಡೋಣ ಜೈಲ್ ಅಥಾರಿಟಿಗೆ. Let him take the treatment at the cost, at his cost, and with the supervision of the jail authorities. ಅಷ್ಟೇ. That can be done.
He even not able to walk also, my lord. My colleague has visited him, my lord, in jail, my lord. 2% they are carrying him, my lord. They are bringing him to the.
ಆಯ್ತ್ರಿ, ಅದಕ್ಕೆ ಸರ್ಜರಿ ಮಾಡ್ಸೋಣ, ಅದಕ್ಕೆ ಯಾಕೆ ಚಿಂತೆ ಮಾಡ್ತೀರಿ? ನೀವು ಹೇಳಿದ ಹಾಸ್ಪಿಟ್ಲಿಗೆ ಕಳಿಸ್ಕೊಡೋಣ.
My lord,
ಯಾವ ಹಾಸ್ಪಿಟ್ಲ್ ಬೇಕು ಕೇಳಿ.
even on merits also, my lord. Merits also, my lord. His lordship has granted a bail to the accused number 4 also, my lord.
ಅಕ್ಯೂಸ್ ನಂಬರ್ 4 ಯಾವ ಕೊಟ್ಟಿದೀವಿ ಅಂತ ನೋಡಿದಿರ ರೀಸನ್?
ನೋಡಿ.
ಆಯ್ತು, ಅಷ್ಟೇ. ಮೆಟೀರಿಯಲ್ ಎಲ್ಲ ಕೊಟ್ಟಿದೀವಿ.
ಅಲ್ಲ, ಇದರಲ್ಲಿ ಇವನು ಕ್ರಾಸ್ ಅಲ್ಲಿ ಕ್ಲಿಯರ್ ಆಗಿ ಹೇಳ್ತಾರೆ, ಮೇಡಮ್. ಕ್ರಾಸ್ ಅಲ್ಲಿ
ಹೇಳಿದನ್ರಿ, ಅದಕ್ಕೆ ಕೇಳಿದೆ. ಅವತ್ತೇ ಕ್ರಾಸ್ ಮಾಡಿದ್ರ ಬೇರೆ ದಿವಸ ಮಾಡಿದ್ರ ಅಂತ? ಹಾಸ್ಟೈಲ್ ಮಾಡಿಸಿದಿರಿ, ಆಮೇಲೆ ಕ್ರಾಸ್ ಮಾಡಿದಿರಿ ಅಷ್ಟೇ. ಅದೇ ನಡೆಯೋದು. ಹಾಸ್ಟೈಲ್ ಮಾಡಿಸಿದ್ರು, ಅವತ್ತೇ ಕ್ರಾಸ್ ಮಾಡಿ ಅವನ ಆನ್ಸರ್ ಎಲಿಸಿಟ್ ಮಾಡಿದ್ರೆ ಪರವಾಗಿರ್ಲಿಲ್ಲ. ನೀವು ಟೈಮ್ ತಗೋಬಿಟ್ಟು ಕ್ರಾಸ್ ಎಕ್ಸಾಮಿನೇಷನ್ಗೆ ಆಮೇಲೆಲ್ಲ ಹಾಸ್ಟೈಲ್ ಮಾಡಿಸ್ಕೊಂಡು ಕರ್ಕೊಂಡು ಬಂದು ಆನ್ಸರ್ನ ಯು ಪುಟ್ ದಿ ಆನ್ಸರ್ ಟು ದಿ ಮೌತ್ ಆಫ್ ದಿ ವಿಟ್ನೆಸ್ ಅಂಡ್ ಗಾಟ್ ದಿ ಆನ್ಸರ್.
there is no recovery also, my lord. There is no recovery from already is more than 3 years.
ಡೈರೆಕ್ಟ್ ಎವಿಡೆನ್ಸ್ ಇದ್ದಾಗ ರಿಕವರಿ ಬೇಕಾಗಿಲ್ಲ. If case depends upon circumstantial evidence, then we have to see the recovery.
But he cross examination clearly he is admits, my lord, in a cross examination.
ಅಷ್ಟೇ ಅಲ್ಲ, that's all.
My lord, his condition is very serious, my lord. Condition is very serious, my lord.
Serious, ಅದಕ್ಕೆ ಟ್ರೀಟ್ಮೆಂಟ್ ಕೊಡ್ಸೋಣ. ನೀವು ಕೇಳ್ದಲ್ಲಿ ಕೊಡ್ಸೋಣ.
2 months interim bail, my lord. Interim bail maybe.
ನೋಡ್ರಿ, ಬ್ರೂಟಲ್ ಅಟ್ಯಾಕ್, 18 ಇಂಜುರೀಸ್, ಅದು ಏನು ಮನಸೋ ಇಚ್ಛೆ ಕೊಚ್ಚಿಕೊಂಡಿರೋದು. ಮೈ ಕಾನ್ಸಿಯನ್ಸ್ ವಿಲ್ ನಾಟ್ ಪರ್ಮಿಟ್.
At least, my lord.
ಅದಕ್ಕೆ ನಾವು ಸ್ವಲ್ಪ ಬಿಗಿ ಇಂಥವ್ರಲ್ಲೆಲ್ಲ.
His condition is, my lord, at least 1 month at least. 1 month.
ಆರ್ಟಿಕಲ್ 21 ಅನ್ನ ಮಾತಾಡ್ತೀರಿ, ಅದೇ ಲೈಫ್ ಆಫ್ ಎ ಪರ್ಸನ್ ಹೇಳಿ.
At least
ಇರ್ಲಿ, ಇರಾಸ್ತಿ ಸಲ ಇರ್ಲಿ. ಯಾವಾಗ ಆಗಿರೋದು ಇನ್ಸಿಡೆಂಟ್? ಅಟ್ಲೀಸ್ಟ್ ಪಾಪ ಪ್ರಜ್ಞೆನಾರು ಹೋಗಿ.
3 years 6 months
ಅಷ್ಟೇನಾ? ಲೈಫ್ ಇಂಪ್ರಿಸನ್ಮೆಂಟ್ ಇರೋದು, ಟೇಕಿಂಗ್ ಆಫ್ ಲೈಫ್. ನಿಮಗೆ ಜೈಲಲ್ಲಿ ಇಟ್ಟಿದ್ಕೆ ಒಂಥರ ಆಗುತ್ತೆ, ಜೀವ ತೆಗಿಯುವಾಗ ಅಲ್ವಾ?
In fact, he was not present, my lord.
ಪ್ರಪಂಚದಲ್ಲಿ ಇಲ್ದಂಗೆ ಮಾಡಾಕಿದಿರಲ್ಲ.
In fact, he was not
His
present.
evidence is very clear. Went inside the toilet.
There is
and
no,
public
my lord, specific
came
contact, my lord.
out from
Even in a chief
ಆಯ್ತು,
of, ತಾವು ನೋಡಿದ್ರಿ ನಾನು ಇದು ಮಾಡಿದ್ರಲ್ಲ, there is no chief ಅಲ್ಲೂ, there is no direct ಆಗಿಲ್ಲ, ಕಾಮನ್ ಆಗಿ ಹೇಳಿರೋದು ಅವರು.
ಹೌದ್ರಿ,
ಹಿಂಗೆ ಹೊಡೆದ್ರೆ ಅಂತ ಎಲ್ಲೂ ಇಲ್ಲ.
ಕೂಗಾಡ್ತಾ ಇದ್ರು, ಹೋದ್ರೆ ಎಲ್ಲರೂ ಹೊಡಿತಾ ಇದ್ರು ಅಂತ ಹೇಳಿದ್ರು. ಏನ್ ಇಂಡಿವಿಜುವಲ್ ಆಗಿ ಒಬ್ಬೊಬ್ಬರದೇ ಹೇಳ್ಬೇಕು ಅಂತ ಏನಿಲ್ಲ. ತೊಗೊಳ್ಳಿ, heard the appellant counsel and also the counsel appearing for this state. This is a successive bail petition and earlier this court has considered the bail petition in criminal petition number 8650 of 2021 with order dated 14th day of January 2022. And while rejecting the application in paragraph number 6, taken note of vote act of this petitioner, since he had snatched the knife from accused number 5 and inflicted injury on shoulder of the deceased, and as a result he had sustained the injuries, and also taken note of corresponding injury on the shoulder, since the eyewitness speaks about inflicting the injury on the shoulder, and also taken note of common object in eliminating the victim. Now the counsel appearing for the petitioner would submit that the eyewitnesses also have been examined. Only PW2 supports in the chief evidence, but in the cross examination turns hostile. And this court already granted relief in favor of accused number 4 after the examination of witness. And hence this petitioner also entitled for bail on the ground of parity. The counsel also would submit that there is no any recovery at the instance of this petitioner and recovery at the instance of other petitioners. Per contra, the counsel also in support of his argument in the previous occasion got the report, requested to get the report from the jail authority, and the additional SPP also filed the memo along with the report. The counsel would submit that petitioner is suffering and he needs the surgery. and hence he may be enlarged on bail on the main medical ground. Per contra, the counsel appearing for the state would submit that when the petitioner was taken to the hospital, he got himself discharged from the hospital. And even though suggested for surgery. And also counsel submits that even though PW2 has turned hostile in the cross examination, but in the chief evidence, he has deposed before the court with regard to the very presence of this petitioner as well as inflicting the injury. And only after taking time for cross examination, answer was put to the mouth of the witness and he admitted in the cross examination. And this court cannot usurp the jurisdiction of the trial court, and trial court has to appreciate the evidence available on record. The counsel also would submit that if the petitioner choose to have the surgery in any other private hospital also, this court can direct the jail authorities to take him to the particular hospital in which he takes treatment, and he can be provided treatment with the supervision of the jail authority. Having heard the appellant counsel and also the petitioner counsel and also the counsel appearing for the respondent, this court already considered the matter on merits in criminal petition number 8650 of 2021, and in paragraph number 6 also considered the material on record. Now the counsel contention is that the PW2, who is an eyewitness, has turned hostile in the cross examination, but the fact is that he had supported in the chief evidence is also not in dispute. And the cross examination was also made subsequent to the chief evidence. And when such being the case, the trial court has to appreciate the evidence available on record, and this court cannot usurp the jurisdiction of the trial court to appreciate the evidence available on record, sitting in considering the only the bail petition. No doubt this court granted bail in favor of accused number 4, wherein this court made an observation that no material is found when the prosecution witnesses are examined, and hence exercise the discretion in favor of accused number 4 in other bail petition. There is a force in the contention of the appellant respondent counsel that he can be provided treatment with the supervision of the jail authority. The counsel appearing for the state also brought to notice of this court that he voluntarily got discharged from the hospital, and when such being the material available on record, the petitioner can take treatment at his cost in any of the hospital he chooses under the supervision of jail authorities, and he can be provided with the treatment. And having considered the material on record and specific court act allegation is also made against this petitioner, and then there is a direct evidence against the petitioner, even on the submission of counsel appearing to the petitioner, that no recovery and the same is not material. In view of the discussions made up, I pass the following order. Bail petition is rejected. However, the jail authority is directed to take him to the hospital, in which hospital the petitioner intend to take treatment of surgery. And the surgery would be at the cost of the petitioner.
Copy may be communicated to the jail authority ಮೇಲೆ ನಾವು ಕೊಟ್ಟರೆ
ಹೋಗುತ್ತೆ, ಅವ್ರು ಕಮ್ಯುನಿಕೇಟ್ ಮಾಡ್ತಾರೆ.
74, Ketan Kumar.
Short accommodation. Short accommodations.
First time. Petitioner counsel seeks time and list this matter on 11-12. First time ನಿಮ್ಗೆ ಡೈರೆಕ್ಷನ್ ಆಗಿಲ್ವಾ? ಹಾಗಾದ್ರೆ ತಗೊಳ್ಳಿ. Additional SPP is directed to take notice and file objections if any. List this matter on 11-12.
75 is the first time.
ಇದು ಫಸ್ಟ್ ಟೈಮ್ ತಗೊಳ್ಳಿ. Additional SPP is directed to take notice and file objections if any. List this matter on 11-12.
76, Basavaraju.
ಬಸವರಾಜು TA.
Successive application mala.
ಏನ್ ಅಫೆನ್ಸ್ objections ಆಗ್ತಾ ಇದ್ದೀರಾ? Statement of objections filed by the respondent counsel.
Malarship, page number 77 is the earlier order. On merits, this honorable court is rejected. And 1 year time limit is granted to the sessions court to complete the trial. Malarship, now 2 years is already completed after the direction of this honorable court. Now the petitioner is in judicial custody since from 4 years, 7 months. My lordship, trial PW 4 is going on.
ಅಫೆನ್ಸ್ ಏನ್ರಿ?
Offense NDPS case, my lordship, under section
ಏನ್ ಕ್ವಾಂಟಮ್
22-23 commercial quantity, please.
ಎಷ್ಟಿದೆ ಏನು?
1 kg 3.
ಮ್ಯಾನುಫ್ಯಾಕ್ಚರ್ ಡ್ರಗ್ ಏನು?
My lordship,
ಕೊಕೇನ್.
yes.
ಟ್ರಯಲ್ ಕೋರ್ಟ್ ಅಲ್ಲಿ ಕಮೆಂಟ್ಸ್ ಆಗಿಲ್ವ ಟ್ರಯಲ್?
My lordship, only 3 witnesses complete.
4 witnesses.
Four.
ಹಾ.
My lordship, totally 15 witnesses, my lordship. Takes, my lordship, some more time. My lordship, the page number 83, please, my lordship, the section, my lordship, honorable Supreme Court, my lordship, is 3 years, 3.5 years. My lordship, section 37, my lordship, regards cannot be applicable if there is a long incarceration. My lordship, only 3 witnesses, my lordship, and also, my lordship, page number 93, my lordship, I wanted to canvass this point, my lordship, on merits. My lordship, the samples, my lordship, as per the Mohan Lal's case, 93, my lordship. Last lines, lordship, continuation. My lordship, this is the judgment, my lordship, 52A. My lordship, at the airport, my lordship, the contraband is seized. My lordship, investigation officer, complainant PW1 is drawn the samples in the airport. My lordship, section 52A is mandated the concerned officer to draw the samples before the magistrate. My lordship, that has not been completed, my lordship. Next, page number 94, that would be construed as a primary evidence.
That is your defense alva?
Is the defense, my lordship, it is true, but mandatory, the provisions, my lordship, that
Is the punishment rate, commercial quantity, 20 years.
minimum 10 years, maximum 20 years.
It's fine of 2 lakhs.
It is, my lordship, takes, my lordship, already, my lordship, nearly 5 years.
ಆಯ್ತಲ್ರಿ 3-4 ಜನ ಎಕ್ಸಾಮಿನ್ ಮಾಡಿದವ್ರು ಸಪೋರ್ಟ್ ಮಾಡಿದಾರ ಇಲ್ಲ?
Support ಮಾಡಿದಾರೆ sir. All intelligent ಮಾಡಿದಾರೆ.
ಮತ್ತೆ
Our intelligent officer, they always support, my
Appreciate
lordship,
ಮಾಡ್ಬೇಕಲ್ಲ?
but my lordship, this 52A, my lordship, the samples, not drawn.
ಡಿಫೆನ್ಸ್ ಅಲ್ಲಿ ಎಲಿಸಿಟ್ ಮಾಡಿ ಆನ್ಸರ್ಸ್ ಫ್ರಮ್ ದಿ ಮೌತ್ ಆಫ್ ವಿಟ್ನೆಸಸ್.
That is already elicited, my lordship, that is the matter of appreciation. But my lordship, honorable,
ಕಂಪ್ಲೀಟ್ ಮಾಡ್ಲಿ ಆಮೇಲೆ ಹೇಳಿರ ನೀವು.
honorable Supreme Court, my lordship, only on the count 52A itself, my lordship, this judgment is pronounced.
ಹೌದು.
My lordship, on the count alone, my lordship, there is no primary evidence, my lordship, matter is acquitted. My lordship, 52A.
ಹೌದ್ರಿ, ದಿಸ್ ಇಸ್ ಆನ್ ಮೆರಿಟ್ಸ್ ರೀ. ಮೆರಿಟ್ಸ್ ಅಲ್ಲಿ ನಾನ್ ಕಂಪ್ಲೈನ್ಸ್ ಆಫ್ ಸೆಕ್ಷನ್ 52A he was acquitted. ಹೌದಾ?
My lordship, there is a merits. It is true, my lordship, if there is no mandatory provision is not complied, my lordship, there is a good ground for bail. My lordship, since I am in judicial custody, my lordship, since 4 years, 7 months, nearly, my lordship, 5 years. My lordship, only 3 witnesses.
ಡೈರೆಕ್ಷನ್ ಕೊಡೋಣ ಬಿಡಿ. ಏನ್
another 11 witnesses takes
ವಿಟ್ನೆಸಸ್? 10 ಜನ. ಎಷ್ಟು ಜನ ವಿಟ್ನೆಸಸ್ ಇರೋದು?
15, my lord.
ಹಾ.
Takes, my lordship, please.
6 months ಅಲ್ಲಿ ಕಂಪ್ಲೀಟ್ ಮಾಡಿ.
My lordship. Lordship, already passport, my lordship, is seized, is under the custody. My lordship,
ಏನ್ ಸೀಸ್ ಆಗಿದೆ?
passport, my lordship, he never be.
ಪಾಸ್ಪೋರ್ಟ್.
Yes, passport and visa, my lordship, is already under seized. My lordship, again time is granted, my lordship.
ಹಾಸ್ಪಿಟಲ್ ಆದ್ರೆ ಎಲ್ಲ ವಾಪಸ್ ಕೊಡ್ತಾರ್ರಿ.
ಮತ್ತೆ 2 ವರ್ಷ ಆಯ್ತು ಸ್ವಾಮಿ, ಮತ್ತೆ ಬಂದ್ರೂ again they
6
will
months
seek.
ಕೊಡೋಣ ಅಷ್ಟೇನೆ.
My lordship, 5 years, my lordship. Honorable Supreme Court, my lordship,
ಏನ್ ಮಾಡೋಣ?
37, my lordship.
ಕಮರ್ಷಿಯಲ್ ಕ್ವಾಂಟಿಟಿ, ಇಟ್ ವಿಲ್ ಬಿ an impact on the society ಅಲ್ವಾ?
True, my lordship, 37, my lordship, cannot violate article 21, my lordship.
The NDPS Act al 37 is very
It's
specific.
number 83, my lordship.
You have to
Honorable
make out
Supreme-
a case. When you have not made out the case, then question of granting the bail doesn't arise.
Lordship, 83, my lordship, Honorable Supreme Court clearly, my lordship, 3.5 years, my lordship, served. Long incarceration, my lordship, 4 years, 7 months, 5 years, my lordship. 3 witness takes, my lordship, thousands of cases, my lordship,
Will be
only
an
2 days NCB cases here.
It will be an impact on the society.
Only ವಾರಕ್ಕೆ 2 ದಿನ ಹಾಕೊಂತಾರೆ ಸ್ವಾಮಿ, NCB and DRA. My lordship, thousands of cases, witnesses are coming and going back, and also witnesses are not regular. Lordship, this is continuously happening, please, your honorship, take some reasonable time to. Lordship, any condition, my lordship, I am ready to put signature in the NCB. DRA officers, my lordship, she is a woman, my lordship, she is applying some various elements, my lordship.
Woman paragraph number 3 ಅಲ್ಲಿ ನೋಡಿ, ಎಲ್ಲ ಇನ್ಸ್ಟಾಲ್ಮೆಂಟ್ ಅಲ್ಲಿ ತೆಗ್ದಿರೋದು ಹೊರಗಡೆಗೆ. swallowed some capsules. He was taken to the ladies' toilet. After 15 minutes, the lady officer came out of the toilet and showed a white cloth tube-like pad, which accused had kept in her vagina surface, weighing 20 grams of white powder. Again, after 15 minutes, 34 capsules were removed. And again, accused revealed that she is having further contraband in her rectum. And after 15 minutes, another 13 capsules were ejected. Thus, in all, 150 capsules were seized, in all weighing 1,385.02 grams. And when the same was tested through test kit, the powder is said to have been cocaine. After seizure of the narcotic substance and arrest of accused, report was submitted before the custom inspector. This is the material. That is the reason only I rejected the earlier
earlier
petition.
rejected. It is true, my lordship,
Okay.
because long incarceration. my
True
lordship,
ಆದ್ಮೇಲೆ ಏನ್ ಮಾಡೋದು?
we are not admitted, please, your honor. Long incarceration, 5 years.
ಎಲ್ಲ ಹೊರ ತೆಗ್ದಿರೋದ್ರಿ.
My lordship, I am found up.
Good.
Chances of absconding is
I
not there.
heard the petitioner counsel and also the counsel of.
My lordship, 2 months direction, my lordship, I am ready to be, my lordship, 2 months
Respondent.
direction, my lordship.
This
I
court
permitted
earlier
to
rejected
withdraw
the
2
petition
months direction.
with
by
order
candidate.
dated 21st day of June 2022. In criminal petition number 9087 of 2021. And while rejecting the bail petition, taken note of 1,385.02 grams of 150 capsules were seized.
One
the
submission
petitioner.
before, my lordship.
And the court has to take note of modus operandi of the petitioner. And detailed order was passed.
My lordship, just a second, my lordship.
Rejected the same. Now the counsel appearing to the petitioner would submit that this petitioner is in custody from last 4 years, 7 months. And though direction was given by this court to dispose of the matter not later than 1 year from the date of receipt of copy of this order. And in spite of 2 years has been elapsed, the trial has not been completed. And on the ground of incarceration, the petitioner may be enlarged on bail. For contra, the counsel appearing to the respondent brought to notice of this court the recovery at the instance of the petitioner, and counsel also would submit that already 4 witnesses have been examined and already trial has been commenced, and the witnesses have supported the case of the prosecution. And when such being the material on record, a time bound direction may be given to try and dispose of the case. Having heard the petitioner counsel and also the counsel appearing to the respondent and also taking note of the quantity of cocaine was seized at the instance of the petitioner, that is commercial quantity. In all, 1,385.02 grams of 150 capsules were seized at the petitioner, and in detail considered the matter earlier while rejecting, and now the only contention that he is in custody from last 4 years, 7 months. And this court also, while rejecting the earlier bail petition, taken note of the recovery at the instance of the petitioner narrated in paragraph number 3 in detail. When such being the case, when the trial already been commenced and the witnesses have supported the case of the prosecution, and this court cannot appreciate the evidence available on record by usurping the jurisdiction of the trial court, and only this court can give direction to the trial court to try and dispose of the matter within a time bound period. Even though this court earlier granted 1 year time, and even after lapse of 2 years also, trial has not been completed, and taking into note of the said fact into consideration, examine the remaining witnesses in keeping them present in the next state of hearing and dispose of the same within a period of 6 months. 6 months.
Time may kindly be shorted, my lordship. 3 months at least, my lordship. I am ready to.
Sorry, no, witness
6 months, it takes long time,
6
my
months.
lordship, again.
Next.
77, Prasanna DP.
For the petitioner. Last occasion, your lordship.
76 ಆಗಿದ್ದಲ್ಲ ಈಗ 77 ಹೇಳಿ ಏನು ಫಸ್ಟ್ ಟೈಮ್
ಅಲ್ಲ, last time notice is ordered. And as per the endorsement, the same is communicated to the respondent. And
ಈಗ ಯಾರು ನೀವ ಅಂಡರ್ಟೇಕ್ ಮಾಡ್ತೀರಾ? ನಿಮ್ಮ ಹೆಸರೇನು? MB
V for victory.
ಕೌನ್ಸಿಲ್ MV ಅಲ್ಲ? MVC undertakes to file wakalat for respond number 2 na,
Sole respondent.
only ಒಬ್ರೇ respondent.
Please, my lord.
Respondent. ಕಾಪೀಸ್ ಕೊಟ್ಟಿಲ್ವಾ?
ಅಲ್ಲ ಕಾಪೀಸ್ ಕೊಟ್ಟಿದೀವಿ,
ಹಾ.
ಬಟ್ ಒನ್ ಮೋರ್ ಸೆಟ್ ನೌ ಇಟ್ ಸೆಲ್ಫ್ ಐ ವಿಲ್ ಫರ್ನಿಶ್ ಒನ್ ಮೋರ್ ಸೆಟ್ ಮೇಲೆ.
ಯಾವಾಗ ಕೊಟ್ಟಿದ್ರಿ?
ಅಲ್ಲ ಕಾಪಿ ಲಾಸ್ಟ್ ಟೈಮ್
ನೋಟಿಸ್ ಹೋಗಿಲ್ಲಲ್ರಿ?
ಹೋಗಿದೆ, ನೋಟಿಸ್ ಹೋಗಿದೆ ಸರ್.
Police report received unserved stating that respondent G Vijay Lakshmi was not available at the address.
ಕಾಪಿ ನಾವು ಆಫೀಸಿಗೆ ಕೊಟ್ಟಿದೀವಿ.
ಯಾವ ಆಫೀಸಿಗೆ?
ಅಲ್ಲ ಇಲ್ಲಿ ಪ್ರೋಸೆಸ್ ಅಲಾಂಗ್ ವಿತ್ ಪ್ರೋಸೆಸ್ ವಿ ಹ್ಯಾವ್ ಫರ್ನಿಶ್ಡ್ ದಿ ಕಾಪಿ.
ವಾಪಸ್ ಬಂದಿರ್ಬೇಕು. ಇದ್ರ ಕೊಡ್ರಿ ಮೇಡಮ್. ಪೊಲೀಸ್ ವಾಪಸ್ ಹಾಕಿದಾರ ನೋಡಿ. ರಿಟರ್ನ್ ಆಫ್ಟರ್ 1 week ಅಂಡ್ ಏನೋ ಪಿಲಿಗ್ರಿಮೇಜ್ ಹೋಗಿದ್ರು ಅಂತ.
ಹೌದು.
ಅಂಡ್ ಅಡ್ವೊಕೇಟ್ ವಿಲ್ ಅಪಿಯರ್ ಆನ್ ದ ನೆಕ್ಸ್ಟ್ ಡೇಟ್ ಆಫ್ ಹಿಯರಿಂಗ್ ಅಂತೇನೋ ಅಲ್ಲಿ ಹೇಳಿದ್ದಾರೆ.
ಹೇಳಿದೆ.
ಬಂದಿದ್ಯಾ ಮೇಡಮ್ ಪೇಪರ್? ಇಲ್ಲ ಒಂದ್ ಮೂರು ಕಾಪಿ ಕೊಟ್ರಿ?
ಇವಾಗ ಈಗಲೇ ಕೊಡ್ತೀನಿ, ಇವತ್ತು ಕೊಡ್ತೀನಿ.
ವಾಪಸ್ ಬಂತ ಅದ್ ಕೊಟ್ಟಿದಾರ ಅಂದೆ. ಅದೇ ಕಾಪೀಸ್ ಕಳ್ಸಿದ್ ರೆಸ್ಪಾಂಡೆಂಟ್ ಗೆ ವಾಪಸ್ ಬಂದಿದ್ಯಾ ಅಂದೆ. ಅದು ಇದ್ರೆ ಅವ್ರಿಗೆ ಕೊಟ್ಬಿಡಿ ಹಿಂದೆ. ಐ ನೋ ದಿ ಎಂಡಾರ್ಸ್ಮೆಂಟ್. ಅದೇನದು ಯಾರು ಕೊಟ್ಟಿರೋದು? ಅದೇ ಕೊಟ್ಬಿಡಿ ಅವ್ರಿಗೆ ಅಷ್ಟೇ. ಪೊಲೀಸ್ ಜೊತೆಗಿದೆಯಲ್ಲ ರಿಪೋರ್ಟ್ ಜೊತೆಗಿರೋದು, ಅದನ್ನೇ ಕಾಪೀಸ್ ಅವ್ರಿಗೆ ಕೊಟ್ಬಿಡಿ. ಮತ್ತೊಮ್ಮೆ ಯಾಕೆ ಅವರು ಜೆರಾಕ್ಸ್ ಮಾಡ್ಕೊಡೋದು? ತೊಗೊಳ್ಳಿ. ದಿ ಕಾಪೀಸ್ ಆಫ್ ದಿ ಕ್ರಿಮಿನಲ್ ಪಿಟಿಷನ್ ಇಸ್ supplied to the counsel for the respondent, and if wakalat is filed within week ಅಲ್ಲ next week ಬರುತ್ತೆ, ಅದಕ್ಕೆ within 3 days the registry is directed to show the name of the counsel for respondent and list this matter on 11/12.
ಮುಚ್ಚಬಿಡಿ.
78 V Siddeshwara.
Petitioner in this case, my lord. Petitioner is accused number 1, my lord. My lord, for punishable under section 302, 201, 109, read with 34, my lord. In all 2 petitioners, my lord. My lord, previously, my lord.
ಬಾಲಚಂದ್ರ earlier ರಿಜೆಕ್ಟ್ ಆಗಿದೆ.
ಇದೆ ಸ್ವಾಮಿ. ರಿಜೆಕ್ಟ್ ಆಗಿದೆ ಸ್ವಾಮಿ.
ಬೇರೆ ಬೆಂಚ್ ಮುಂದೆನೆ.
ಬೇರೆ ಬೆಂಚ್ ಮುಂದೆ. ಡೀಟೇಲ್ಡ್ ಆರ್ಡರ್ ಆಗಿದೆ. My lord, only ground I am urging right now is delay in trial, my lord. He was
delay in trial.
Delay in trial.
Offense in 302.
Yes, my lord.
ಯಾವ year?
My lord, 21, my lord. 21. He was arrested on 25/7/21. SC is of 2022, my lord.
Comments ಆಗಿದೆ ಇಲ್ಲ ಟ್ರಯಲ್?
ಟ್ರಯಲ್ ಕಮೆಂಟ್ಸ್ ಆಗಿಲ್ಲ ಸ್ವಾಮಿ.
ಆಗಿದೆ.
ಆಗಿಲ್ಲ ಸ್ವಾಮಿ. ಆಗಿಲ್ಲ ಸ್ವಾಮಿ.
ಚಾರ್ಜ್ ಎಲ್ಲ ಫ್ರೇಮ್
ಚಾರ್ಜ್ ಆಗಿದೆ ಸ್ವಾಮಿ. ಯಾಕಂದ್ರೆ ನಾನು ಕಸ್ಟಡಿ
ಫ್ರೇಮ್ ಆಗಿದೆ.
ಆಗಿದೆ ಸ್ವಾಮಿ. ನಾನು ಕಸ್ಟಡಿಯಲ್ಲೇ ಇದ್ದೀನಿ.
ರಿಪೋರ್ಟ್ ತರಿಸ್ಕೋತೀರಿ? Why the trial has not been commenced? Get the report. Additional SPP seeks time to get the report with regard to not commencing of trial. And hence this matter on 11/12.
Obliged.
79 Prasanna Kumar V.
Prasanna Kumar. ಯಾರಿಗೆ? R3 ಈಗ R2 ಗೆ ಕೌನ್ಸಿಲ್ ಶ್ರೀ ವಕಾಲತ್ ಹಾಕಿದೀರಾ? ಏನು ಶ್ರೀಧರ ಕೆ submits that he has filed wakalat on behalf of R3. ಹೇಳ್ರಿ.
I'm for the petitioner, my lord.
ರಿಪೋರ್ಟ್ ಅಂದ್ರೆ ಸರ್ವಿಸ್ ಆಗಿರೋದು R1 ಗ R2 ಗೆ ಆಯ್ತಾಯ್ತು. ಸುಮ್ಮನೆ ಅದು ಫಾರ್ಮಾಲಿಟೀಸ್ ಅಪಿಯರ್ ಆದ್ಮೇಲೆ ಅವರು ತೊಗೊಳ್ಳಿ. ಅಡಿಷನಲ್ SPP ಫೈಲ್ಸ್ ರಿಪೋರ್ಟ್ ಹ್ಯಾವಿಂಗ್ ಸರ್ವ್ಡ್ ದಿ ಕಾಪಿ ಆನ್ ದಿ R2. ಎಸ್ ರೆಡಿ ಏನ್ರಿ?
Yes, my lord. Yes.
ನಿಮ್ನೆ ನೀವು ರೆಡಿ ಇದ್ದೀರಾ ಏನೋ?
Yes, my lord.
ಕ್ಯಾನ್ಸಲೇಷನ್ ಆಫ್ ಬಿಲ್ ಇದು?
Yes, my lord.
25,000 rupees past.
Yes, my lord.
One more complaint. With the intention to cancellation of the bail. And that ground they again the petition approach.
ಆಯ್ತು ಹೇಳಿ ಏನ್ ಗ್ರೌಂಡ್ ಇದೆ
Yes,
ನೋಡಿ.
my lord. But ಏನು ಅಂತಂದ್ರೆ ಕ್ರೈಮ್ ನಂಬರ್ 69/2020, my lord. First FIR.
ಈಗ ನೀವೇನ್ ಕ್ಯಾನ್ಸಲೇಷನ್ ಆಫ್ ಬೇಲಿಗೆ ಬಂದಿದ್ದೀರಾ?
My lord. Yes.
ಆಯ್ತು.
Second FIR crime number 281/2020, my lord. But ಅವ್ರು ಏನ್ ಮಾಡಿದ್ದಾರೆ ಅಂದ್ರೆ ಅಲ್ಲಿ 21/11/2020 ಅಲ್ಲಿ ಬಿ ರಿಪೋರ್ಟ್ ಹಾಕ್ಸ್ಬಿಟ್ಟು 27/11 ಅಲ್ಲಿ 2020 ಅಲ್ಲಿ ಅವರು ಬೇಲ್ ತಗೊಂಡಿದ್ದಾರೆ ಸ್ವಾಮಿ. ಬಟ್ ಅದು ನಮ್ ಗಮನಕ್ಕೆ ಬರ್ದೇ ಇರೋದಕ್ಕೆ ಅದು ರಿಜೆಕ್ಟ್ ಆಗಿ ಅಲ್ಲಿ ಫೈನ್ ಹಾಕಿದ್ದಾರೆ ಸ್ವಾಮಿ. ಸೊ ಇವಾಗ ಥರ್ಡ್ FIR ಆಗಿದೆ ಸ್ವಾಮಿ. ಕ್ರೈಮ್ ನಂಬರ್ 203/2023. ಅವ್ರಿಗೆ ತಿರ್ಗಾ ಮತ್ತೆ ಒಂದು
ಆಯ್ತು. ಬೇಲ್ ಗ್ರಾಂಟ್ ಮಾಡುವಾಗ ಏನೇನ್ ಕಂಡೀಷನ್ ಇದೆ? ಎಲ್ಲಿದೆ ಆರ್ಡರ್? ಬೇಲ್ ಆರ್ಡರ್?
ಬೇಲ್ ಕಂಡೀಷನ್ಸ್ ವೈಲೇಷನ್ ಆಗಿದೆ ಮೈ ಲಾರ್ಡ್.
ಅರ್ಲಿಯರ್ ಆರ್ಡರ್ ಎಲ್ಲಿದೆ? ಬೇಲ್ ಅದು ರಿಜೆಕ್ಟ್ ಅದು ಇತ್ತು ಮೇಡಮ್. ಕ್ಯಾನ್ಸಲೇಷನ್ ಆಫ್ ಬೇಲ್ ರಿಜೆಕ್ಟ್ ಮಾಡಿರೋದು ಆನ್ ಕಾಸ್ಟ್ ಆಫ್ ₹25,000. ಅರ್ಲಿಯರ್ ಬೇಲ್ ಆರ್ಡರ್ ಎಲ್ಲಿದೆ? ಬೇಲ್ ಗ್ರಾಂಟ್ ಮಾಡಿದಾಗ ಪಾಸ್ ಮಾಡಿದ ಆರ್ಡರ್ ಎಲ್ಲಿದೆ ಮೇಡಮ್?
ಮೈ ಲಾರ್ಡ್ ಅದರಲ್ಲಿ
ಯು ಆರ್ ಟೆಲ್ಲಿಂಗ್ ದಟ್ ದೇರ್ ಇಸ್ ಎ ವೈಲೇಷನ್.
Yes, my lord.
Ah,
Page annexure B, page number 29, my lord.
29.
Case number 6/34/2020. ಅವರು ಸೆಷನ್ಸ್ ಕೋರ್ಟ್ ಅಲ್ಲಿ ಬೇಲ್ ತಗೊಂಡಿರೋ ಕಾಪಿ ಮಾಡಿ.
ಸೆಷನ್ಸ್ ಕೋರ್ಟ್ ಅಲ್ಲೇ ಬೇಲ್ ಆಯ್ತು.
ಎಸ್ ಮೈ ಲಾರ್ಡ್.
ಆಯ್ತು.
438 ಕೇಳಿ.
438.
ಎಸ್ ಮೈ ಲಾರ್ಡ್.
ಹಾ. ಈ ಕೇಸಿಗೆ ಸಂಬಂಧಪಟ್ಟಂತೆ.
ಎಸ್ ಮೈ ಲಾರ್ಡ್.
ಏನ್ ಅಫೆನ್ಸಸ್ ಏನು?
ಅಫೆನ್ಸ್ ಮೈ ಲಾರ್ಡ್.
354, 420, 448, 504, 506.
120, 448, 420, 354 my lord.
ಬೇಲ್ ಕಂಡೀಷನ್ ಏನ್ರಿ?
Bail conditions, my lord.
46.
My lord.
36.
36 page number, my lord.
ಹಾ.
He shall not direct or the indirectly hold out, threaten the prosecution or witness ಅಂತ ಇದೆ, my lord.
ಹಾ.
Second, fourth bail condition shall not temper the prosecution or witness or any manner shall not intimated to the complainant.
ಆಯ್ತು.
Condition number 5 shall not commit similar offense or the any offense during to the pendency of this case ಅಂತ ಇದೆ ಸ್ವಾಮಿ. ಸ್ವಾಮಿ ಇದ್ರಲ್ಲಿ ಲಾಸ್ಟ್ ಅವರು ಥರ್ಡ್ FIR ಹಾಕಿದ್ದಾರೆ ಸ್ವಾಮಿ. ಪೇಜ್ ಥರ್ಡ್ FIR ಹಾಕಿದ್ದಾರೆ.
3 FIR.
ಹಾ, ಎಸ್ ಮೈ ಲಾರ್ಡ್. ಪೇಜ್ ನಂಬರ್ 65 ಮೈ ಲಾರ್ಡ್.
FIR at whose instance?
ಎಸ್ ಮೈ ಲಾರ್ಡ್.
FIR at whose instance? Third FIR.
3/2023 my lord. 203/2023.
ಕಂಪ್ಲೇಂಟ್ ಕೊಟ್ಟವ್ರು ಯಾರು?
Ravikumar V my lord. Same as
ಸೇಮ್ ಕಂಪ್ಲೇಂಟ್.
Same complainant my
ನಿಮ್ಮ
lord.
ಉದ್ದೇಶ ಅದೇ
Same
ಇರ್ಬೇಕು.
accused, same complainant.
ನಿಮ್ಮ ಉದ್ದೇಶ ಅದೇ ಇರ್ಬೇಕು. ಮೂರನೇ ಕಂಪ್ಲೇಂಟ್ ಕೊಟ್ಟು
My
ಕೇಸ್
lord,
ಕ್ಯಾನ್ಸಲ್
ಏನು
ಮಾಡ್ತಾರೆ.
ಅಂತಂದ್ರೆ ಪ್ರತಿ ಸರಿನೂ ಅವ್ರ ಮನೆಯಲ್ಲಿ ರೆಂಟಿಗೆ ಇರೋ ಕಾರಣಕ್ಕೆ ಪ್ರತಿ ಸರಿನೂ ಅವರು ಥ್ರೆಟ್ ಮಾಡ್ತಾನೆ ಹೋಗ್ತಾ ಇದ್ದಾರೆ ಸ್ವಾಮಿ. ಬದುಕಕ್ಕೂ ಬಿಡ್ತಾ ಇಲ್ಲ ಈ ತರ.
ಬೇರೆ ಯಾವ್ದಾರ ಏನಾರು ಕಂಪ್ಲೇಂಟ್ ಹೇಳ್ರಿ. ಕಂಪ್ಲೇಂಟ್ ಯಾರು ಬೇರೆಯವ್ರು ಏನಾರು ಕೊಟ್ಟಿದಾರಾ?
ಇಲ್ಲ.
ನೀವು ಕಂಡೀಷನ್ ಹಾಕಿರೋದ್ನ ಅದಕ್ಕೋಸ್ಕರ ಮತ್ತೊಂದು ಕಂಪ್ಲೇಂಟ್
ನೋ ಮೈ ಲಾರ್ಡ್. ಇದ್ರ ಅವ್ರ ಮನೇಲಿ ಇದಾರೆ ಅನ್ನೋ ಕಾರಣಕ್ಕೆ ಅವ್ರ ಮನೆ ಬಿಟ್ಟು ಹೋಗ್ಲಿ ಅನ್ನೋ ಕಾರಣಕ್ಕೆ ಥ್ರೆಟ್ ಮಾಡ್ತಾ ಇದ್ದಾರೆ ಸ್ವಾಮಿ. ನೋಡಿ ಸ್ವಾಮಿ, ಇದ್ರಲ್ಲಿ ಬೇಕಂತ ಕಂಪ್ಲೇಂಟ್ ಕೊಡಕ್ಕೆ ಏನಿದೆ? ಅವ್ರು ಪ್ರತಿ ಸಾರಿನೂ ಆ ತರ ಮಾಡ್ತಾ ಇದ್ದಾರೆ. 67 ಇದೆ ಸ್ವಾಮಿ ಪೇಜ್ ನಂಬರು. FIR ಅಲ್ಲಿ 3, 4 and 5 ಕಂಡೀಷನ್ಸ್ ನ ಉಲ್ಲಂಘನೆ ಮಾಡಿದ್ದಾರೆ ಅಂತಾನೆ FIR ಹಾಕಿದ್ದಾರೆ ಸ್ವಾಮಿ. ನೀವು ಪರ್ಮಿಷನ್ ಕೊಟ್ರೆ ನಾನು ಒಂದ್ ಸ್ವಲ್ಪ ರೀಡ್ ಮಾಡ್ತೀನಿ.
ಆಯ್ತು, ಓದಿ.
ಮಾನ್ಯ ನ್ಯಾಯಾಲಯ PCR ನಂಬರ್
ಪೇಜ್ ಹೇಳ್ಬೇಕು ನೀವು ಎಲ್ಲಿ ಓದ್ತಾ ಇದ್ದೀರಾ?
67 my lord.
67.
Yes my lord.
ಹೇಳಿ.
ಮಾನ್ಯ ನ್ಯಾಯಾಲಯ PCR ನಂಬರ್ 5942/2023 ದಾವೆಯ ಸಾರಾಂಶವೇನೆಂದರೆ, ಫಿರ್ಯಾದಿದಾರರು ಶ್ರೀ ರವಿಕುಮಾರ್ V ರವರು ಈ ಹಿಂದೆ ಮಾನ್ಯ 7 ACCM ನ್ಯಾಯಾಲಯದಲ್ಲಿ PCR ನಂಬರ್ 1906/2020 ದೂರಿನಲ್ಲೇ ಕಟ್ಟುತ್ತಿರುವ ಬಿಲ್ಡಿಂಗ್ ಮನೆಯನ್ನು ತೋರಿಸಿ ಈ ಮನೆಯನ್ನು ಲೀಸಿ ಕೊಡುವುದಾಗಿ ಹೇಳಿ 5 ಲಕ್ಷ ರೂಪಾಯಿಗಳನ್ನು ಫಿರ್ಯಾದಿದಾರರಿಂದ ಪಡೆದುಕೊಂಡು ವಾಪಸ್ಸು ಕೊಡದೆ ಸತಾಯಿಸಿ ನಂತರ ದಿನಾಂಕ 7/1/2020 ಫಿರ್ಯಾದಿದಾರರ ಮೇಲೆ ಮತ್ತು ಇತರ ಅವರ ಹೆಂಡತಿಯ ಮೇಲೆ ಜಗಳ ಮಾಡಿ ಬಗ್ಗೆ ಆರೋಪಿಗಳಾದ ತಿಮ್ಮ ಹನುಮಯ್ಯ, ಕೃಷ್ಣಪ್ಪ, ಕೃಷ್ಣವೇಣಿ, ಜಗದೀಶ್, ಜನಾರ್ದನ್ ಇವರುಗಳ ವಿರುದ್ಧ ಫಿರ್ಯಾದಿದಾರರು ದಾವೆಯನ್ನು ನೀಡಿದ ಮೇರೆಗೆ ನಂದಿನಿ ಲೇಔಟ್ ಪೊಲೀಸ್ ಠಾಣೆಯಲ್ಲಿ ಮೊಕದ್ದಮೆ ಸಂಖ್ಯೆ 69/2020 ಕಲಂ 110, 504, 506, 448, 120B, 420, 354 of IPC ರೀತಿಯ ದೂರು ದಾಖಲಾಗಿದ್ದು, ಈ ಕೇಸಿನಲ್ಲಿ ಆರೋಪಿಗಳು ಮಾನ್ಯ CCH 46 ನ್ಯಾಯಾಲಯದಲ್ಲಿ ಕ್ರಿಮಿನಲ್ ಮಿಸ್ಲೇನಿಯಸ್ ನಂಬರ್ 6/34/2020 ರಲ್ಲಿ ಆರೋಪಿಗಳ ಷರತ್ತುಬದ್ಧ ಜಾಮೀನು ನೀಡಿದ್ದು, ಈ ಪ್ರಕರಣದಲ್ಲಿ CC ನಂಬರ್ 12365 2022 ಮಾನ್ಯ ನ್ಯಾಯಾಲಯದಲ್ಲಿ ವಿಚಾರಣೆಯಲ್ಲಿರುವಾಗಲೇ ಜಾಮೀನು ಷರತ್ತುಗಳನ್ನು 3, 4, 5ರಲ್ಲಿ ಷರತ್ತುಗಳನ್ನು ಉಲ್ಲಂಘನೆ ಮಾಡಿ ಆರೋಪಿಯಾದ ತಿಮ್ಮ ಹನುಮಯ್ಯವನ್ನು ಈತರು ದಿನಾಂಕ 27/2/2023 ಬೆಳಿಗ್ಗೆ 9 ಗಂಟೆ ಸಮಯದಲ್ಲಿ ಫಿರ್ಯಾದಿದಾರರು ತಮ್ಮ ಮನೆಯಲ್ಲಿ ಇರುವಾಗಲೇ ಫಿರ್ಯಾದಿದಾರರ ಮನೆಗೆ ಅತಿಕ್ರಮಣ ಪ್ರವೇಶ ಮಾಡಿ ಫಿರ್ಯಾದಿದಾರರನ್ನು ಉದ್ದೇಶಿಸಿ, ನೀನು ನನ್ನ ವಿರುದ್ಧ ಹಾಕಿರುವ 9ನೇ ACCM ನ್ಯಾಯಾಲಯದಲ್ಲಿರುವ CC ನಂಬರ್ 12365/2020 ಕೇಸನ್ನು ವಾಪಸ್ಸು ತೆಗೆದುಕೊಳ್ಳುವುದಿಲ್ಲ ಎಂದರೆ ನಿನ್ನ ಜೀವನವನ್ನು ಅಂತ್ಯ ಮಾಡುತ್ತೇನೆ, ನೀನು ಈ ಕೇಸಿನಲ್ಲಿ ಸಾಕ್ಷ್ಯವನ್ನು ನೀಡಲು ಬದುಕಿರುವುದಿಲ್ಲ ಎಂದು ಬೆದರಿಕೆ ಹಾಕಿರುತ್ತಾರೆಂದು ಮಾನ್ಯ ನ್ಯಾಯಾಲಯದಲ್ಲಿ ಆರೋಪಿತನಾದ ತಿಮ್ಮ ಹನುಮಯ್ಯನವರ ವಿರುದ್ಧ ಹಾಕಿಕೊಂಡ PCR ದಾವೆ ಅಂತ ಇದೆ ಸ್ವಾಮಿ. ಇವರು ಇನ್ನೂ ಸ್ವಾಮಿ 2020 ಮ್ಯಾಟ್ರು ಇನ್ನೂ ಎವಿಡೆನ್ಸ್ ಆಗಿಲ್ಲ ಸ್ವಾಮಿ. ಎವಿಡೆನ್ಸ್ ಆಗಕ್ಕೆ ಬಿಡ್ತಾ ಇಲ್ಲ ಸ್ವಾಮಿ. ಪ್ರತಿ ಸಾರಿನೂ ಅವ್ರಿಗೆ ಬ್ರತ್ ಮಾಡೋದು ಸ್ವಾಮಿ. ಅವ್ರ ಮನೆಯಲ್ಲಿ ರೆಂಟ್ ಇರೋದು ಅನ್ನೋ ಕಾರಣಕ್ಕೇನೆ ಮನಿ ಖಾಲಿ ಮಾಡ್ಕೊಂಡು ಹೋಗು, ಇಲ್ಲ ಅಂದ್ರೆ ನೀನ್ ಬದುಕಕ್ ಬಿಡಲ್ಲ, ನಮ್ಮ ಮೇಲೆ ಕೇಸ್ ಹಾಕ್ತೀಯಾ ಅಂತ ಸ್ವಾಮಿ. ಇವ್ರು ಯಾರು ಅಂದ್ರೆ ಒಬ್ರು MLA ಇದ್ದಾರೆ, ಅವ್ರ ಇನ್ಫ್ಲೂಯೆನ್ಸ್ ಪರ್ಸನ್ ಮೈಲೋಡಿರು ತುಂಬಾ ಟಾರ್ಚರ್ ಮಾಡ್ತಾ ಇದಾರೆ ಸ್ವಾಮಿ. ಮನೇಲಿ ಇರಕ್ಕೆ ಬಿಡ್ತಾ ಇಲ್ಲ. 2 ಹೆಣ್ಮಕ್ಳು ಅವ್ರ ಹೆಂಡತಿ ಇದಾರೆ ಸ್ವಾಮಿ. ಮನೆಯಲ್ಲಿ ಅವ್ರ ಅಳಿಯನ್ನ ಕಳ್ಸಿಬಿಟ್ಟು ಸೀಮೆ ಎಣ್ಣೆ ಹಾಕಕ್ಕೆ ಅವ್ರ ಮನೆ ಕಳ್ಸಿದ್ರು ಸ್ವಾಮಿ. ಅವನು ಡ್ರಿಂಕ್ ಮಾಡ್ಕೊಂಡು ಅವ್ರ ಮನೆ ಹತ್ರ ಹೋಗ್ಬಿಟ್ಟು ಅವ್ರಿಗೆ ತುಂಬಾ ಟಾರ್ಚರ್ ಮಾಡಿದ್ದಾರೆ. ಈ ತರ ಪ್ರತಿಯೊಂದು ಸಾರಿನೂ ಅವ್ರಿಗೆ ಟಾರ್ಚರ್ ಮಾಡ್ತಾ ಇದಾರೆ ಸ್ವಾಮಿ. ಅವ್ರನ್ನ ದಾರಿಯಲ್ಲಿ ಓಡಾಡಕ್ಕೂ ಬಿಡ್ತಾ ಇಲ್ಲ. ಚಾರ್ಜ್ ಶೀಟ್ ಮೈ ಲಾರ್ಡ್. ಫೈಲ್ ಚಾರ್ಜ್ ಶೀಟ್ ಮೈ ಲಾರ್ಡ್.
ಈ ಸಬ್ಸಿಕ್ವೆಂಟ್ FIR ಮೇಲೆ ಚಾರ್ಜ್ ಶೀಟ್ ಹಾಕಿದೆಯಾ?
3/2023 FIR ಗೆ ಚಾರ್ಜ್ ಶೀಟ್ ಫೈಲ್ ಆಗಿದೆ ಸ್ವಾಮಿ. ಸ್ವಾಮಿ 83 ಪೇಜ್ ನಂಬರ್ ಈ ಸಾಕ್ಷಿಯಲ್ಲಿ ನೀಡಲು ಬರುತ್ತಿಲ್ಲವೆಂದು ಸಾಕ್ಷಿ 1 ರವರಿಗೆ A1 ಆರೋಪಿಯು ಬೆದರಿಕೆ ಹಾಕಿರೋದು ತನಿಖೆಯಿಂದ ದೃಢಪಟ್ಟಿರುತ್ತದೆ ಅಂತ ಹೇಳಿದ್ದಾರೆ ಸ್ವಾಮಿ ಇದ್ರೆ ಲಾಸ್ಟ್ ಲೈನ್ ಮೇಲೆ ಸ್ವಾಮಿ ಈ ತರ ನೆಕ್ಸ್ಟ್ ಅವರು ಎವಿಡೆನ್ಸ್ ಕೊಡಕಂತ ಹೋದಾಗ ಮೈಲಾರ್ಡ್ ಅವ್ರಿಗೆ ತಿರ್ಗಾ ಮತ್ತೆ ಮ್ಯಾಜಿಸ್ಟ್ರೇಟ್ ಕೋರ್ಟ್ ಅಲ್ಲಿ ಧಮಕಿ ಹಾಕಿದ್ದಾರೆ ಸ್ವಾಮಿ ತಿರ್ಗಾನು ಮತ್ತೆ FIR ಆಗಿದೆ ಹಲ್ಸೂರ್ ಗೇಟ್ ಪೊಲೀಸ್ ಸ್ಟೇಷನ್ ಅಲ್ಲಿ ಕೈಂಡ್ಲಿ ಮೆಮೊ ಫೈಲ್ ದಿ ಮೆಮೊ ಮೈಲಾರ್ಡ್ ಇನ್ನೊಂದು FIR ಆಗಿದೆ ಮೈಲಾರ್ಡ್ FIR ನಂಬರ್ 116/2024 ಪ್ರತಿ ಸಾರಿನೂ ಅವ್ರಿಗೆ ಇಷ್ಟು ಟಾರ್ಚರ್ ಮಾಡ್ತಾ ಇದ್ದಾರೆ ಸ್ವಾಮಿ ಬದುಕಕ್ಕೂ ಬಿಡ್ತಾ ಇಲ್ಲ ದಾರಿಯಲ್ಲಿ ಓಡಾಡಕ್ಕೂ ಬಿಡ್ತಾ ಇಲ್ಲ ಅವರು ವಾಚ್ಮ್ಯಾನ್ ಮೈಲಾರ್ಡ್ ಹಾಸನಿಂದ ಬಂದು ಇಲ್ಲಿ ಬೆಂಗಳೂರಲ್ಲಿ ಕೆಲಸ ಮಾಡ್ಕೊಂಡು ಏನೋ ಒಂದು ಆಸೆಗೆ ಮನೆ ಲೀಸ್ಗೆ ಹಾಕೊಂಡು ಸ್ವಲ್ಪ ಬದುಕಬೇಕು ಅಂತ ಅವ್ರಿಗೆ 5 ಲಕ್ಷ ರೂಪಾಯಿ ಕೊಟ್ಟಿದ್ದಾರೆ ಸ್ವಾಮಿ ಮನೆ ಬಾಡಿಗೆನು ಕೊಟ್ರು ಎಲ್ಲಾ ಈ ತರ ಮಾಡಿ ಅವ್ರಿಗೆ ಬದುಕಕ್ಕೂ ಬಿಟ್ಟಿಲ್ಲ ಅವ್ರ ದುಡ್ಡು ತಗೊಂಡು ಅವ್ರಿಗೇನೆ ಬೆದರಿಕೆ ಹಾಕ್ತಾ ಇದ್ದಾರೆ ಸ್ವಾಮಿ ಕೈಂಡ್ಲಿ ಕ್ಯಾನ್ಸಲ್ ದಿ ಬೇಲ್ ಮೈಲಾರ್ಡ್ ಈ ಹಿಂದೆ ತಮ್ಮ ಮುಂದೆನೆ ಬಂದಿತ್ತು ಮೈಲಾರ್ಡ್ ಇದ್ರಲ್ಲಿ ಇವ್ರು ಏನ್ ಮಾಡಿದ್ದಾರೆ ಅಂತಂದ್ರೆ ಅದ್ರಲ್ಲಿ ಇನ್ಸ್ಪೆಕ್ಟರ್ಗೆ ಹೇಳ್ಬಿಟ್ಟು ಬಿ ರಿಪೋರ್ಟ್ ಹಾಕ್ಸ್ಕೊಂಡ್ಬಿಟ್ಟು ಬೇಲ್ ತಗೊಂಡಿದ್ದಾರೆ ಮೈಲಾರ್ಡ್ ಅದು ನಮ್ ಗಮನಕ್ಕೆ ಬರ್ದೇ ಇರೋ ಕಾರಣಕ್ಕೆ ಅದು ರಿಜೆಕ್ಟ್ ಆಗಿ ಫೈನ್ ಹಾಕಿದ್ವಿ ತಮ್ಮ ಮುಂದೆನೆ ಇತ್ತು ಮೈಲಾರ್ಡ್
What is the status of the case before the trial court? First case.
ಮೈಲಾರ್ಡ್
First case ಅಲ್ಲಿ ಏನಾಗಿದೆ ಸ್ಟೇಟಸ್ ಏನೀಗ?
ಫಸ್ಟ್ ಕೇಸ್ ಅಲ್ಲಿ ಮೈಲಾರ್ಡ್ ಅದ್ರಲ್ಲಿ ಚಾರ್ಜ್ ಶೀಟ್ ಆಗಿದೆ ಚಾರ್ಜ್ ಆಗಿ
ಆಯ್ತು ಅದೆಲ್ಲ PCR ಹಾಕಿದ್ರಿ ಕೇಸ್ ರಿಜಿಸ್ಟರ್ ಆಯ್ತು ಈ ಕೇಸ್ ನಡೀತಾ ಇದೆ ಏನು ಟ್ರಯಲ್ ಯಾವ ಸ್ಟೇಜ್ ಅಲ್ಲಿ ಇದೆ?
ಸ್ಟೈಲ್ ಎವಿಡೆನ್ಸ್ ಇದೆ ಮೈಲಾರ್ಡ್ ಇನ್ನು
ಎವಿಡೆನ್ಸ್ ಕಮೆಂಟ್ಸ್ ಆಗಿಲ್ವಾ?
ಎವಿಡೆನ್ಸ್ ಆಗಿಲ್ಲ ಸ್ವಾಮಿ ಇನ್ನು
Okay, why you have not led evidence?
ಮೈಲಾರ್ಡ್ ಇವ್ರು ಪ್ರತಿ ಸರಿನೂ ಅವ್ರಿಗೆ ಥ್ರೆಟ್ ಮಾಡ್ತಾ ಅವ್ರು ಹಾಸ್ಪಿಟಲೈಸ್ ಆಗಿದ್ರು ಸ್ವಾಮಿ ಅವರು ಈ ಹಿಂದೆ ಅದನ್ನ ಬೇಕು ಡಾಕ್ಯುಮೆಂಟ್ಸ್ ನಾನು ಸಬ್ಮಿಟ್ ಮಾಡ್ತೀನಿ ಮೈಲಾರ್ಡ್.
Madam, you get
One
the
time
report
ಕೊಟ್ಟು.
from the concerned police. Now there are 2 cases are registered against him. One ಯಾವಾಗ ಖಾಲಿ ಮಾಡ್ತೀವಿ ಅಂತ ಹೇಳಿದಾರೆ? ಯಾರು ಅಂಡರ್ಟೇಕ್ ಮಾಡಿರೋದು? ಅವ್ರೇನು?
ಅವ್ರಿಗೆ ಬಂದು ಎವಿಡೆನ್ಸ್ ಕೊಡೋದಿಲ್ಲ ಜಸ್ಟ್ ಕೋರ್ಟ್ ಹತ್ರ ಹೋಗ್ತಕ್ಕಂಥದ್ದು ಇಲ್ಲಿ ಬಂದು ನಮ್ಗೆ ಎದುರಿಸ್ತಂತೆ ಅದೊಂದು ಕಂಪ್ಲೇಂಟ್ ಕೊಡುವಂಥದ್ದು. ಇಲ್ಲಿ ಎವಿಡೆನ್ಸ್ 2020 ಮಾಡಿ is not attained to the witness bar still. Only to create the problem ಏನಂದ್ರೆ ಬೇರೆಯವ್ರಿಗೆ ಯಾರೋ 5 ಲಕ್ಷ ಕೊಟ್ಟಿದ್ದಾರೆ ಇವ್ರ ಮುಖಾಂತರ ಅದನ್ನ ವಸೂಲಿ ಮಾಡಕ್ಕೋಸ್ಕರ ಈ
ಒಂದ್ ನಿಮಿಷ ಮೇಲೆ ನಾವು ಬೇರೆಯವ್ರು ಯಾರಿಗೂ ದುಡ್ಡು ಕೊಟ್ಟಿಲ್ಲ
ಆಯ್ತು
ಸರ್ ಮನೇಲಿ ಇರೋ
ಚಾರ್ಜ್ ಶೀಟ್ ಅಲ್ಲಿ ಯಾರ್ಯಾರು ವಿಟ್ನೆಸಸ್ ರೀ?
ಅವ್ರ ಬ್ರದರ್ ಮತ್ತೆ ಅವ್ರ ವೈಫ್ ಸ್ವಾಮಿ ಯಾಕಂದ್ರೆ ಮನೆಯಲ್ಲಿ ಬಂದು ಅವ್ರ ಮನೆಯಲ್ಲಿ
ಇಲ್ಲ
ಬೇರೆ ಯಾರು ನೋಡಿಲ್ಲ ಸ್ವಾಮಿ ಅವ್ರ ಮನೆಯಲ್ಲಿ ಇರುವಾಗಲೇ ಅವ್ರ ಮನೆಯಲ್ಲೇ ಲೀಸ್ಗೆ ಅವ್ರ ಮನೆಯಲ್ಲೇ ರೆಂಟ್ಗೆ ಇರೋ ಕಾರಣಕ್ಕೆ
ಆಯ್ತು go and give evidence before the trial court.
ಸೊ ಅದ್ರಗೋಸ್ಕರ ಅವರು CC ಕ್ಯಾಮ್ರಾನು ಹಾಕೊಂಡಿದ್ದಾರೆ ಮೈಲಾರ್ಡ್ ಮನೆ
Go and give evidence before the trial court in first matter. Third, heard the petitioner counsel and also the counsel appearing for the respond number 2. The present petition is filed for cancellation of bail granted in favor of ನೀವು ಆ ಕೋರ್ಟಲ್ಲಿ ಹಾಕೋಬೇಕಿತ್ತಲ್ವಾ?
ಸ್ವಾಮಿ ಹಾಕಿದೀವಿ ಅಲ್ಲೇ ಹಾಕಿದೀವಿ
Reject ಆಗಿದೆ.
ಆಗಿದೆ ಅದು
118.
Only for purpose of cancelling the bail, entire awareness ಮಾಡಿರ್ತಕ್ಕಂಥದ್ದೇ cancellation of bail ಆಗಿರ್ತದೆ awareness ಮಾಡಿ
PCR ಹಾಕಿದ್ದು. ಫಸ್ಟ್ ಕೇಸನ್ನು PCR ಮೇಲೆನಾ ಅಥವಾ
ಎಸ್ ಮೈಲಾರ್ಡ್ 3
ಎಲ್ಲ
ಕೇಸಸ್
PCR.
ಆರ್ PCR ಮೈಲಾರ್ಡ್
PCR number 5 in court. Yes, only many reason to give the police complaint against the Maya ಕೊಟ್ಟಿರ್ತಕ್ಕಂಥದ್ದು for cancellation of bail.
ಎಸ್ ಮೈಲಾರ್ಡ್ ಥ್ರೆಟ್ ಮಾಡಿದೆ ಅವ್ರೇನೆ ಅವ್ರ ಮನೆಗೆ ಹೋಗಿ ಅವರು ಮತ್ತೆ ಅವ್ರ ಅಳಿಯನೇ
ಆಯ್ತು.
ಮಾಡಿದ್ದು ಮೈಲಾರ್ಡ್ ಬೇಲ್ ಕಂಡೀಷನ್ ವೈಲೇಷನ್ ಆಗಿದೆ ಅಂತ ಅವರು ಕ್ಲಿಯರ್ ಆಗಿ ಮೆನ್ಷನ್
Allow
ಮಾಡಿದ್ದಾರೆ
me to dictate the order. Both. Heard the petitioner counsel and also the counsel appearing for the respondent. The petitioner has approached this court, praying this court to cancel the bail granted in favor of the respond number 2.
ಸ್ವಾಮಿ ಅವ್ರು
in
ಹಿಂಗೆ ಥ್ರೆಟ್
contention of the
ಮಾಡ್ತಾ ಇದ್ರೆ
counsel
ಅವ್ರು ಎಲ್ಲಿಗೆ
that-
ಹೋಗ್ಬೇಕು ಹೇಳಿ
Particularly
Legal
while
justice
granting the bail, impose the conditions. Condition number 3, 4, 5. And this court and the trial court while granting anticipatory bail impose the condition that he shall not directly or indirectly hold out threats to the prosecution witnesses or lure them in any manner. Next, he shall not tamper with prosecution witnesses in any manner. He shall not intimidate the complainant. 5. He shall not commit similar offences or any offence during the pendency of the case. Counsel of referring these conditions would vehemently contend that the respondent number 2 violated the conditions and specific complaint was given causing threat to the complainant, and police have registered the FIR and FIR based on the direction of the trial court, based on the magistrate referring the matter under section 156(3) and investigated the matter and filed the charge sheet, and once again caused the threat, and hence one more complaint was given and FIR was registered against the respondent number 2, and hence it is a fit case to cancel the bail granted in favor of the respondent number 2. The counsel also vehemently contend that when the application was filed before the trial court for cancellation and the same was also not considered in a proper perspective and requires to be interfered and to cancel the bail. Purport, the counsel appearing to the respondent would contend that earlier also this court in criminal petition number 2567 of 2021 connected with criminal petition number 2579 of 21 dismissed the similar petition with a cost of rupees 25,000. Also, counsel would submit that having developed the habit of filing false complaint and before the court and getting the matter referred to the police and filing of charge sheet, and counsel also would submit that in the said charge sheet the wife and brother are the witnesses and there are no any independent witnesses. And also once again given the complaint and causing threat to the respondent, and no grounds are made out and not violated any conditions and not threatened at any point of time. And these are the complaints are also filed at the instance of the respondent number 2 only, and no any other independent persons have lodged any complaint, and the complaint is only filed in keeping the conditions imposed by the trial court, particularly condition number 3 to 5. Hence no grounds are made out. Having heard the petitioner counsel and also the counsel appearing for the respondent, and no doubt the trial court granted an anticipatory bail in favor of respondent number 2, and also condition number 3 to 5 was also imposed. And counsel appearing for the petitioner also brought to notice of this court the other PCR also filed against the respondent, and the same was referred for the investigation, and police have investigated the matter and filed the charge sheet. The counsel appearing to the respondent also brought to notice of this court the witnesses in respect of additional other charge sheet is also wife and brother, and other FIR is also registered having caused the threat, and records also discloses that there are 3 complaints against the respondent number 2. And counsel appearing to the respondent number 2 also brought to notice of this court that this petitioner has already undertaken in the CRP filed before this court that he is going to vacate the premises in the month of January 2025. And in the meanwhile, complainant is filing this complaint before the court and harassing the respondent number 2. Having taken note of the setback into consideration as well as the subsequent charge sheet is also, the petitioner also not disputes the fact that witnesses are only the wife and brother and no other independent witnesses, and when such material available before the court, and also The issue is also with regard to the having collected an amount of rupees 5 lakh, a case was registered. And admittedly, the petitioner is the tenant,
Yes.
tenant of the respondent number 2. And when undertaking was also given to quit and vacate the premises in the month of January 2025. And having considered the relationship between the parties as tenant and owner. And this court already dismissed similar application by imposing the cost. Hence, I do not find any ground to once again cancel the in keeping. The offences are also alleged against the respondent number 2. And hence no ground is made out to cancel the bail invoking under section 439(2) of CRPC. In view of the discussions made up, I pass the following order. Dismissed.
80. Virana Sikki.
Next week, my. Next week, my. Check up on.
Respondent number 2 idara? Issue notice against respondent number 2 through court, and also the additional SPP is directed to serve the notice on respondent number 2 through IO also. This matter after vacation.
After vacation, madam.
R1 ಇನ್ನು ಆಗಿಲ್ಲ ಟೇಕ್ ನೋ additional SPP is directed to take notice for R1. 2 ವಾರ ಬಿಟ್ಕೊಡಿ ಬಿಫೋರ್ ವೆಕೇಶನ್ ಅದು ನೆಕ್ಸ್ಟ್ 11th ಬೇಡ 18-12 ಆಯ್ತು ನೋಟಿಸ್ ಹೋಗಿ ಜಾರಿಯ ಬರ್ಬೇಕಲ್ಲ 18-12
Started in admission
Started
81.
Kumara.
Kumar.
ಏನ್ರಿ revision petition?
My lords, this is a matter that pertains to that BMTF, my lords. My lords had heard this matter at quite a length, my lords, when the interim order was passed. Interim order was passed on 5th March 2024. It contains the 3 contentions that we had urged, my lords. One is with regard to the power and jurisdiction of BMTF, which had not been extended post 2013. That was the first aspect, my lords. Then we also pointed out, so far as a court which deals with land grabbing, it does not even have jurisdiction to try offences under 420, my lords. And third is, while taking cognizance, there's absolute no application of
Respondent side have produced
waivers
the
of
documents.
Illa, my lords. What they have produced is, now, my lords, between 2013 till 2020, there's no notification at all. Now, a notification that has been produced before the court is of the year 2020, where, my lords, they say there was an extension for 2 years. Now, if the power and jurisdiction has not been extended, my lords, here the notification only speaks about the certain staff members being put into it. So, my lords, in fact, my reliance was on 9 decisions which my lords had seen in detail, my lords.
While passing the interim order, I have
Yes, my lords.
considered those.
All those, and
citations.
even after that, my lords, the matter came after that. And my lords, I had given a complete set of memo of citations. My lords has that, my lords. One memo of citations.
On what date?
Date ಹಾಕಿಲ್ಲ.
ಮೇಡಮ್ ಅದ್ರ ಜೊತೆ ಇದೆ.
ಯಾವ date ಕೊಟ್ಟಿದ್ದು?
ಅಪೀಲು ವಕಾಲತ್ತು
20? Sure.
citations.
My lords, on the memo of citations, ಅದನ್ನ we have categorized it.
ಇದೆಲ್ಲ notifications ಇದೆ.
Initial, ಅಲ್ಲ, ಅದು ಬೇರೆ my lords. ಒಂದು
Government creation of
notification ಒಂದು separate ಕೊಟ್ವಿ. Citation separate ಕೊಟ್ವಿ. Notification all pertains to the constitution of BMTF and extension of its power and jurisdiction which ended on 2013. Now, post that there was no, post that, my lords, there was no extension of the power and jurisdiction. My lords get set citation sets.
Yes.
My lords, adರಲ್ಲಿ Roman number 1 in the citations itself, BMTF does not have power jurisdiction to register cases or to investigate post 18/3/2013. My lords gets that, my lords. Yeah, ಮೇಲ್ಗಡೆ first sheet ಅಲ್ಲೇ ಇದೆ. Memo of citation first sheet ಅಲ್ಲಿ.
Memo of citations ಅಂತೇನಿಲ್ಲ, but ಯಾವ್ದೋ
My lords, isn't it?
Justice Dinesh Kumar ಅವ್ರ ಆರ್ಡರ್ ಒಂದಿದೆ.
ಅದು ನಂತರ, my lords, that was last of the judgments. My lords, could I just, it's in this manner, my lords, the whole set.
ಆ ತರ ಯಾವ್ದು ಇಲ್ಲ. ಯಾವ್ದೋ ತಮೇರಿ ಸೆಲ್ವನ್ ಏನೋ ಒಂದಿದೆ. ಇಲ್ಲ ಮೇಡಮ್ ನೋಡಿ ಅದ್ರಲ್ಲಿ ಇದೆಯಾ?
ಅದೇ ಇರ್ಬೇಕು, my lords, that has the whole set.
ಅದ್ರಲ್ಲೇನೋ ಬೇರೆ ಇದೆ ನೋಡಿ, citations ಅದ್ರಲ್ಲಿ.
Adril Roman number 1, my lords, is that first point, BMTF does not have power or jurisdiction to register cases or to investigate post 18/3/2013. My lords, the judgments in that support, my lords, of the coordinate benches from 1 till 10, my lords, 10 decisions where they say that they don't have power and jurisdiction. Then on the next page, my lord, special court constituted under the Karnataka Land Grabbing Prohibition Act does not have jurisdiction to try IPS offences. Two decisions that we relied on, my lords.
IPC offenses.
IPC offences, because 420, it goes to about 7 years. Their jurisdiction is only for 3 years, my lords. So there we relied on a division bench ruling of Andhra Pradesh and one of Tamil Nadu, my lords. And on the last point, my lords, need for application of mind prior to issuance of process, my lords, we relied on this Sriram Properties. That was the case, my lords, where they upheld the act. But at the same time, my lords, they say under the act, when the court takes cognizance, there should be application of mind before the issue process. Anta. Those were the judgments that we relied on, my lords. So after all that, court wanted to know from the government, how do you say after 2013 that there is power and jurisdiction to BMTF? And the only notification which they produced, my lords, after that is one notification, which is 8/3/2022, which speaks about certain staff members being, well, they're the staff members who are appointed to this BMTF. That is all that has been produced. The notification where there's extension of power and jurisdiction post 2013 is still not produced.
That is 2011-24. Last time ಏನ ಮಾಡಿದ್ರಿ ನೀವು ಹಾಕಿದ್ರಿ ಹಾ ಎಸ್ ನೋಟಿಫಿಕೇಶನ್ ಅಲ್ಲಿ ಏನಿದೆ ಮೇಡಮ್ ಇದರಲ್ಲಿ ಇದು ಓನ್ಲಿ ಕ್ರಿಯೇಷನ್ ಆಫ್ ಪೋಸ್ಟ್
Good. ಇನ್ನೂ ಇದೆ. ನಮ್ದ್ರಲ್ಲಿದೆ. I think that's it.
And investigate the matter also in this protecting the government land. 1996.
That you are relying upon the proceedings of the government of Karnataka. Deal with the IPC offenses,
That is it.
Which records your lordship RTC extracts. One of the grounds of the petitioner your lordship is that there is no record as brought on by the prosecution to show that the present petitioner is not the owner of the land. One of the grounds that is urged by the petitioner your lordship. Which the RTC copies your lordship. It shows that the present petitioner is the owner of the lands which have been from the land grabbing.
Land grabbing. Same server number.
Petitioner is owner of the land. Encroachment.
So that is the extract your lordship.
What are other offences?
Could I just point? Order religion, cognizance office.
Hmm. Hmm. 70, Hmm. Hmm. The complaint discloses commission of offences only under the Indian Penal Code or under the Karnataka Police Act, then it will not be competent on the part of the BMTF to only exclusive offences ಇದ್ದಾಗ.
ಇಲ್ಲ ಮೇಲೆ jurisdiction ಇರುವುದು ಕೋರ್ಟಿಗೆ to try offences less than 3 years. So 420, if you include with anything, goes to up to 7 years. And that was what was held by the division bench of Andhra and of Chennai. So more than 3 years, court does not have the jurisdiction. But now, my lords, when order on framing charge, they include 420 also. My lords would notice page 16. 16. The court would hold it has powers.
16 of your appeal memo?
Yes, my lords, of the revision petition, order dated 12th January 2024, order on framing charge, the court holds that it has powers for 420. My learned friend is accepting the fact that the court does not have powers for 420.
Other than 420, they can proceed, alva?
No, my lords, I will just point it out, my lords. If my lords would kindly have the 3 grounds that I had taken, power and jurisdiction, because if it is held that BMTF has the power, it goes contrary to the 10 decisions of the coordinate benches. I'll just point that out. Now, my lords has one memo where I have put the 3 points for consideration along with the notifications, important notifications. My lords has that memo, my lords.
Memo dated?
My lords had it earlier. My lords saw that memo with the notifications annexed. There are 3 notifications which are annexed, important notifications, because out of that arises whether they have power or jurisdiction. I think it's 19.6, my lords.
Citations.
ನಾನೇ.
ನೋಡಿ ಅದಕ್ಕೆ ಅದಿರ್ಬೇಕು. ಕೊಡಿ. 10.4.
My lords, in that it starts with challenge to the taking of cognizance and issuance of process. First page, Ali, my lords.
This memo.
ಹೌದು, my lords. It's
ಸರ್ ಅದೇ ಬೇರೆ ಇದೆ ಬೇರೆ.
ನಂದು ನೋಡಿ.
3 notifications you have relied upon.
3 notifications. My lords.
One is 19.3.96.
Now kindly notice those notifications, my lords. So, my lords, my contention is that post 2013, there's no jurisdiction. That's a contention. 18.3.2013. After that, no jurisdiction to BMTF is my contention. Now, kindly notice the very first notification for the creation of this force. That is dated 19th March 1996. my lords would see that order portion, sanction is accorded to constitute a force to be called as a Bangalore Metropolitan Task Force. On the next page, my lords, which is the matters that they could investigate. Second paragraph. My lords, 5 special enactments, Karnataka Municipal Corporation Act, Bangalore Development Act, Karnataka Municipalities Act, Bangalore Water Supplies, and Karnataka Slum Area. Then, my lords, the paragraph after that, every person employed in the Bangalore City Corporation, the Bangalore Development Authority, or any other local authority within the Bangalore metropolitan area shall forthwith communicate to the task force any information which he may possess respecting commission or attempt to commit any offense by any person under those acts are mentioned.
Yes.
The task force shall be provided with the assistance of the reserve police by the KSRF during the critical periods of operation whenever required. The Metropolitan Task Force will be a field unit to the Urban Development Department of Government of Karnataka and work under the overall supervision and control of the Secretary, Urban Development Department. My lords, it is signed also at page 3 by the Under Secretary to the Government,
Yes.
Urban Development Department.
Yes.
My lords, post this, my lords, we have had as many as 11 notifications, my lords. But those 11 notifications then get superseded by this notification dated 2/2/2013. My lords would now kindly notice page 6, my lords, the government
2013.
order itself.
Yes.
Page 6,
Hmm.
dated 2/2/2013, paragraph 7, government is pleased to supersede all orders and notifications issued subsequent to government order 19/3/1996. So you retain the original notification and all the other notification after that gets superseded. And on the next page, my lords, it's empowered to inquire into offences pertaining to government lands and properties under the following laws in the Bangalore metropolitan area. On the next page, 5 acts are mentioned, my lords. So 5 plus the original 5. So now we have 10 enactments which comes under this force because 96 had 5 enactments plus these 5 more. BMTF can register a case and proceed with the investigation of case if the facts contained in the complaint disclose offences under special acts mentioned in GO of 1996 and those mentioned above read with or without those relevant under the Indian Penal Code and the Karnataka Police Act. If the complaint discloses commission of offences only under the Indian Penal Code or under the Karnataka Police Act, then it will not be competent on the part of BMTF to proceed with the investigation thereof. Then comes the next notification 4 days later. My lords, the next notification, my lords may notice this particular notification I read was again by the Urban Development Department. The next notification which comes 4 days later is done by the Home Department without being aware of the previous notification. My lords would get that as 6/2/2013 notification in exercise of powers conferred by clause S of section 2, declaring it as a police station, my lords, of the Code of Criminal Procedure, and in supersession of all earlier notification issued in this behalf, the government of Karnataka hereby declares the places specified in column 2 of the schedule below as police station and specify the local areas mentioned in the corresponding entries, column 3 thereof, as local areas included within the jurisdiction of these police stations. Below that, my lords, Bangalore Metropolitan Task Force shall have jurisdiction in respect of offences under Karnataka Municipal Corporation Act, Bangalore Development Act, Karnataka Municipalities Act, Karnataka Slum Dwellers, those 10 acts that we get, my lords. And this is by the Home Department without, my lords, being aware that 4 days earlier, it was the concerned department which had issued the previous notification. Now, post this, my lords, comes a series of challenges to say BMTF is not a police station and it has no power and jurisdiction post the date of 18/3/2013. Now, that is a set of judgments, my lords, which my lords may now consider. In the memo of citations, the first of the judgment, which was decided on 10/10/2013, It's a very comprehensive judgment, my lords. In my memo of citation, first judgment 10-10-2013, the relevant portion in this judgment, my lords, is at page 193, my lords. It was on a batch of matters, my lords. It went to the Supreme Court confirmed this. Page 193. In all these cases, as noticed supra, the accusation made against these petitioners is that they have either deliberately or wantonly and for extraneous consideration omitted to take action as required by law to prevent unauthorized illegal construction over private properties. Petitioners have not been accused of creating false or forged document in collusion with public and thereby loss of revenue. However, regard to the specific power and function of BMTF as narrated in various notifications, including the clarificatory notification recently issued by the government on 2/2/2013, that is the notification number 2, which I pointed out, my lords, it is clear that BMTF has no jurisdiction to register any case and investigate any offense relating to the alleged unauthorized illegal construction over private properties. No doubt, as per section 321B of KMC Act, jurisdictional officer who's proved to have failed to prevent unauthorized deviation or construction, that whole paragraph, my lords, where they say they have no power or jurisdiction. My lords, that paragraph and paragraph 20 and 21 will point the same, my lords, at page 196 and 197. This was followed, my lords, by the next decision, which my lords would get at page 206, dated 21st January 2014, page 206.
Yes.
My lords, 207, it's a very short order, my lords, 207. At the instance of a private person, Bangalore Metropolitan Task Force registered criminal case against petitioner in crime number so-and-so for offences under 217 of IPC. This court in criminal petition number so-and-so and connected matters held that the task force has no jurisdiction to register a case for offences punishable under the IPC for the reasons stated in the order in criminal petition so-and-so, and on the same terms, petition is hereby allowed. Now, my lords, this matter went up to Supreme Court. Page 209, my lords should notice 3629 of 2019, which is against the very first order of His Lordship Justice Keshav Narayana, my lords.
Yes.
Then, my lords, at page 211, the challenge against the second order of His Lordship Justice Nagmohan Das, my lords. Now, in this order, please notice, my lords, what the Supreme Court would hold. At page 213, right at the bottom, however, we are at pain, my lords should notice that portion, to note that notwithstanding notifications governing the petitioners, they proceed on wrong track. We have sufficiently indicated to the learned senior counsel appearing for the petitioner that the situation could have been remedied very easily by them, either by adopting a different process or bringing in adequate change in the existing notification or by introducing a new one. Unfortunately, this has not been done, leading to quashment of proceedings initiated without even undergoing the process of trial. We hope and trust that the petitioners would do the needful so that the violators and those who are helping them while discharging their public duties would be brought to justice. With this observation, SLPs are dismissed. Then, my lords, after that, no remedial action done by the state. Matters kept coming here for quashment. Please notice next, my lords, 215, order dated 26 September 2018. Again, in this matter, my lords, the relevant portion at page 244, paragraph 12, the court notices all the earlier notifications that are issued. 244, paragraph 12. It's a contention of the learned senior counsel that the case came to be registered on 18/4/2013, but as per the government order dated 12/9/2012, the constitution of BMTF and its tenure was from 7/12/2011 to 18/3/2013. Under the said order, 9 officers have been authorized to work with the BMTF. That whole contention comes there, my lords. And then please notice the next page, my lords. Even the learned HCGP has not made it clear that the said power of BMTF has been extended. In that light, if the entire material is scrutinized, admittedly the complaint was filed on 18/4/2013. Power of BMTF expired on 18/3/2013. Under such circumstances, it clearly goes to show that complaint which has been registered is without there being any authority. In that light, there appears to be force in the argument advanced by so-and-so that the complaint filed is liable to be quashed, and the court would quash the proceedings on that score, my lords. Thereafter, again, my lords, petitions after petitions, my lords, just one paragraph may point out again in this judgment, which is at page 259, paragraph 22. Be that as it may. Be that as it may, even as discussed above, BMTF power has not been extended after 18/3/2013. Then under such circumstance, the police officers who are working under BMTF were not having any authority to arrest and detain. As held in this order, as well as earlier orders, power of BMTF is limited and it is not having the power of general police station to take cognizance of any offense under IPC. In that light, the arrest which has been made is not justified. Hence, a person who powers with any authority thereunder, it will be wrongful detention and confinement, and as such, compensation has to be paid to the accused petitioners in this regard. And then the court would go on to direct payment of that compensation, my lords. Then, my lords, the next decision in that series would be His Lordship Justice Dinesh Kumar's judgment, my lords, page 263.
Same observation, not extended.
Yes, my lords. 263, relevant portion of that judgment, my lords, paragraph 5 ali, 269 alide. And court falls back on the previous orders, my lords. And at page 272, they say, thus it's relevant to note tenure of BMTF ended on 18/3/2013. No materials placed in this proceedings to show term of BMTF has been indeed extended. However, it is submitted that the matter with regard to power and jurisdiction is pending before the Honorable Supreme Court of India. This is the submission done. That's the orders which I have produced, my lords, to say Supreme Court dismissed it then. Then, my lords, the next judgment at 277, 4th June 2019. The relevant portion in this judgment, my lords, is paragraph 7 at page 284. Insofar as the contentions, my lords, gets it at page 284, paragraph 7. Insofar as the contention raised by learned counsel for the petitioners, touching the jurisdiction of BMTF to lay the charge sheet is concerned, coordinate bench of this court, after considering the notification, they say it expires on 18/3/2013, my lords. And the court says, even though said decision is pending, yet having regard to notification issued by the government and reasons assigned in the above order, I am in full agreement with the judgment of this court and hold BMTF is not a police station within the meaning of 2S, and it has no authority or jurisdiction to register the above case in respect of alleged offences. Paragraph 9, my lords, FIR gets quashed, and my lords may notice it is not just IPC offences, but also under the Karnataka Land Revenue Act. Paragraph 9, my lords, bottom.
Yes.
Then, my lords, again on 5th August 2019, page 288. Same, my lords, it's by the same judge. Quash the proceedings on the same score.
Yes.
And, my lords, at 295, more recently, my lords, on 22nd June 2022, my lords, a coordinate bench would take the same view, my lords.
Yes.
On 22nd June 2022, and the last of the judgment, page 301, 20th December 2023. Now, this is insofar as jurisdiction of BMTF is concerned, my lords. The second point is, my lords, 420, whether they can try it. My lords, Act itself makes it clear, jurisdiction of the court is up to 3 years. So any offense more than that, the court itself does not have any jurisdiction. That, my lords, has been discussed under 2 decisions, my lords. One is of the division bench of Andhra Pradesh, other is of Tamil Nadu, my lords.
Yes.
My lords, I think those two judgments are also there. And the last of the judgment, my lords, to say, even at the time when you're going to take cognizance, there ought to be application of mind, my lords. If my lords would now kindly have my petition, I've produced the order sheet, how the issuance of process that has taken place. Now, this is on an FIR charge sheet, my lords, not even on a private complaint.
Yes.
So my lords should have annexure B, relevant portion, my lords, page 23 order sheet we have produced, my lords, page 23. Order sheet is 22nd May 2023. On the next page, my lords, on the top, nothing, my lords, on cognizance, what is there? Issue summons to accuse through superintendent of police. This is all that we get, my lords. And this goes contrary to the division bench ruling where they upheld the act, my lords, but said, when you're going to be taking cognizance or issuing process, there should be due application of mind. That, my lords, should get, my lords, in the case of Shruti versus. I'm sorry, my lords. I'll do, that is the.
No detailed order is required and it requires the application of mind.
And quite recently, my lords, a coordinate bench also took the same view at the time when you're going to take cognizance.
Yes.
My lords, this should be it.
Yes,
So,
madam.
my lords, my respectful submission is, if this contention now that is taken up, then it disturbs all the rulings that have been done till date, my lords.
Yes.
That BMTF has no juice.
193. 193 of referred. 190. What RTC, what it shows? That's all. Extension.
The notification is only for extension of the power of the BMTF person. With regard only to the force. The power exists with the BMTF itself investigate the matter. Only the force extension, not the extension of the power to the BMTF. Only the force who are appointed as police officers, it's only their power of extension.
Then what do you say with regard to the judgments which have been referred? Saying that no extension up to 2030. Whether you have filed any appeal against all these judgments. Court already comes to a conclusion that no extension of the power up to 2013. He referred number of judgments, wherein also the court comes to a conclusion that no extension of the powers after 2013. What do you say with regard to the said finding, whether those orders have been challenged? Hmm. 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 Is it your argument that 1996 notification is not properly read by the court while passing such an
My
order?
lords, oh, sorry, I'm sorry.
Is it your contention? Because now you are relying upon the 1996 notification. Is it your contention that all the courts, while coming to such a conclusion, not read the notification of the 1996 in a proper sense? That is your argument. Yes. Hmm. 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 That's all. Not reserved.
One clarification, my lords. They said the SLP is pending. No, SLP is disposed.
Already
That's one.
disposed- already disposed
Clear it
of.
both the SLPs. Oblige.
Not reserved.
It's interim order which is there.
Interim order granted earlier is extended till next date of hearing.
Oblige.
Yes, next matter, admission. Srinivasa Rao, SS. Hmm.
Plus, I request for a week's adjournment. Madam.
Hmm. Petitioner counsel seeks time. Other side are idara, HCGP and Sebastian, R2 counsel also present and additional SPP also present, list this matter. After winter vacation,
Please, ma'am. Interim order.
after winter vacation.
Interim order.
Interim order granted earlier is extended till next date of hearing.
Grateful. 83.
Hmm.
Karuna.
Karunakara.
Petitioner.
Hmm.
It was argued.
Hmm. Other side produced some documents in the previous.
Yeah, they produced the documents that I have produced.
Hmm.
There is no fresh documents are produced or new documents are produced.
Hmm.
All the documents they have produced are the documents that I rely upon.
Hmm.
Facts of the matter in a nutshell, my lord, again,
Hmm.
recapitulate.
Hmm.
There is one Halavaya.
Hmm.
Halavaya is the grantee.
Hmm.
His wife is Javaramma.
Hmm.
I am adopted. Sumitra is adopted, who is A2. Halavaya has a son called Iraya.
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 Hmm.
Their daughter is Rupa, who is a complainant.
Hmm.
Their contention is that I have taken away.
Is the daughter of Iraya.
Daughter of Iraya. Rupa is the daughter of
Daughter
Iraya.
of- huh.
So, but they have made a mistake in the.
Your claim is that she is the adopted daughter.
I am the adopted daughter of Halavaya.
Huh.
I am the adopted daughter of Halavaya. They have made a mistake in the complaint itself, saying that I am the daughter of Iraya.
Hmm.
They made a mistake. Notwithstanding all that, my lord,
Hmm.
the suit is filed on 2/4/2019
Hmm.
for declaration.
Hmm.
They have a grievance against me,
Hmm.
saying that about 21 years ago,
Hmm.
there was a mutation entry in my name.
Hmm.
After institution of this suit,
Hmm.
they filed this private complaint
Hmm.
on 4/6/2019,
Hmm.
alleging offences.
Hmm.
In the suit,
Hmm.
which is filed for declaration,
Hmm.
they say that they are in possession.
Hmm. Hmm.
They say that they are in possession. I have come out very clear in my written statement,
Hmm.
saying that I am the adopted daughter of Halavaya.
Hmm.
This is a matter that requires to be
Hmm.
thrashed out before the civil court.
Hmm.
What they are aggrieved by the fact that the mutation entry took place in the year 98, 99. That is 21 years before they filed the civil suit. The mutation entry has taken place based on a unregistered palupati. I myself have produced two mutation registers. One is 97, 98. Another is 98, 99. Both are MR4. Both say the same thing. One based on Oppige Mere, another is on partition. These mutations have taken place. Second mutation, there is an unregistered palupati, which I have produced, they have also produced. Unregistered palupati. I myself had produced as an additional document. The state has also produced the same document. According to me, all these things requires
whether you are an adopted daughter or not.
I am an adopted daughter or not. If I am able to establish I am an adopted daughter, then I have to ask for necessary other release before the revenue.
That's all.
That's all. That's it.
Humble submissions. I filed my synopsis. Kindly have a look for synopsis. Not 1955 to 56.
Synopsis.
Synopsis, list of events synopsis I filed.
Sorry.
Put it in. Along with this one also. List of documents also filed.
List of events ಅಂತ ಕೊಟ್ಟಿದ್ದಾರೆ ನೀವು.
ಹೌದು, ಪ್ಲೀಸ್ ಮೇಡಮ್, ಪ್ಲೀಸ್. ಅದ್ರ ಜೊತೆಗೆ ಡಾಕ್ಯುಮೆಂಟ್ಸ್ ಕೊಟ್ಟಿದ್ದೀನಿ ಸಪರೇಟ್ ಆಗಿ. ಡಾಕ್ಯುಮೆಂಟ್ಸ್
ಆಯ್ತು.
1955-56 ಅಲ್ಲಿ ಹಳವಯ್ಯ ಹ್ಯಾಸ್ ಬಿನ್ ಗಿವನ್ by the deputy commissioner 15 years bound ಅಲ್ಲಿ they have been allotted 4 acres 9 guntas of land. Helavaya Henti still Javram also she has given evidence in the later stage. I'll come to that part later. Later on Helavaya, after the death of Helavaya, Iraya our Vamsharukshanu the documents given the documents also in page number 2015 ಅಲ್ಲಿ. The Iraya 3 daughters, sisters, Madevamma, Lakshmamma, Sannamma. All the Iraya, that after the death of Helavaya to Iraya has gone. Iraya only 2 daughters.
Rekha Rupa.
That's all. After that one in Panchayati Palupatre Paritika, what they do. In Panchayati Palupatre, there is no any this one. Based on this one, her mutation has been transferred to the 1998-1999 synopsis to the lady Sumitra. Nowhere she is related. Even in evidence nalli nodidru, they even kindly see the page number Javaramman statement atolli. Our adopted daughter agidre senior school as it states that in page number 36 hogi. Our charge sheet alle there. Javaramma herself given a statement. Javaramma is the Irama's mother. She herself gives statement that we don't have any adopted daughters. Herself she said that completely.
Where is that statement?
Page number 36 my lord in charge sheet ಅವ್ರದೇ ಇದು ಇದ್ರಲ್ಲಿ 36 man.
ನೀವು ಕೊಟ್ರ ಅವ್ರ ಡಾಕ್ಯುಮೆಂಟ್ ಅಲ್ಲ.
ಅವ್ರು ಇದ್ರಲ್ಲಿ ಅವ್ರು ಕೊಟ್ಟಿದ್ದು ಇದ್ರಲ್ಲೇ ಇದೆ ಚಾರ್ಜ್ ಶೀಟ್ ಅಲ್ಲಿ.
ನಾಟ್ ಯುವರ್ ಡಾಕ್ಯುಮೆಂಟ್ಸ್.
ನಾಟ್ ಮೈ ಡಾಕ್ಯುಮೆಂಟ್ಸ್. ಅವ್ರ ಡಾಕ್ಯುಮೆಂಟ್ಸ್ ಎಲ್ಲ ಇದೆ. ಪೇಜ್ ನಂಬರ್ 36 ಮೈ ಲಾರ್ಡ್. ಚಾರ್ಜ್ ಶೀಟ್ ಅಲ್ಲಿ ಮೇಡಮ್.
ಚಾರ್ಜ್ ಶೀಟ್.
ಪ್ಲೀಸ್ ಮೇಡಮ್.
ಪ್ರೈವೇಟ್ ಕಂಪ್ಲೇಂಟ್ FIR
ಆಗಿದೆ.
ದೆನ್ ಚಾರ್ಜ್ ಶೀಟ್ ಅಲ್ಲಿ
ಪೇಜ್ ನಂಬರ್ 36 ಅಲ್ಲಿ ಮೈ ಲಾರ್ಡ್. Javaramma is the mother of Helavaya, wife of Helavaya. Mother of Iraya. Your adopted child ಅಂತ ಹೇಳಿದ್ರೆ the Iraya, that Javaramma herself she says it. Shall I read the relevant portions? ನಾನು ಮೇಲ್ಕಂಡ ವಿಳಾಸದಲ್ಲಿ ಕೂಲಿ ಕೆಲಸ ಮಾಡಿಕೊಂಡು ವಾಸವಾಗಿರುತ್ತೇನೆ. ನಮಗೆ 4 ಜನ ಮಕ್ಕಳಿದ್ದು ಮೊದಲನೆಯ ಮಗ ಈರಯ್ಯ, ಎರಡನೆಯವಳು ತಂಗಿ ಮಹಾದೇವಿ, ಮೂರನೆಯವಳು ಲಕ್ಷ್ಮಿ, ನಾಲ್ಕನೆಯವಳು ಸಣ್ಣಮ್ಮ. 3 ಜನ ಹೆಣ್ಣು ಮಕ್ಕಳನ್ನು ಮದುವೆ ಮಾಡಿಕೊಂಡಿದ್ದು ಅವರುಗಳು ಅವರ ಗಂಡ ಮಕ್ಕಳ ಜೊತೆಯಲ್ಲಿ ವಾಸವಾಗಿರುತ್ತಾರೆ. ನನಗೆ ನನ್ನ ಮಗ ಈರಯ್ಯ 2 ಜನ ಹೆಣ್ಣು ಮಕ್ಕಳಿದ್ದು ಮೊದಲನೆಯವಳು ರೇಖಾ, ಎರಡನೆಯವಳು ರೂಪ. ನನ್ನ 2 ಹೆಣ್ಣು ಮಕ್ಕಳನ್ನು ಮದುವೆ ಮಾಡಿಕೊಟ್ಟಿದ್ದು ಅವ್ರ ಗಂಡ ಮಕ್ಕಳೊಂದಿಗೆ ವಾಸವಾಗಿರುತ್ತಾರೆ. ನನ್ನ ಗಂಡ ಹೆಳವಯ್ಯ ಬಿನ್ ಹುಚ್ಚಯ್ಯರವರು ದಡದಳ್ಳಿ ಗ್ರಾಮದ ಸರ್ವೆ ನಂಬರ್ ಸೋನ್ಸಲ್ಲಿ 4 ಎಕರೆ 9 ಗುಂಟೆ ಜಮೀನು ದುರಾಸ್ತು ಮೂಲಕ ಬಂದಿದ್ದು ಅವರು ಸದರಿ ಜಮೀನನ್ನು ಹಕ್ಕು ಸ್ವಾಧೀನದಲ್ಲಿ ಮಾಡಿಕೊಂಡು ಬಂದಿದ್ದು. ನನ್ನ ಗಂಡ ಹೆಳವಯ್ಯ ಅವರವರು ಪೌತಿ ಆದ ನಂತರ ನನ್ನ ಮಗ ಒಬ್ಬನೇ ಮಗನಾದ ಈರಯ್ಯನಿಗೆ MR ಸೋನ್ಸೋ ಅಲ್ಲಿ ವರ್ಗಾವಣೆ ಮಾಡಿಕೊಂಡು ಸ್ವಾಧೀನ ಹೊಂದಿಕೊಂಡು ಜಮೀನನ್ನು ಅನುಭವದಲ್ಲಿದ್ದನು. ನಮ್ಮ ಗ್ರಾಮವಾದ ದಡದಳ್ಳಿ ಗ್ರಾಮದ ಜನಾರ್ದನ ಡಿ ಬಿನ್ ಈರಯ್ಯ ರವರ ವಿದ್ಯಾವಂತರಾಗಿದ್ದು ಇವರು ನಿವೃತ್ತಿ ಬ್ಯಾಂಕ್ ನೌಕರರಾಗಿದ್ದು ಇವರು ನನ್ನ ಮಗನ ಅನಕ್ಷರತೆಯನ್ನು ದುರುಪಯೋಗ ಮಾಡಿಕೊಂಡು ಸದರಿ ನನ್ನ ಮಗನ ಹೆಸರಿನಲ್ಲಿದ್ದ ದಡದಹಳ್ಳಿ ಗ್ರಾಮದ ಸರ್ವೆ ನಂಬರ್ 6ರಲ್ಲಿ 4 ಎಕರೆ 9 ಗುಂಟೆ ಜಮೀನನ್ನು ತನ್ನ ಹೆಂಡತಿಯಾದ ಸುಮಿತ್ರಾ ಅವರವರು ನನ್ನ ಗಂಡ ಹೆಳವಯ್ಯರವರ ಮಗಳು ಎಂದು ಅವರ ಈರಯ್ಯ ತಂಗಿ ಎಂದು ಸುಳ್ಳು ಹೇಳಿ ದಾಖಲಾತಿಗಳನ್ನು ಸೃಷ್ಟಿಕೊಂಡು ತನ್ನ ಹೆಂಡತಿ ಸುಮಿತ್ರಾರವರ ಹೆಸರಿಗೆ ಖಾತೆ ಮಾಡಿಸಿಕೊಂಡಿರುತ್ತಾರೆ. ನಂತರ ನನ್ನ ಹೆಂಡತಿ ಸುಮಿತ್ರಾ ಅವರ ಹೆಸರಿನಿಂದ ತನ್ನ ಮಗನಾದ ಪ್ರಶಾಂತ್ ಡಿಜೆ ಹೆಸರಿಸದರಲ್ಲಿ ಜಾಮೀನು ಖಾತೆ ಮಾಡಿಸಿಕೊಳ್ತಾರೆ. ಮೆಲಾಡ್ ಈ ಸಬ್ಸಿಕ್ವೆಂಟ್ಲಿ ಇದಕ್ಕೆ ಸಬ್ಸ್ಟಿಟ್ಯೂಟ್ ಮಾಡಕ್ಕೆ ಸುಮಿತ್ರಾ ಸ್ಕೂಲ್ ಕೈಂಡ್ಲಿ ಸಿ ದಿ ಸ್ಕೂಲ್ ದಿಸ್ ಒನ್ ಮೆಲಾಡ್. Straight away she says that she is the daughter of Nanjappa. Page number 63, my lord. Sumitra is the daughter of Nanjappa. Shala Pravesha Dakalate, even subsequently 64, 65. All she is A.N. Sumitra, daughter of A. Nanjappa. So totally they are different and she is the different one. They are not with any document subsequently they are given that she have been adopted. ಆಮೇಲೆ ಈರಯ್ಯ ಸ್ಟೇಟ್ಮೆಂಟ್ ಕೈಂಡ್ಲಿ ಸಿ ಪೇಜ್ ನಂಬರ್ 32. ಈರಯ್ಯ ಸ್ಟೇಟ್ಮೆಂಟ್ ಅಲ್ಲಿ ನೋಡಿ. Shall I read it? Same paragraph. ನಾನು ಮೇಲ್ಕಂಡ ವಿಳಾಸದಲ್ಲಿ ಪೇಜ್ ನಂಬರ್ 32 ಮೇಲೆ ಮೇಲ್ಕಂಡ ವಿಳಾಸದಲ್ಲಿ ಕೂಲಿ ಕೆಲಸ ಮಾಡಿಕೊಂಡು ವಾಸವಾಗಿರುತ್ತೇನೆ. ನಮ್ಮ ತಂದೆ ಹೆಳವಯ್ಯ, ತಾಯಿ ಜವರಮ್ಮರವರಿಗೆ ನಾವು 4 ಮಕ್ಕಳಿದ್ದು, ನನ್ನ ಮೊದಲನೆಯವಳು, ಎರಡನೆಯವಳು ತಂಗಿ ಮಹಾದೇವಿ, ಮೂರನೆಯವಳು ಲಕ್ಷ್ಮಿ, 4ನೇ ಸಣ್ಣಮ್ಮ. ನನ್ನ 3 ಜನ ತಂಗಿಯರಿಗೆ ಮದುವೆ ಮಾಡಿಕೊಟ್ಟದ್ದು. ಅವರ ಗಂಡ ಮಕ್ಕಳ ಜೊತೆ ವಾಸವಾಗಿರುತ್ತಾರೆ. ಸಿಮಿಲರ್ಲಿ ದೆನ್ ದೇ ಆರ್ ಶೋಯಿಂಗ್ ದಿ ಪಾಳುಪತ್ರೆ ದಿಸ್ ಒನ್ ಅನ್ರಿಜಿಸ್ಟರ್ಡ್ ಅಂದ್ರೆ 4 ಜನ ಸಮ್ ಗ್ರಾಮ ಪಂಚಾಯತಿ ದೇ ಸೇಡ್ ದಟ್ ದೇ ಪಾಳುಪತ್ರ ನನ್ನ ಡಾಕ್ಯುಮೆಂಟ್ಸ್ ಇದೆ. ಕೈಂಡ್ಲಿ ಸಿ ಮಲರ್. Not only misled the entire society, my lord. Kindly see, Palupancha, page number 16. None documents nalli.
Page number 60. Nimma document.
16, my lord. 16.
16.
15 ನಲ್ಲಿ ಅವ್ರದ್ದು ಪ್ರಮಾಣ ಪತ್ರ ಹಾಕಿ ಅವ್ರದ್ದು ವಂಶವೃಕ್ಷ ಹಾಕಿದ್ದೇನೆ. 1 file 15 ಲಿ ನಂದು ಡಾಕ್ಯುಮೆಂಟ್ಸ್ ಮೇಲೆ. ಮುಟೇಷನ್ಸ್ ಇದೆ.
16.
Malad, I'll go to the first page, Malad. Page number 2, 55, 56 in the Helavaya Nesrale, the mutation. First 2-3 pages are there. Then we'll come to the page number 7, Malad. Ali Helavaya, our after the death of Helavaya, Iraya Hesrige Agute. Page number Idrali. There onwards, 90 Idrali Helavaya Agute. Adad Mele, kindly see the Vamsharuksha. There he has himself has given complete Vamsharuksha. Apart from after that one panchayati palu parikattu idರಲ್ಲಿ ಏನು ಯಾರು ಸಿಗ್ನೇಚರ್ ಈರಯ್ಯದು ಈ ತರ ತೋರಿಸ್ಬಿಟ್ಟು ಇದು ಅನ್ಎಜುಕೇಟೆಡ್ ಫೆಲೋ ಅಲ್ಲಿ ಈರಯ್ಯ ಅಂತಾನು ಬರೆದಿದ್ದಾರೆ. ಇದು ಮಾಡ್ಬಿಟ್ಟು ದೆನ್ ಶಿ ಹಸ್ ಶೋನ್ ಮಿ ಹರ್ ನೇಮ್ ಹ್ಯಾಸ್ ಬಿನ್ ಟ್ರಾನ್ಸ್ಫರ್ ಫ್ರಮ್ 98 to 99 to till date. Malad, interestingly kindly see the gift deed, Malad. Other subsequently page number 22.
ಇದ್ರಲ್ಲಿ ಏನಿದೆ ಈ ಡಾಕ್ಯುಮೆಂಟ್ ಅಲ್ಲಿ? ಪಂಚಾಯತಿ
ಪಾಲಿಪತ್ತು ಕ್ರಮ ಅಂದ್ರೆ ಆರೋಗ್ಯ ಸರಿ ಇಲ್ಲ ಕಾರಣ
ತಂಗಿಯಾದ ಸುಮಿತ್ರಮ್ಮ ಅಂತಿದೆ.
ಅಲ್ಲ ಮೇಡಮ್, ಅಲ್ಲ ಹಂಬ ಸಮಸ್ಯೆ. ಕ್ರಮವೇನೆಂದ್ರೆ ನನಗೆ ಆರೋಗ್ಯ ಸರಿ ಇಲ್ಲದ ಕಾರಣ ವಿವಾಹವಾಗಿರುವುದಿಲ್ಲ. ನನ್ನ ತಂಗಿಯಾದ ಸುಮಿತ್ರ ವ್ಯವಹಾರ 2 ಮಕ್ಕಳಿದ್ದಾರೆ ಆಲ್ರೆಡಿ ಅವ್ರಿಗೆ. ಅಲ್ಲಿ ವಿವಾಹವಾಗಿರುವುದಿಲ್ಲ. ನಾನು ಮತ್ತು ನನ್ನ ತಂಗಿಯಾದ ಸುಮಿತ್ರರು ನಾವುಗಳು ಇಬ್ಬರು ಅವಿಭಕ್ತ ಕುಟುಂಬದಲ್ಲಿ ಇದ್ರಿಂದ ನನ್ನ ಪಾಲನೆ ಮತ್ತು ಪೋಷಣೆಯನ್ನು ನನ್ನ ತಂಗಿ ನೋಡಿಕೊಂಡಿರುವುದರಿಂದ ನನ್ನ ಪಿತ್ತಾಜತೆ ಆಸ್ತಿಯಾದ ಖಾಲಿ ಸ್ವಾಧೀನದಲ್ಲಿರುವ ದಡದಹಳ್ಳಿ ಗ್ರಾಮದ ಸೋನ್ಸೋ ನನ್ನ ತಂಗಿಯ ಸುಮಿತ್ರಾ ಕೋಮ್ ಜನಾರ್ದನ್ ಇವರಿಗೆ ಸದರಿ ಶೆಡ್ಯೂಲ್ಗಳು ಪಂಚಾಯಿತಿಯ ಸಮಕ್ಷಮ ಸರ್ಪದಿಗೆ ಬಿಟ್ಟು ಕೊಟ್ಟಿರುತ್ತೇನೆ. ರಿಲಿಂಕ್ವಿಶ್ ಡೀಡ್. ಅಲ್ಲಿ ಮದುವೆ ಆಗಿಲ್ಲ.
ಈರಯ್ಯ ಸತ್ತಿರೋದು ಯಾವಾಗ?
ಆ ಲೇಟರ್ ದಟ್ ಈರಯ್ಯ ಒಂದು ಈವನ್ ಫೈಲ್ ಕಂಪ್ಲೇಂಟ್ ಆಲ್ಸೋ ಲೇಟೆಸ್ಟ್ ಸತ್ತಿದ್ದಾರೆ 95 4-5 years ಅಲ್ಲಿ. ಮೊನ್ನೆ 4-5 ವರ್ಷದ ಹಿಂದೆ ತೀರ್ಕೊಂಡು
ಈಗ
ರೀಸೆಂಟ್ ಆಗಿ ಅಂಡ್ himself is given a complaint. ಅವರು nowhere she is related to her, himself has given a complaint. Is a fake one, my lord. But apart from that, kindly see the gift deed ಅಲ್ಲಿ relevant paragraph page number 22, my lord. I read it all. Gift deed. ಕ್ರಮವೇನಂದ್ರೆ ಥರ್ಡ್ ಪ್ಯಾರಾಗ್ರಾಫ್. ಕ್ರಮವೇನೆಂದರೆ ಈ ದಾನ ಪತ್ರದಲ್ಲಿ ಅನುಸೂಚಿತವಾಗಿ ಸ್ವತ್ತು ನನಗೆ ಸ್ವಯಾರ್ಜಿತವಾಗಿ ಬಂದು ಸ್ವತ್ತಾಗಿದ್ದು. Sumitra is giving gift deed to her son Prashant, saying that it is ಸ್ವಯಾರ್ಜಿತವಾಗಿ ಬಂದಿದೆ. That what she mentions here. ಸ್ವಯಾರ್ಜಿತವಾಗಿ ಬಂದ ಸ್ವತ್ತಾಗಿದ್ದು ಅಂದಿನಿಂದ ನನ್ನ ಹೆಸರಿಗೆ ಬಂದು ನನ್ನ ಹಕ್ಕು ಮಾಲೀಕತ್ವ ಮತ್ತು ಸ್ವಾಧೀನದಲ್ಲಿರುವ ಸ್ವತ್ತಾಗಿರುತ್ತದೆ. ಸದರಿ ಅನುಚಿತ ಸ್ವತ್ತಿನ ಖಾತೆ MR ನಂಬರ್ 4 ನನ್ನ ಹೆಸರಲ್ಲಿ ಈಗ ನನ್ನ ಮಗನಾದ ಡಿ ಜೆ ಪ್ರಶಾಂತ್ ಆದ ನಿನ್ನ ಮೇಲೆ ನನಗೆ ಹೆಚ್ಚಿನ ಪ್ರೀತಿ ಮಮತೆ ಹಾಗೂ ವಾತ್ಸಲ್ಯ ಇರುವುದರಿಂದ ಈ ದಿನ ನಿನ್ನ ಮೇಲೆ ನನಗೆ ಇರತಕ್ಕ ಪ್ರೀತಿ ಮಮತೆ ವಾತ್ಸಲ್ಯ ಮೇಲ್ಕಂಡಂತೆ ನನ್ನ ಹಕ್ಕು ಮಾಲೀಕತ್ವದ ಮತ್ತು ಸ್ವಾಧೀನದಲ್ಲಿರುವ ಅನುಸೂಚಿತ ಸ್ವತ್ತನ್ನು ಈ ದಿನ ನಿನಗೆ ದಾನವಾಗಿ ನೀಡಿರುತ್ತೇನೆ ಹಾಗೂ ದಾನವಾಗಿ ನೀಡಿರುವ ಅನುಸೂಚಿತ ಸ್ವತ್ತಿನ ಸ್ವಾಧೀನ ಈ ದಿನ ನಿನಗೆ ಬಿಟ್ಟು
reasons for gifting the property.
Yes, my lord. Well, it all shows, my lord, completely shows that it has been fabricated, not only fabricated, but they not only they mislead and government officials, they mislead enter this the society itself. And nowhere even Helvaya, Helben wife, Jaurama ಹೇಳ್ತಾಳೆ ಆಕಿನ ಮಗಳಲ್ಲ. ಆಮೇಲೆ ಹೆಳವೆಯನ್ನ ಮಗ ಈರಯ್ಯ, ಈರೈನ್ ಸಿಸ್ಟರ್ ಸ್ಟೇಟ್ಮೆಂಟ್ಸ್ ಕೊಟ್ಟಿದ್ದಾರೆ. ಆಲ್ ಸ್ಟೇಟ್ಮೆಂಟ್ಸ್ kindly see page number. ಮೇಲಾಡ್ ರೇಖಾ ದ ಡಾಟರ್ಸ್ ಆಲ್ಸೋ ಕೊಟ್ಟಿದ್ದಾರೆ. ಆಮೇಲೆ ಈರೈನ್ ತಂಗಿ ಆಲ್ಸೋ ಕೊಟ್ಟಿದ್ದಾಳೆ. ಈರೈನ್ ತಂಗಿ ಸ್ಟೇಟ್ಮೆಂಟ್ ಕೊಟ್ಟಿದ್ದಾಳೆ. And school record also shows ಈರಯ್ಯ ಸಿಸ್ಟರ್ ಪೇಜ್ ನಂಬರ್ 42 ಲಕ್ಷ್ಮಿ ಇನ್ನೊಂದು ಈರೈನ್ ಇನ್ನೊಂದು ಸಣ್ಣಿ ತಂಗಿ ಹಾಕಿ 38 ಪೇಜ್ ನಂಬರ್ 38 ಪೇಜ್ ನಂಬರ್ 40 ಅಲ್ಲಿ ಸಣ್ಣಮ್ಮ 42 ಪೇಜ್ ನಂಬರ್ ಅಲ್ಲಿ all they are given this one charge sheet ಅಲ್ಲಿ statements. This lady is nowhere belong to their this one mala, but forcibly they taken even ಇದರಲ್ಲಿ 3 ಜನ ವಿಲೇಜ್ ಅಕೌಂಟೆಂಟ್, ದಿ ದೆನ್ ವಿಲೇಜ್ ಅಕೌಂಟೆಂಟ್, ದಿ ದೆನ್ ತಹಸೀಲ್ದಾರ್, ದಿ ದೆನ್ ಯಾರವರು ರೆವೆನ್ಯೂ ಇನ್ಸ್ಪೆಕ್ಟರ್ ಆಲ್ಸೋ ಇನ್ವಾಲ್ವ್ಡ್ ಮೇಲೆ. Everybody is fabricated. She is uneducated, the manipulated. Entire whole family comes and tell that he has no adopted. From 98 to 99 continued like this. Justice has to provide to this.
Reply. Kindly come to ink page 17.
17 of your document.
Their own document. I know produce
Their own document.
Their document.
17.
Yes. Learned friend read the Palupatti. This is the MR. 4/9890.
But Palupatti, it is mentioned that she is the sister of this Iraya.
Palupatti, that is a mistake. I am not the sister of Iraya. I am the adopted daughter. I have also in my written statement before the civil court, I have denied the relationship of Iraya with the complainant in para 2, which I will take my lord to. Now in this MR, ಅಳವಯ್ಯ ಹೆಸರಿಂದ ಖಾತೆ ಮಾಡುವ ಬಗ್ಗೆ ಇಲ್ಲಿ ನಮೂದಿಸಿರೋ ಸರ್ವೆ ನಂಬರ್ ವಿಸ್ತೀರ್ಣಗಳನ್ನು ಮೇಲ್ಕಂಡರವರಿಗೆ ಖಾತೆ ಮಾಡುವ ಬಗ್ಗೆ ಅವರ ಗ್ರಾಮದಲ್ಲಿ ಕಲಂ ನಂಬರ್ 21A ಪ್ರಚಾರಪಡಿಸಲಾಗಿ ನಿಗದಿತ 60 ಯಾರಿಂದಲೂ ಯಾವ ತಕರಾರು ಸಂಬಂಧ
ಬರದಿಲ್ಲದ ಹಾಗೂ ಸಂಬಂಧಪಟ್ಟ
ಒಪ್ಪಿಗೆ ಹೇಳಿ ಸದಸ್ಯರುಗಳೇ ಕುಟುಂಬ ಸದಸ್ಯರುಗಳೇ ಒಪ್ಪಿಗೆ ಹೇಳಿ ನೀಡಿರುತ್ತಾರೆ. ಪೂರ್ತಿ ಕಡತ ತಯಾರು ಮಾಡಿ ಮುಂದಿನ ಕ್ರಮಕ್ಕೆ ಒಪ್ಪಿಸಿ. This has happened way back in 98-99. And the complaint is of the year 2019. 21 years has elapsed. Kindly now see the written statement that I have filed, that ink page 115, 111 along with my petition is the civil suit that they have lodged. Kindly see ink page 112, para 2, last line. 112, para 2, last line. ಒಂದು ಮನೆಯನ್ನು ನಿರ್ಮಿಸಿಕೊಂಡು ವಾದಿಯರು ಇಂದಿಗೂ ವಾಸವಾಗಿದ್ದು ದಾವಾ ಶೆಡ್ಯೂಲ್ ಸ್ವತ್ತಿನ ಸ್ವಾಧೀನವನ್ನು ಹೊಂದಿಕೊಂಡು ಬರುತ್ತಿರುತ್ತಾರೆ. So according to them, they are still in possession. The plaintiffs are Iraya, Rekha, Rupa. Rupa is the complainant before this court. So she lodged the civil suit, then she comes and files this criminal complaint, PCR. Kindly see ink page 115, para 2, line 4. Originally belonged to one Halavaya in his son. However, it is false to state the plaintiff number 2 and 3 are the children of first plaintiff and the plaintiffs are put to strict proof of the same.
That is your written statement.
Written statement. And 117, para 7. This is the contention that I have urged. 117, para 7. The true facts of the case are that the second defendant is the adopted daughter of Halavaya. In view of the same, after the demise of Halavaya, first petitioner Iraya allotted the suit property to her share. As such, as his assent and consent, the kata concerning the suit property was mutated in his favor and second defendant vide MR 4/9798 Thereafter, even the partition was reduced to writing on 19/190. As such, defendant two became the absolute one of the so and so. The mutation of revenue entries was reaffirmed as such, since the revenue entries are standing in the name of the defendant two, second defendant have been in continuous, uninterrupted, settled possession of the suit property. Second defendant has raised loan on the property and have been repaying it in installment. She has put up construction of the house and have been residing in the suit property with her family. She has dug a borewell, electricity connection. So this is the defense that I have taken.
Yes.
But humble submissions, my lord, this is a fake Palupatra.
ಏನದು?
Fake Palupatra.
ಪಾಲುಪತ್ರ.
My humble submission, the learned counsel, right now, starting he said that he is belong to the adopted daughter of Helvaya. In a Salpat Petra, he will tell that adopted daughter of Uchaya. So actually, they know Uchaya is the father of Helvaya. And here in the Palapatra, directly they said the Iraya. All things source, my lord. They are not only fabricated, misleading everywhere.
Petitioner counsel and also the counsel for respondent and also reply argument result.
Oblige, my lord.
84 for
That
further
one
hearing. PM Reddy, Lucky Weeks.
This case may not where even.
Yeah, heard the matter in length.
Towel in the judgment of the Supreme Court.
ಏನಾಯ್ತ್ರಿ ನಿಮ್ದು ಪ್ರೋಗ್ರೆಸ್ ಏನಾರ ಆಯ್ತೇನ್ರಿ ಸುಪ್ರೀಂ ಕೋರ್ಟ್ ಅಲ್ಲಿ?
Out of yesterday, one matter was reserved.
Reserved.
Out of one batch matter, matter was yesterday, it was listed and it was reserved. And the last month, Lord, the following this judgment, Lord, one of the matter was come up before the Supreme Court. And Supreme Court has set aside that order, the order of the coordinate bench.
Order of the?
The passed by the very same coordinate bench followed the judgment of Charan Singh. And pass on that judgment.
Set aside.
Yes. Not this case, but
ಬೇರೆ ಸಿಮಿಲರ್.
ಹೌದು.
ಅಂದ್ರೆ ಆ ಜಡ್ಜ್ಮೆಂಟ್ ನ ರೆಫರ್ ಮಾಡಿ ಇಲ್ಲಿ ಸೆಟ್ ಅಸೈಡ್ ಮಾಡಿರೋ ಆರ್ಡರ್ ವೆರಿ ಜಡ್ಜ್ಮೆಂಟ್ ವಾಸ್ ಸೆಟ್ ಅಸೈಡ್ ಅಂತನಾ?
The last
ಎಲ್ ಸಿ ನಾಗರಾಜ್.
ಹೌದು.
ಅದಾ?
ಹೌದು.
ಈಗೇನು ಇಷ್ಟು ಸೈಟೇಷನ್ಸ್ ರಿಲೇ ಮಾಡ್ತಾ ಇದೀರಾ ನೀವು?
Further, Lord,
ಇಷ್ಟು ಕೊಟ್ಟಿದ್ದೀರಲ್ಲ ಅದು.
presently, Lord, if they are depends on what they are making submission. They last.
Citations.
Yes, Lord. Now additional judgment.
You are relying upon main judgment of this LC Nagaraj case.
Yes.
ಹೌದಾ?
ಹೌದು. And further, Lord, two more judgments wherein apex court has held the coordinate bench was while allowing the petition was held that the preliminary inquiry was not conducted. And so far as preliminary inquiry is concerned, the Honorable Apex Court in the first judgment, Lord, State of Telangana versus Mangipet, wherein it is observed in paragraph number 32 and 33.
Page number?
Page number 16.
16.
How's? Paragraph number 33. In the present case, FIR itself shows that the information collected in respect of disproportionate asset of the accused officer. The purpose of preliminary inquiry is to be screen wholly frivolous or motivated complaint in furtherance of acting fairly and objectively. Here, relevant information available with the information in respect of prima facie allegation discloses cognizable offense. Therefore, once the officer is even without conducting an inquiry or by any manner on the basis of a credible information received by him, it cannot be said that FIR is liable to be caused for the reason that preliminary inquiry was not conducted. And the same can be only be done upon reading the entirety of the FIR. No offense is disclosed. The reference with regard to the judgment referred in so-and-so state of Haryana versus Bhajanlal, wherein the inter-alia held that where the allegations made in the FIR and complaint, even if they are taken on face of value, accepted in the entirety, do not prima facie constitute any offense or make out the case against the accused, and also where the criminal proceedings are manifestly attended with a mala fide or where the proceedings maliciously instituted with an ulterior motive to weaken the vengeance of the accused and with a view of to inspite the due private or personal grudge. Then the Supreme Court said, my lord, in the such circumstance, only the 482 can be exercised. Here, my lord, the charge sheet is filed. At the stage of after filing the charge sheet, the saying that preliminary inquiry was not conducted. And the consideration of quashing the entire charge sheet mainly on the point of preliminary inquiry. That is when the matter is pending before the apex court. And recently the Supreme Court also held in a disproportionate asset, the mini trial or calculating the valuation made by the investigation officer as a chartered accountant by the investigation the court is impermissible. In the next judgment plot as Vijay Lakshmi case, the page number 19, in that plot I'll go to the paragraph number 64.
Page number?
Paragraph number 64.
Page.
Page 84, 86, my lord. 86. In the present case, appellant is challenging the very source of the respondent income and questioning the assets acquired by them based on such income. Hence, the stage of quashing the affair where the court only has to ascertain whether FIR as prima facie make out the commission of causative offence. Reliance on the documents produced by the respondent to quash the FIR would be contrary to the fundamental principles of law. The High Court has gone beyond the ambit of jurisdiction by virtue conducting the trial in an effort to absolve the documents. During the course of our submission, Bhatia so submitted that on the instruction of the investigation officer, during the course of investigation, as about 150 witnesses have been examined, over 500 documents are obtained. Investigation is stated to be an advanced stage of likely to conclude within the period of 2 or 3 months. At the same time, the court has assured the AG on the instruction of the investigation officer before concluding the investigation. The first and the second respondent will call upon enable them to tender explanation in respect of lead to disproportionate asset referred supra. That so far as that observation, Lord. The Supreme Court has said, Lord, the High Court cannot sit like a chartered accountant, cannot go into the calculation made by the investigation officer. That is at paragraph, Lord. And the last judgment, Lord.
Paragraph number 62.3 ಇರ್ಬೇಕು ನೀವು ಹೇಳ್ತಾ ಇರೋದು ಸೋರ್ಸ್ ಇನ್ಫಾರ್ಮೇಶನ್ಗೆ.
Yes, Lord. Out. Yes, in relation to the final.
Against the first respondent are entirely different.
The last judgment plot.
That is mini trial ಮಾಡಬಾರದು ಅಂತ.
ಹೌದು. That was
the investigation still not complete. Accordingly, we set aside the impugned judgment and order dated 13th.
That case also, my lord, the coordinate bench, considering the disproportionate asset and calculated the income of the entire family has been considered while filing the charge sheet. I'll pass on that order also of the coordinate that was passed by the Honorable Apex Court.
This is the order was quashed.
Yes. Therefore, my lord, the 482, the exercising the power under 482, and here it is the revisional jurisdiction. For that point of consideration, my lord, I have placed the judgments in the last date.
Revision cannot be decided on the basis on the defense which have been taken.
Yes. It's a matter of trial. First.
Any reply?
2 minutes, I don't take much. 2 minutes I'll take. All these judgments which my learned friend refer is a case where the A1 is involved, not an abettor. I am now before this honorable court that the petitioner is an abettor. So what is that a better can do now? What is the court can frame charge? Because the main case itself is disappeared. And number one. Number two, my lord, I had already last time I had given a judgment, my lord, order passed by Supreme Court, 2009 to SEC, only the relevant para will read, madam. 2009 to SEC 370. Para 6 is only, I will take your last. Happy, some quotation, sir. May I read that also?
Para 6.
Para 6, 2009. Detailed we did have, file ಮಾಡಿರೋದು. 611.
Separate citation.
611 ಒಂದು ಫೈಲ್ ಮಾಡಿ ಸೆಪರೇಟ್ ಆಗಿ ಒಂದು ಮೆಮೊ ಹಾಕಿ.
611.
ಹೌದು. 6 November 24. Being from so and so to so judgments, Karnataka Cognizance has laid down the criticism of the entertaining an application under section 482 only because a revision petition is the revision petition is maintainable. The same by itself, in our considered opinion, would not constitute a bar for entertaining an application under section 482 of the code, even where a revision application is barred, as for example, the remedy by way of section 115 of the Code of Civil Procedure 1907. This code has held the the remedy under section under Article 226 to 27 of the Constitution of India would be available. The citation which is being shown there. Even in cases where a second revision before the High Court after dismissal of the dismissal of the first one by the court, a session court is barred under section 397 2 of the code, and inherent powers of the code has been held to be available. The power of the High Court can be exercised not only in terms of section 482 of the code, but also under the section 483 thereof. The such provision reads thus: duty of High Court to exercise continuous superintendence over the court of judicial magistrate, even where the High Court shall so exercise its superintendence over the court, the judicial magistrate subordinate to it, as to ensure that there is an expeditious and proper disposal of the cases by such magistrate. The inherent powers of the High Court is not conferred by statute, but has merely been saved thereunder. It is thus difficult to conceive that the jurisdiction of the High Court would be held to be barred only because the revisional court's jurisdiction could also be available, so and so. Now, what it says, as I said, Malad, is the constitutional bench, High Court, and constitutional bench has all the powers to even the supervisor and inspector, Malad. All the other matter referred, my lord, by my learned friend, where the accused is involved, main accused is involved. The main accused himself has been disappeared. Both the cases, as I produced the copies also, my lord, where the observations made by this honorable court in both the ED case as well as 482. It has been quashed.
Heard the respondent counsel and also the reply of revision petition of counsel reserved. ಮುಗಿತಲ್ಲ ಮೇಡಮ್?
ಇಲ್ಲಿ ಒಂದು ಇಂಟೀರಿಯರ್ ಮಾಡಿ ಕೊಟ್ಟಿದ್ರೆ ಒಳ್ಳೆಯಿತ್ತು.
ಏನ್ ಎಂಟ್ರಿ ಮಾಡ್ರ?
ಕೊಟ್ಟಿದ್ರೆ ಒಳ್ಳೆಯಿತ್ತು.
ಇನ್ನೇನ್ ಎಂಟ್ರಿ ಮಾಡ್ರಿ? ಫೈನಲ್ ಇಯರಿಂಗ್ ಮಾಡಿದ್ಮೇಲೆ
ಆಗ್ಬೋದು. ಅದ್ರ ಜೊತೆಗೆ ಆಯ್ತು.
ಅದೇನ್ 230 ಯಾರ ಮೂವ್ ಮಾಡಿದ್ರು ತಗೊಳ್ಳಿ.
230.
That's in this matter, let's
Because my lord, today at 11:30, my lord, they came with the JCB. Standing structures are there over the property. My lord, in the day broad light, my lord, they demolished it. But,
What is the order dismissed? IA one was dismissed.
My lord, I have served the copy of the appeal memo on the caveat. My lord, I have moved the
Caveat,
matter.
caveat idea.
I have moved the matter at that juncture, my lord, very high-handedly. They have come to here today and they have demolished the structure. Absolutely,
Ex
my lord.
parte TI order dated 10/20/21 granted in favor of the plaintiff stand vacated.
Can it be taken up tomorrow, my lord? So tomorrow at 10:30 minutes, I have received the copy, my
His
lord, today.
contention is that you took the JCB today and demolished the building.
My lord, there was
Photographs, my
the
lord, right
structure.
of today, along with the memo, I'm placing it on record. Not a high-handed action, my lord. Now the. They appreciate it.
Why you went with JCB?
My lord,
Was there any order?
my lord, the possession of the property was taken, my lord, in an execution proceedings in the year
It
19.
may be counsel.
Yesterday, I
Why
have
you have
served-
advised your client to take the JCB to the spot? Maybe interim order granted in the year 2021 was vacated recently.
Yes.
Huh.
But there
Why
was
why
a,
he had taken the law into his own
at
hands?
the building, my lord, it was a dilapidated building, my lord. It
Whatever
was,
it may be, whatever it may be. Already there was an injunction order.
yes,
In the year 1921, it was granted. It was vacated recently.
but in
Now,
the
why you took the JCB? Stop all work.
the 24th of October, my lord, the order was passed.
ಆಯ್ತು. Appeal period ಇದೆ ಅಲ್ವಾ? Appeal period ಇದೆಯಾ ಇಲ್ಲ?
Yes.
Then why you took the JCB today? First you advise your client to stop all this work.
Please.
Hmm?
But on merits, my lord, I'll make my submission my lord, by tomorrow or day after, my lord.
First you,
I'll advise.
the counsel for the respondent submits that he will instruct the respondent. Again status ಏನ್ರಿ ಈಗ?
Now, that is the structure.
What was the building actually?
Building was there, my lord. Now, building is demolished today morning. My lord,
What-
those-
ಏನ್ building ಇದು?
It was a house property, a continued house property measuring 20 into 60, which is in my possession.
20 into 60.
60.
Ah.
Now, he claimed, my lord, a portion of a property 20 into 30. Now, my lord, he filed a separate suit. There, my lord, a specific finding is made that my property is different from his property. Now, I file this present suit.
In his suit, there was no any interim order.
No, my lord, that suit came to be decreed.
Decreed.
He sought a declaration of title and for recovery of possession. I filed
Recovery of possession.
possession.
Ah.
I filed an impleading application there.
Ah.
He said the sale deed in my favor is null and void. A specific prior was made. The court below on the earlier occasion, my lord, went into it and said that both properties are different and said that the declaration that my sale deed doesn't bind him cannot be granted. Suit to that extent was dismissed. Against the other defendants, my lord, suit was decreed for delivery of possession and declaration. My lord, then suddenly, my lord, he started to come and interfere over my property to execute the decree. I filed this present suit. Thereafter, my lord, now by the impugned order, the injunction application was rejected. Lord, I did not even anticipate that he would come and take the JCB to the property. He comes and demolishes my property when there is a finding which has attained finality that my property is totally distinct. And the declaration that he sought that the sale deed in my favor doesn't bind him has been dismissed. Now he cannot, my lord, wantonly do it. Now rebels, my lord, debris.
But in the said suit earlier, what he had filed, you are a party.
I got myself impleaded. Yes.
then-
There a specific finding is recorded that my property is different, his property is different. He was given liberty to proceed against his property, which he can do. But on that guy's, my lord, he comes over my property. That's where the difficulty arose. And now, my lord, whether he takes the possession or not is a different thing. But not a high-handedness, my lord, of demolishing it.
Let's, I'll submit.
Building ನೋಡಿ,
No, it was a dilapidated building. It was not a, no, it was a dilapidated building. It was collapsed, my lord, about 3 years ago. It was.
staircase ಎಲ್ಲ ತೆಗ್ದಾಕ್ತಿರೋದು ಕಾಣಿಸ್ತಾ ಇದೆ ನೋಡ್ರಿ, ಕಾಪಿ ನೋಡ್ರಿ.
No, that is the next building, my lord. That staircase, my lord.
ನೆಕ್ಸ್ಟ್ ಬಿಲ್ಡಿಂಗ್ ಈಗ ಡ್ಯಾಮೇಜ್ ಆಗಿದೆಯಲ್ಲ ಇಲ್ಲಿ? ಅವ್ರು
No,
ಇನ್ನೊಂದು
my lord,
building ಅಲ್ಲಿ
no, it is on the other side, my lord. The demolition of the old building did not, my lord,
ಏನ್ರಿ ಇದು?
my lord, I have. But this is the other portion, right? It is not visible here. This staircase, my lord, is not affected by the demolition of the dilapidated building. This is the other, next building. This is not concerned.
Whatever
to
it
the-
may, whatever it may be,
Let's,
you have already filed a caveat before this court, expecting that they are going to file an appeal. Then why your client
Let's,
has taken
let only
a
one.
decision to demolish the building when the appeal period is not over?
Let's, I'll submit, let's.
They have already served the copy.
Not yesterday. Today, my lord, today morning, my lord, it is served, not yesterday, my lord.
ಎಷ್ಟು ಗಂಟೆಗೆ ಸರ್ವ್ ಮಾಡಿದ್ರಿ? ಯಾವಾಗ ಸರ್ವ್ ಮಾಡಿದ್ರಿ ಹೇಳಿ?
But 10:50, my lord, it was served.
10:50 today.
Today.
Copy is served.
Yes.
And then
To the council, my lords, and by that time, my lord, the portion of the dilapidated building was already demolished.
I3, ನೀವು, even though he is unsuccessful before the trial court.
Yes.
When the interim order was vacated.
But they should have held
because
their hands, my lord, I
he
do
was
consider.
enjoying the interim order from 2021. It was vacated in the month of October. And also appeal period is not over. Why your client took the JCB and demolished the building?
The, probably the anxiety must be, my lord, for
What anxiety,
that
eh?
about 22 years, my lord, they are before
Hey.
the court, my lord,
They
sir.
have already filed a caveat, expecting that they are going to file appeal also.
Yes. My lord, in the other suit, my lord, where the decree is granted, my lord, may I make one submission, my lord?
Maybe that is secondary now. Maybe you are having a decree. You are having a decree in respect of your property.
The
But
decree.
they have filed a separate suit and the order has been passed.
The decree is granted and it has been executed in the presence of the present plaintiff. Now, in the execution proceedings, possession was handed over. Now, he did not challenge that proceedings. He files an independent.
ಆಯ್ತು possession ಆಯ್ತು ಸರಿ.
He files an.
ಯಾಕೆ ಈ ಕೆಲಸ ಮಾಡಿದ್ರಿ?
This.
Heard the appellant counsel and also the counsel appearing for the respondent. The appellant counsel brought to notice of this court. Even though appeal period is not over, the respondent came with JCB and demolished the portion of the property. And even caveat is also filed before this court, expecting that an appeal will be filed against the vacating of interim order and taken the law into their own hands and demolished the building. And when the appellant counsel brought to notice of this court, directed the respondent counsel instruct the respondent not to continue the demolition work and stop immediately and list this matter day after tomorrow.
Day after tomorrow. Please.
Pass over idea, Bunny.
Passport matter list number 1, seal number 1, Sanjay P.
For the appellant in this case, my lord. Office objections has been complied, my lord.
ಒಂದಕ್ಕೆ ಸಬ್ಮಿಷನ್ ಕೊಟ್ಟಿದ್ದಾರೆ. ಬಾಕಿದೆಲ್ಲ ಅಟೆಂಡ್ ಮಾಡಿದಾರ ನೋಡಿ?
ಮಾಡಿದೀವಿ ಸರ್.
ಇಲ್ಲಿ ನೋಡಿ, ಇಲ್ಲಿ ಇದು ಇಲ್ಲೇ ಮಾಡಿರೋದ? What is the urgency today?
My lord, there is an order obtained by the respondents in this matter under 14(2), my lord. And the chances are that they might execute it immediately, my lord. There is a FIR which has been filed. And they have filed a 482 petition and got the proceeding stayed. There was an order for maintaining status quo before the lower court, my lord. All these documents was brought to the notice of the court. The plaintiff before the lower court passed away, my lord. And her legal representatives came on record. Without taking into any of these things into account, my lord, the lower court vacated the interim order, my lord. Now, based on that, I filed this appeal, my lord.
What date it was vacated?
It was vacated on 26/11, my lord.
26/11.
Please, my lord.
Sorry, registry is directed to verify whether the office objections are complied. Regarding the submission in nimdu, other office objection?
Everything has been complied, my lord.
Council submission ಏನ ಕೊಟ್ಟಿದ್ರಿ ಒಂದಕ್ಕೆ ನೋಡಿ.
Number 7 ಕೊಟ್ಟಿದ್ದಾರೆ.
Number 7 ಏನು?
Disposal to be correctly stated at page number 5 ಅಂತ ಇದೆ.
Date of disposal of ಏನ IN?
My lord, 26/11 is correct, my lord. That's the correct.
26/11 ಇದೆ. ಇನ್ನೇನು page number 5 ಅಲ್ಲಿ ಏನು ಹೇಳಿದ್ದಾರೆ ನೋಡಿ? Page number 5. 8/9/23 ಅಂತ ಏನೋ ಹೇಳಿದ್ರಿ ನೀವು. OS 269293. There is a typographical error in mentioning in page number 5, date of disposal. And order is specific that order was passed on 26/11/2024. And hence office objection Number ಎಷ್ಟದು? Number 7 is overruled. ವೆರಿಫೈ ಮಾಡ್ಲಿ ನಾಳೆ ನೋಡೋಣ. ಲಿಸ್ಟ್ ಆಗೋಯ್ತೇನ್ರಿ ನಾಳೆದು?
That is extremely important and urgent, my lord.
ಎಕ್ಸ್ಪರ್ಟ್ ಏನ್ ಅರ್ಜೆಂಟ್ ಏನಿದೆ ರೀ?
ಅವ್ರು ಬಂದು ನನ್ನನ್ನು ವೆಕೇಟ್ ಮಾಡ್ತಾರೆ ಸ್ವಾಮಿ.
ಯಾವ
My respectful submission, it is not for the first time that them are, we are at loggerheads, my lord. As early as March 2023, I've been.
ಆಯ್ತು, ಲಿಸ್ಟ್ ದಿಸ್ matter day after tomorrow.
If I can take a chance tomorrow, my lord.
ನಾಳೆಗಿಲ್ಲ, ನಮ್ದಾಗ್ಲೇ ಲಿಸ್ಟ್
ಆಗ್ಲಿ, please, much obliged.
ನಮ್ ಫೈಲ್ಸ್ ಎಲ್ಲ ಪೇಪರ್ ಆಲ್ರೆಡಿ ಕಾರಲ್ಲಿ ಇಟ್ಟಿರ್ತಾರೆ.
Please, madam. Much obliged.
Till number 17.
17 ಹೇಳ್ರಿ, ಬೆಳಗ್ಗೆ ಯಾರು ಇಲ್ಲ?
ಬೆಳಿಗ್ಗೆ
ಇದ್ರಲ್ಲ ಏನೋ ಮೆಮೋ ಹಾಕ್ತೀನಿ ಇದ್ರಲ್ಲ. ತಗೊಳ್ಳಿ, ಅಪಲೆಂಟ್ ಕೌನ್ಸಿಲ್ ಫೈಲ್ಸ್ ಮೆಮೋ ಟು ಡಿಸ್ಪೆನ್ಸ್ ದಿ ನೋಟಿಸ್ ಅಗೇನೆಸ್ಟ್
R1 to R4, my lord.
R1 to 4 and
8 to 36
and 8 to 36.
in one case, my lord.
Since the order impugned is interstate between the appellant and respondent number 5. Respondent ಅಷ್ಟೇ.
Yes.
Respondent number 5 ಅಲ್ಲ?
And connected matter, my lord, R1 and R2.
Respondent number 5 connected ಅಲ್ಲಿ?
1258.
Also filed memo in MFA 1258 of 23 to dispense the notice against respondent number 124.
Rest of the response already dispensed.
Already dismissed ಆಗಿದೆಯಾ? And hence the memo is taken on record, dispense the notice against R1, 2 and 4. List this matter.
Admission, my lord.
Post the matter for admission. ಯಾವಾಗ ಬೇಕು ಹೇಳಿ? ಅರ್ಜೆನ್ಸಿ ಇದೆಯಾ?
Any day, my lord.
ನೆಕ್ಸ್ಟ್ ವೀಕ್ ಅಲ್ಲಿ ಕೊಡಿ.
Interior order may be continued.
Entry matter ಇದೆಯಾ?
correct.
Entry matter granted earlier is extended till next date of hearing. List this matter on 13/12.
Late for me.
34.
Krishnamurthy.
ಬೆಳಗ್ಗೆಲ್ಲ ಹೇಳಿದೆ ಪಾಸ್ ಓವರ್ ಆದ್ರೆ ಆಗಲ್ಲ ಅಂತ. ಏನ್ ಹೇಳಿ? ಯಾವಾಗ ಬೇಕು?
Sorry, I was.
Urgency ಇದೆಯಾ ಏನು?
25.
ನಾಟ್ ಮೇಂಟೈನಬಲ್, ವಾಂಟ್ ಆಫ್ ಜೂರಿಸ್ಡಿಕ್ಷನ್.
Want of.
ಅದೇನ್ ಟೈಮ್ ಲಿಮಿಟೇಷನ್ ಏನ್ ಕೊಟ್ಟಿಲ್ಲಲ್ಲ, ಯಾವತ್ ತಗೋಬೇಕು? ನೀವು ಹೋದ್ ದಿವಸ ಕೊಡ್ತಾರ ಅಷ್ಟೇ.
ಹೌದು.
ಅರ್ಜೆನ್ಸಿ ಏನು? ಲಿಸ್ಟ್ ದಿಸ್ ಮ್ಯಾಟರ್ ನೆಕ್ಸ್ಟ್
ಅಲ್ಲ ಅದ್ರಲ್ಲಿ
ಫಾರ್ ವಾಂಟ್ ಆಫ್ ಟೈಮ್.
ಅಲ್ಲ ಅವ್ರು ಡಿಗ್ರಿ ಬರ್ದು ಬಿಟ್ರೆ
ಡಿಗ್ರಿ ಹೆಂಗ್ರಿ ಬರೀತಾರೆ? ನಿಮ್ಗೆ ರಿಟರ್ನ್ ಮಾಡ್ದಲೇನೆ?
ಅದಕ್ಕೆ.
ಏನಾಗುತ್ತೆ?
In fact,
next
your
week
lordship has directed me to
next
serve the
week
copy on
ಆಯ್ತು.
the council. I have served it. They are not appearing.
ಮಾಡಿದೀರಾ? ಸರ್ವ್
ಹೌದು,
ಮಾಡಿದ್ದೀರಾ ಆಲ್ರೆಡಿ?
ಹೌದು.
ಆರ್ಡರ್ ಇತ್ತ?
ಹೌದು, ತಾವ್ ಹೇಳಿದ್ರಿ.
ಮತ್ ನೋಟಿಸ್
Take
ಹೋಗ್ಬೇಕಲ್ಲ?
notice on the trial court counsel.
Advocate fails to come and take the notice.
Yes.
Notice has to be issued to the
Party.
parties. Agar ಇಲ್ಲಿ ತೊಗೊಳ್ಳಿ,
Only one party.
issue emergent notice against the respondent. Since in spite of copies are served on the counsel who appeared before the trial court did not choose to appear before this court. And hence list this matter on 14/12, 14 ರಜಾ ಇರ್ಬೇಕು. 16/12.
35. Kashinath JD.
ಕಾಶಿನಾಥ್ ಅಯ್ಯೋ 1 and 2 rejected on cost of rupees 5,000. ಯಾವಾಗ ಬೇಕು ಹೇಳಿ?
Appear for the respondent number 1.
ಮಾರ್ನಿಂಗ್ ಹೇಳಿದೆ ಆಗೋದಿಲ್ಲ, ರೀಚ್ ಆಗೋದಿಲ್ಲ ಅಂತ. ಪಾಸ್ ಓವರ್
Friday, my lord.
ಈ ಫ್ರೈಡೆ, ಈ ವೀಕ್ ಅಲ್ಲಿ ಆಗೋದಿಲ್ಲ, ನೆಕ್ಸ್ಟ್ ವೀಕ್ ಅಲ್ಲಿ ನೋಡಿ. ಅದರ್ ಸೈಡ್ ಆರ್ ಇದೀರಾ?
Respondent number 1.
9th, my lord.
Both councils are present for want of time. List this matter on
9th, my lord.
9th. ಮಂಡೇಗೆಲ್ಲ ಜಾಸ್ತಿ ಇದೆ ರೀ.
Tuesday.
ಅದಕ್ಕೆ ನಾನು ಇವತ್ತು ಬೆಳಗ್ಗೆ ಇಟ್ಕೊಂಡಿರ್ತೀವಿ, ನಾವು ಓದ್ಕೊ ಬರ್ತೀವಿ, ನೀವು ಬರ್ಬೇಕು ಕೋರ್ಟ್ಗೆ, ಅಸಿಸ್ಟ್ ಮಾಡ್ಬೇಕು ಕೋರ್ಟ್ಗೆ.
I'm apologizing, my lord, for that. 10th, my lord.
11/12 ನೋಡಿ, 11/12 ಹಾಕಿರಿ.
Obliged.
36.
36 ಆಲ್ಸೋ ಪಾಸ್ಟ್ ಓವರ್.
Sorry, my lord.
ಇದೇನ್ರಿ ಇದು? ಅಲೋಡ್ A1 ಅಲೋಡ್ ಕನ್ಸ್ಟ್ರಕ್ಷನ್.
Yes, my lord.
ಹೇಳಿ ಯಾವಾಗ ಬೇಕು? ಫಾರ್ ವಾಂಟ್ ಆಫ್ ಟೈಮ್ ಲಿಸ್ಟ್ ದಿಸ್ ಮಾಟರ್ ಆನ್ 11/12 or
11.
11/12.
Much.
40.
RFA-ನಾ? ಇವೆಲ್ಲ ಫೈನಲ್ ಇಯರಿಂಗ್ ಅಥವಾ
Parted in.
ಇದು ಪಾರ್ಟೆಡ್?
ಹೌದು sir, 40 parted.
ಪಾರ್ಟೆಡ್. PB ರಾಜು ಯಾವತ್ ಬೇಕ್ರಿ?
9th or 10th.
9th to 10th ಎಲ್ಲ ಜಾಸ್ತಿ ಇದೆ ಅನ್ಸುತ್ತೆ. ಪಾರ್ಟೆಡ್ ಎಲ್ಲ ರಿಲೀಸ್ ಮಾಡೋಣ ಆಫ್ಟರ್ ವಿಂಟರ್ ವೆಕೇಶನ್ ಮಾಡ್ಕೊಬಿಡಿ. ಏನ್ರಿ ಎಷ್ಟೊತ್ತಾಗುತ್ತೆ? ಜಾಸ್ತಿ ಹೊತ್ತಾಗುತ್ತೆ ಏನು? ನಿಮ್ಗೆ ಅರ್ಧ ಗಂಟೆ? ನಿಮ್ಗೆ
Only take 15 minutes for me.
ಹಾಗಾದ್ರೆ ನೋಡೋಣ.
It is a matter-
ಮಾತಾಡಲ್ಲ ನೆಕ್ಸ್ಟ್ ವೀಕ್ ಅಲ್ಲಿ ಹಾಕಿರಿ.
Matter of settlement among the joint members.
ಆಗಿಲ್ವಾ?
The proposals.
ನೋ ಚಾನ್ಸ್ ಆಫ್ ಸೆಟಲ್ಮೆಂಟ್?
My clients.
ನಾವು ಪ್ರಪೋಸಲ್ ಕೊಟ್ಟಾಗ ಅವ್ರು ಒಪ್ಲಿಲ್ಲ.
ನಮ್ಮ ಕ್ಲೈಂಟ್ಸ್ ಅವ್ರ ಆಫೀಸ್ಗೆಲ್ಲ ಹೋಗಿದ್ದಾರೆ. They already negotiated.
Did I say no?
ಇನ್ನೊಂದು ವಾರ ಟೈಮ್ ಕೊಡ್ತೀನಿ ನೋಡಿ, ಟ್ರೈ ಮಾಡಿ. ಆಯ್ತು ಹಾಕಿರಿ. ಹಾಗೇನೆ 12/12 ಅಷ್ಟೊಳಗೆ ನೋಡಿ, ಏನಾರು ಮಾಡ್ಕೊಳಂಗಿದ್ರೆ ಮಾಡ್ಕೊಳ್ಳಿ.
12th it is not possible, my lords. My personal inconvenience. 13th or 11th.
13/12.
Final hearing matter 42.
ಫೈನಲ್ ಹಿಯರಿಂಗ್ ಎಲ್ಲ ಆಫ್ಟರ್ ವಿಂಟರ್ ವೆಕೇಶನ್. ಕಮೆಂಟ್ಸ್ ಆಗ್ತಿಲ್ಲ ಯಾವ್ದು ಮಾಡಲ್ಲ ತಗೊಳಲ್ಲ. ಈ ಪಾರ್ಟರ್ ಸುಮಾರು ಇದೆ, ಒಂದು 40-50 ಇದೆ. ಎಲ್ಲ ಆಫ್ಟರ್ ವಿಂಟರ್ ವೆಕೇಶನ್ ಅಂತ ಹಾಕ್ಬಿಡಿ, ಡೇಟ್ ಏನ್ ಬೇಡ. ಯಾವ್ದಾರು ಎಂಟ್ರಿ ಮಾಡರ್ಸ್ ಏನಾರು ಇದ್ರೆ ಮಾತ್ರ ಮೆನ್ಷನ್ ಮಾಡಿ ಯಾವ್ದ್ರಲ್ಲ. ಫೈನಲ್ ಹಿಯರಿಂಗ್ ಅಲ್ಲಿ
ಸೀರಿಯಲ್ ನಂಬರ್
60 ಏನಾಯ್ತು? 60 ಯಾರು ಬೆಳಿಗ್ಗೆ ಮೆನ್ಷನ್ ಮಾಡಿರಲ್ಲ?
FDP ಇತ್ತು.
60 ಯಾರು ಬೆಳಿಗ್ಗೆ ಮೆನ್ಷನ್ ಆಫ್ಟರ್ ವಿಂಟರ್ ವೆಕೇಶನ್ ಅಂತ ಆಗಿದೆ. ಯಾರು ಸಬ್ಮಿಷನ್ ಮಾಡಿ ನಿಮ್ಗೆ ಹೇಳಿದೀವಿ ಅಂದ್ರಲ್ಲ?
They are not informed me, my lord. Since morning I have been waiting for this matter. All
ಲೋಕನಾಥ್
the parties are before this court.
ಯಾರ ಕೌನ್ಸಿಲ್ ಲೋಕನಾಥ್ ಅಂತ ನಾನು ಲಾಯರ್ ಹೆಸರನ್ನು ಕರೆದ್ನಲ್ಲ. ಇವ್ರು ಕೇಳಿದಾಗ ಟೈಮ್ ಕೇಳಿದಾಗ BR ವಿಶ್ವನಾಥ್ ಫಾರ್ R5
I am
ಟೈಮ್
for
ಕೇಳಿದ್ರು.
R7. I am the contesting party, my lord.
ನೀವು R7
I am the contesting party.
ಲೋಕನಾಥ್ ಯಾರು ಮತ್ತೆ? ಅವ್ರಿಗೆ ಲೋಕನಾಥ್ ಅವ್ರಿಗೆ ಹೇಳಿದೀವಿ ಅಂದ್ರು.
ಅವರು ಇದು appellant ಅವರು.
ಹಾ
He is appellant.
ಹಾ
And he has taken time without my knowledge.
R7 ನೀವು?
You may kindly see in the list also it is shown as the impleading applicant, but my application is already allowed. I brought on record already. It may be
16 ನಲ್ಲಿ ಯಾವ್ದು ಇಂಪ್ಲೀಡಿಂಗ್ ಅಪ್ಲಿಕೇಶನ್ ಅಂತ ಇಲ್ವಲ್ಲ?
ಅಲ್ಲ ಇದರಲ್ಲಿ ಲಿಸ್ಟ್ ಅಲ್ಲಿ ತೋರಿಸಿದ್ದಾರೆ.
ಹಾ
ಆಲ್ರೆಡಿ ರೆಕಾರ್ಡ್ ಬಂದಿದ್ದೀನಿ.
ಬಟ್ ಇದಾಗಿದೆ, ಅಮೆಂಡ್ಮೆಂಟ್ ಆಗಿದೆಯಾ?
ಆಗಿದೆ, ಅವ್ರು ಹಾಕಿದ್ದಾರೆ.
ಬಂದ್ಮೇಲೆ
ಹಾಕಿದ್ದಾರೆ.
ಅದೇ ಇಷ್ಟೇ ಇವ್ರು ಹೇಳಿದ್ರು. ಇಂಪ್ಲೀಡಿಂಗ್ R7A ಅಂತ ಇದೆ. R7A ನೀವು ಅಪಿಯರ್ ಆಗ್ತೀರಿ?
ಹೌದು ಸರ್. ಇಂಪ್ಲೀಡಿಂಗ್ ಅಪ್ಲಿಕೇಶನ್ ಅದನ್ನ ಡಿಸ್ಮಿಸ್ ಮಾಡಿದ್ರು. ಎಲ್ಲರ್ಸ್ ಬ್ರಾಟ್ ಆನ್ ರೆಕಾರ್ಡ್.
ಮೇಡಮ್ 60 ಅಲ್ಲಿ the counsel appearing for the respondent number 7 would submit that he is the contesting respondent and without any intimation took time.
Kindly have it on 16th.
This matter on
16th, 17th, 18th, any date.
16-12.
Much
ನೋಡಿ ಆರ್ಡರ್ ಶೀಟ್ ಟೈಪ್ ಆಗಿದ್ರೆ ಕರೆಕ್ಟ್. ಲೇಟರ್ ಅಂತ ಮಾಡಿ. ಲೇಟರ್ ಕೌನ್ಸಿಲ್ ಫಾರ್ R7 ಮೇಡ್ ಸಬ್ಮಿಷನ್ ದಟ್ in his absence date was taken ಅಂತ ಹಾಕಿ 16-12 ಹಾಕಿ ನೋಡೋಣ. ಅವ್ರು ಟ್ರೈ ಮಾಡಿ.
My lordship, serial number 46.
46
Next week, my lordship.
ನೆಕ್ಸ್ಟ್ ವೀಕ್ ಯಾವ್ದು ಇಲ್ಲ ಮೇಡಮ್. ಕಮೆಂಟ್ಸ್ ಆಗ್ತಿಲ್ಲ, ಯಾವ್ದು ಆಗಲ್ಲ.
Property taken possession in the year 85,
ಏನ್
my
ಮಾಡೋಣ?
lordship.
2016 ಅಲ್ಲಿ ಇಂದ ಸುಮ್ನೆ ಇದೀರಿ, ಈಗೇನ್ ಅರ್ಜೆಂಟ್ 24ರಲ್ಲಿ?
I'll try, my lordship. Next week one date, my lordship. Recharge,
18-12 ನೋಡೋಣ, ಕೊಟ್ಟಿರ್ತೀನಿ ಅಷ್ಟೇ.
please,
ಇದು 46 ಒಂದು 18-12 ಹಾಕಿರಿ ನೋಡೋಣ. ಅವಕಾಶ ಇದ್ರೆ ಮಾಡೋಣ.
please.
ಬಾಕಿ ಎಲ್ಲ ಆಫ್ಟರ್ ವಿಂಟರ್ ವೆಕೇಶನ್ ಅಂತ ಹಾಕಿ ಮೇಡಮ್. ಡೈರಿ ಡಿಸ್ಪೋಸಲ್ ಹೇಳೋದೇ ಬಿಟ್ಬಿಟ್ಟಿದೆ. ಹೇಳೋದೇ ಇಲ್ಲ ಯಾವಾಗ, ಸುಮಾರು ದಿವಸ ಆಯ್ತು. ಯಾವಾಗ ಹೇಳಿದ್? ಲಾಸ್ಟ್ ಹೇಳಿರೋದು ಯಾವಾಗ? 2-3 days ಅಲ್ಲ, ಲಾಸ್ಟ್ ವೀಕ್ ಇಂದಲೇ ಹೇಳಿಲ್ಲ. ಲಾಸ್ಟ್ ವೀಕ್ ಇಂದ ನನಗೆ ಗೊತ್ತೇ ಇಲ್ಲ ಏನ್ ಡಿಸ್ಪೋಸಲ್ ಆಗ್ತಿದೆ, ಏನಾಗ್ತಿದೆ. ಒಂದ್ ದಿವಸ ಅದು ದಿನ ಹಂಗೆ ಆಗುತ್ತೆ.
ಮೇಡಮ್ ಕಾಫಿ ಸರ್ವ್ ಮಾಡಿ ನನಗೆ. 46 ಅಲ್ಲ ನೀವು ಕಾಫಿ ಸರ್ವ್ ಮಾಡಿ. ಗೌರ್ಮೆಂಟ್ ಮೇಡಮ್ ಕಾಫಿ ರೆಸ್ಪಾಂಡ್ ಕೊಟ್ಬಿಡ್ತೀವಿ.
Number ಹೇಳಿ, ನಾಳೆ
ಇಲ್ಲಾಂದ್ರೆ ಮತ್ತೆ ಅದೇ ಡೇಟ್ ಗೋಪಾಲ್ ಇಲ್ಲೇ ಕೊಟ್ಟಿಲ್ಲ ಮತ್ತೆ ನಾನು ಡೇಟ್
ಅಲ್ಲಿ ಮೆಮೋ ಬುಕ್ ಇದೆ ಅಲ್ಲಿ ಮೆಮೋ ಬುಕ್ ಪ್ಲೀಸ್ ಅಲ್ಲಿ ನೋಡಿ. ನಿಮಿಷ ಹೇಳಿ, ನಿಮಿಷ. ಇದು 42 ಆಯ್ತಲ್ಲ, ಆಮೇಲೆ 43 ಇಲ್ಲ, 44 ನಿಮ್ಗೆ ಮಾಡಿದ್ರೆ ವೆಕೇಶನ್, 45 ಇಲ್ಲ, 46 ನಿಮ್ಗೆ, 47 ನಿಮ್ಗೆ, 48
ಅದಕ್ಕೆ ನಮ್ಗೆ ಅಲ್ಲ ಕಾಫಿ ಕೊಡಿ ಅಂತ ಬರಿಬೇಡಿ.
ಆಮೇಲೆ 51 52 ಇಲ್ಲ, ಚೆನ್ನಾಗಿದೆ. 53 to 56 ಆಫ್ಟರ್ ವೆಕೇಶನ್. ಆಮೇಲೆ 57 58 ಇಲ್ಲ, 59
ಮೇಡಮ್ ಬರ್ತಾನೆ.
60 ಇಲ್ಲ, 61 to 63 ಇದೆ. 64. 55 ಇಲ್ಲ 67, 66, 67, 68. After vacation.
Ma'am, 50.
17. ಅದೇ
Ma'am,
ಕೊಟ್ಟಿಲ್ಲ
50.
dispensation memo. ಹಾ.
Madam.
70, 13, 12. ನಮಸ್ಕಾರ. 13, 12. ಹೇಳಿ 54.